Welcome, everyone. I'm Jessica Malugin of the Competitive Enterprise Institute, and it falls upon me this privilege of welcoming you this morning to Tech Freedom and CEI's exploration of the constitutional limits for the Federal Trade Commission and the Department of Justice in matters concerning speech, content moderation, and alleged political bias in media. So I'm going to leave the nitty-gritty details of that to the esteemed Tech Freedom senior, but not in an age way, in a wisdom way, competition counsel, Bilal Syed. But very briefly, I just want to take this chance to thank Tech Freedom staff and CEI staff. They have done the Lord's work in putting all this together, so we thank them a bunch, and we thank you once again for joining us. Okay, with that, Bilal.
Okay, thank you, Jess. So as Jess mentioned, I'm Bilal Syed from Tech Freedom. I also will be brief. Look, I see the antitrust agencies and the regulatory agencies, predominantly the FCC, but maybe others, sort of using the language of choice and diversity to support the use of law enforcement in the regulatory state to compel speech. This seems like a bit of a contradiction to those of us who have been practicing in this space for some time, but it's an interesting question. So today, we will spend the full day talking about antitrust and consumer protection laws that the FTC and DOJ either suggest may be relevant to questions of so-called political bias, content moderation, and censorship. And tomorrow we'll spend the day analyzing the FCC's role in this space. For both days, we've got four or five panels, each with experts in this area. If anyone can be called an expert in what might be a very new area, a new use of the antitrust laws and the FCC regulations and laws. So with that, I will turn it over to the first panel, and Casey Maddox, who will lead the discussion. Thank you.
Thank you very much. All right. Well, thank you, and thanks to both Tech Freedom and CEI for making this happen. We're going to kick off with a first panel on the First Amendment and the First Amendment's applicability to these concerns. My name is Casey Maddox. I am Vice President for Legal Strategy at Stand Together, have a history as a First Amendment litigator, and am now presently at Stand Together, working with a lot of the organizations and people in this space. I'm going to go ahead and do the intros for everybody up top. I think as I do that, you should be appropriately impressed with this group of folks. But I'm going to try to do this as quickly as I can so that we can actually save time for the conversation. But immediately to my right, Jonathan E. Mord is a constitutional and administrative attorney who regularly practices before federal courts and agencies. Began his career in the Reagan administration at the FCC. Has repeatedly defeated the FDA in court. He's the author of several critically acclaimed books on law and regulation, including Freedom, Technology, and the First Amendment, which sounds like exactly what we are discussing here. So that seems quite helpful. He's General Counsel for the Alliance for Natural Health USA, Vice President, Legal and Regulatory Strategies International, and the Managing Principal of E. Mord & Associates. To his right is Bob Korn-Revere, who has been a First Amendment litigator for more than 4 decades. In 2023, Bob joined FIRE from the law firm of Davis Wright Tremaine, where he was a partner for 20 years. And before that, he was a partner at Hogan & Hartson, served as legal advisor and later chief counsel to the FCC chairman, James Quello. He's a prominent writer, thinker, acclaimed, has written many books, has been acclaimed by a number of organizations as one of DC's best attorneys, especially in the First Amendment and media context, and is an all-around good dude. Scott Wilkins is senior counsel at the Knight First Amendment Institute at Columbia University, where he focuses on freedom of speech online and government regulation of social media platforms. He's been involved in several high-profile cases at the Institute and engages in both public thought leadership, as well on free speech issues. Before coming to Knight, he spent over a decade in private practice at Jenner & Block, where he focused on copyright infringement in the digital age, litigating against major platforms like YouTube and Google, and successfully shuttered Aereo, as I understand it, after prevailing in the Supreme Court in 2014. Harvard Law graduate, which is fine, I guess, and a Fulbright scholar. He is not, however, a graduate of the University of Virginia. That is Barron. Barron Soka, who is a UVA law grad. I also am a UVA graduate, so we share this. Barron is president of Tech Freedom, named one of Washington, D.C.'s 500 most influential people by Washingtonian magazine, where his work focuses on how law shapes the digital media in the U.S. and Europe, especially free expression, consumer and child protection, and telecommunications. He was previously senior fellow and director of the Center for Internet Freedom at the Progress and Freedom Foundation, and practiced at Latham & Watkins. Has a variety of fancy degrees, but again, both domestic and French, although I'm most impressed by his UVA law degree. So we're going to start going down the line this way and begin with Jonathan, about 5-ish minutes each. And then we will start doing some questions. And I believe we will take questions also. Is that the expectation? If people have them?
Sure.
I just randomly just decided on that. So, so prepare your questions in advance if you have questions to ask. But we will we'll begin and go down the line with opening comments on the intersection of First Amendment and the FTC.
All right, thank you so much. Well, this business of trying to influence content or censor it, suppress it, or coerce it out of existence is very old indeed. And it is really wise to begin with first principles. So we have a Constitution that is supposed to be one of limited powers. And the Constitution was delegated no power over speech and press, but to make that a redundancy that was quite clear, we have the First Amendment. And the First Amendment is intentionally one that is designed to deprive the government of any power over speech and press. This business of influencing content has occurred even as the First Amendment was ratified in 1791 forward, with efforts almost constantly to use government to censor the speech of those with whom government disagrees, particularly those in power. So the Alien Sedition Acts in 1798 introduced this idea that somehow seditious libel was okay under the First Amendment. The idea that government, if criticized, or if government men and women were criticized, that would be an appropriate basis for prosecution. Some 14 Republican editors went to jail as a result of enforcement of those censorship provisions of the Alien Sedition Act. This then led to the Kentucky resolutions, the Virginia resolutions, and the proposition reaffirmed from the first Congress by James Madison that indeed government had no such power and that seditious libel was meant not to exist in America. And yet we have constantly, as I mentioned, all the way up to the present, the Biden administration, for example, being an extraordinary example of government censorship, where coercion and influence and turning big tech into agents of the state all occurred for the purpose of censoring criticism of the COVID vaccine or criticism of Biden himself, his policies, or particularly Hunter Biden. And this sort of abuse of power is seemingly something that politicians are addicted to. And it seems to be an impulse that they can't control. The current situation threatens us. It threatens us with a reuse of this same censorship power for allegedly a beneficial purpose, to prevent bias in the media. Who wouldn't want an unbiased media? The problem is that we can't entrust any single individual to exercise that kind of editorial control. And so in conclusion, there was an example of this that Bob and I were speaking about before we started the panel. And in the Reagan administration, with the Fairness Doctrine, the Syracuse Peace Council decision got it right, held it unconstitutional under the First Amendment, as a more recent example of why it is, even when people like Pat Buchanan and Phyllis Schlafly were saying to Reagan, who was an ally, we have to have the Fairness Doctrine in order to get our views through the media, and we have to see a law enacted to ensure that.
Yeah. Big
you overrule
networks.
it. There you go.
Big networks. Yeah.
So I'll conclude with that, but I must say that this is an old issue, recurring one, and we need to be on our guard perpetually against it.
Thank you.
Well, if you came here looking for some kind of disagreement among members of this panel, I think you may have come to the wrong place. It is a perennial topic, as Jonathan said, that continues to come back. We actually started our careers around the same time in Washington, and I was always envious of Jonathan, particularly because he'd written the book, Freedom, Technology, and the First Amendment. And it's a book I always wished I had written. And then shortly thereafter, I had the opportunity to work with one of my previous professors, Harvey Zuckman, in putting together a communications law treatise for West Publishing Company. And Harvey agreed with my request to have a chapter devoted to new technologies in the First Amendment. Now, when we were writing his book, my chapter in those days, it was really talking about how broadcasting should be treated with the same First Amendment regard as traditional media. Fortunately, because I lagged behind in getting that book done, the internet happened. And so the chapter that I began writing as one about the First Amendment rights of broadcasters and how having a two-tiered level of constitutional protection made no sense, morphed in the writing. So that by the time the book was published in 1999, we had Reno versus ACLU coming out. We had a new recognition by the courts for the first time that a new communications technology should receive full First Amendment protection. And so the theories that we were playing with at the time in the 80s, in the 90s, became real, except for broadcasting, but we'll get to that. And so it is, I think, one lesson from that is that the lessons that we learned during those periods are being unlearned. We have to reinforce the messages that we were trying to provide at the time. But the other one, and I think it's pertinent to this panel, is that the First Amendment can't be avoided just through nomenclature or classification. You can't say, for example, this is a communications law issue, so the First Amendment may apply, and this is a trade issue, and the First Amendment doesn't apply. And this goes back to the beginnings of First Amendment jurisprudence. If you look at Neer versus Minnesota, for example, the landmark case from 1931, where the Supreme Court held that not just that a prior restraint was a violation of the First Amendment, but that the First Amendment protected against more than just prior censorship by the government. The court also said that you can't simply change your description of something and avoid the First Amendment. The court wrote, characterizing the publication as a business and the business as a nuisance does not permit an invasion of the constitutional immunity against restraint. So that was sort of the baseline for First Amendment analysis. And over the years, we developed a rich body of First Amendment law. But again, it doesn't matter what you call a rule. It doesn't matter how you classify an agency, or for that matter, classify a technology. The basic charter, the first principle of the First Amendment applies. One of the consequences of developing a strong body of First Amendment jurisprudence is that it leads to endless attempts to get around it, endless numbers of end runs. And you see that today, given that basic decision in Reno versus ACLU, that the internet receives full First Amendment protection. Now you see efforts around the country trying to avoid the strictures of the First Amendment simply by saying that this state law or this regulation. It doesn't regulate speech, it regulates conduct, it regulates business, it regulates truth in advertising, when in fact it really is ultimately a regulation of speech. We saw this in the litigation over the California Age-Appropriate Design Code Act, which has been enjoined in the wake of NetChoice versus Bonta, now enjoined for the second time. But one of the ways in which that law tried to regulate the internet and avoid First Amendment protections was to disguise itself as a privacy regulation. It wasn't a privacy regulation, it was a regulation of speech, and it included a provision that required covered businesses to enforce their terms of service with the state's oversight. So the state would be determining whether or not they were actually enforcing their content policies in an appropriate way. The court saw through that, and so far we'll see if the Ninth Circuit, the second time it goes up there, agrees. Same true in X Corp versus Bonta. This was a California law requiring online companies, social media companies, to post their terms of service and to provide reports to the government about how they defined and enforced against a list of 6 different topic areas. Now, it didn't say you had to do pretty much anything, but you still had to provide those reports and then would count on public shaming and political pressure to pressure the social media companies to behave. That case, by the way, was argued in the Ninth Circuit the same day as NetChoice versus Bonta, and the same panel decided both cases and made it quite clear that we're dealing with First Amendment restrictions and not, as the state had argued, mere commercial speech. NetChoice versus Yoast is a challenge to the Ohio social media law, and there the state defended that by saying that this isn't a regulation of speech, this is a regulation of contract. And so, what the hell? And the state has the power to regulate contracts between these big social media giants and minors, of course. Isn't that obvious? Well, no, again, the court saw through that and saw that it was a direct regulation of speech. And we also see this in private litigation, one in a case that I'm handling. But there are 2 cases now pending, filed by, at the time, President-elect Trump. One against CBS in Texas, alleging that the way that 60 Minutes edited its interview with Kamala Harris was a violation of the state deceptive practices law. In other words, the law that covers whether or not a used car salesman turns back his odometer also determines how CBS should edit a news program. The same argument essentially is being made in Trump versus Seltzer, which is the lawsuit that then President-elect Trump filed against famed Iowa pollster J.N. Seltzer, a client of Fire's, arguing that the Iowa poll released a few days before the election, which at the time suggested that Kamala Harris was in the lead, turned out not to be true, but that was the finding at the time, that this outlier poll is subject to the Iowa consumer deception law, and that it should be penalized for coming out with the wrong numbers in this poll. Again and again, you see efforts to end-run the First Amendment by using trade regulation, commercial speech regulations, and so on. And all of them are subject to the First Amendment. Now, there was a time when the FTC understood this. There was a time, if you remember the early 2000s, when regulating video games was all the rage, that various states passed laws regulating the access by minors to video games. The FTC did 2 major reports on access by minors to video games, whether or not voluntary ratings were helping, and they were tasked by Congress to look at whether or not the FTC had a role in applying consumer deception law to how the games were rated and whether or not those ratings were accurate. And to its credit, the FTC at the time found that that would be a violation of the First Amendment, because obviously you were trying to apply a trade practices law to what is, in essence, an editorial judgment. Now, that turned out to be at a time when the FTC took legal analysis seriously. It was before the time when heads of agencies were scrambling all over themselves to please the Mad King. And as a consequence, those days may be in our past. Those decisions by the agency at the time, and those regulations ultimately were never adopted, But those regulations were foreshadowed by efforts to turn the movie rating system, the Motion Picture Association rating system, into a yardstick for whether or not minors could get into movies. Every court that looked at the attempt to turn those private ratings into regulations was struck down on First Amendment grounds, and that informed the FTC in its judgment. Today we hear that the FTC is open to proceeding to determine whether or not it has a role in regulating the moderation practices of social media companies, but it comes less than a year after the Supreme Court made it clear in no uncertain terms that those moderation decisions are governed by the First Amendment. They are in effect editorial decisions, even when they're made by algorithm. In most cases, there's some wiggle room there in the Moody analysis, but nonetheless, the solid majority of the Supreme Court made it clear that this is not a regulation of conduct, it is not a regulation of commerce, and it is an area where the FTC has no legitimate role.
Well, I'm glad I get to go last, because now I get to sort of comment on what the other folks have said. No, I would say that there is a lot of broad agreement here. However, I do think there may well be some disagreement that is significant. And let me just, to sort of explain that, let me go back to the net choice decision in the Supreme Court. And I think folks will know that Texas and Florida were the first states to try to regulate social media, and that those two laws were both at issue in the net choice case. And just to simplify it, those two laws, in essence, had two parts. Both laws had kind of two main parts. One, I think we would all agree on here, was patently unconstitutional, which tried to tell the platforms what they could what they could not remove, but in essence, to tell them what they had to publish and what they couldn't publish. And that is, clearly unconstitutional. The majority of the Supreme Court said that. I don't think that was ever in question. However, it's notable, given what you already heard, that in that litigation, Texas and Florida took the position that social media platforms have absolutely no First Amendment rights whatsoever. They made the argument about its conduct, not speech. They made other arguments trying to claim that they're common carriers, like a phone company. There was an array of arguments made, but those were squarely rejected, and the court accepted the argument that there is some close analogy between the Miami Herald newspaper's actions in that case from the mid-'70s, I believe, and what Texas and Florida were trying to do in regulating the social media platforms. So I think on that score, we up here probably all agree. Now, I don't know to what extent we agree with the second parts of those two laws, which have to do with transparency requirements. And I am not saying that those specific requirements are constitutional under the First Amendment, but I do think that requiring transparency can survive First Amendment scrutiny. It is a regulation of speech. There's no question about that. But I think that it can be subject to a significantly lower level of scrutiny, not strict scrutiny. And I think that the platforms certainly take the position that any kind of regulation that touches on the content they publish should be subject to strict scrutiny. And we don't believe that at the Knight Institute. We do think that there are some types of government regulation that should be able to pass First Amendment scrutiny. They are very constrained, and the First Amendment plays a rightfully very powerful role in protecting editorial judgment. But it's important that what is categorized as editorial judgment not be exaggerated beyond what the proper scope should be. And so, even transparency requirements, when they're evaluated under the lower level of scrutiny outlined in the Zauderer case, which, by the way, the Supreme Court in NetChoice, they spent almost no time on this at all, and they didn't really have even the full raft of transparency requirements before them, but several justices did indicate that they thought Zouderer was the appropriate standard in a couple sentences with no analysis, so we'll see what happens there. But I think this is an area where there may be room for further litigation. There certainly will be state laws that try to take advantage of Zouderer and plainly violate it because they're unduly burdensome. But I think we have to see about that. Just to mention a couple of additional areas, I do think there, but again here, labels, as we've heard, are very important. And when I say the word privacy, I don't mean to suggest that privacy is somehow, a privacy regulation is somehow not a regulation of speech. It certainly can be. But I think that there may be room for privacy regulation, and also there may be room for some kind of interoperability requirement that increases the rights of users to port their content between platforms. There are, I think, important ways that the authority of users to have influence over their experience online can be enhanced through regulation without violating the First Amendment. And that's where I think there may be some disagreement here, and we can get into that. But I wanted to add that little bit of excitement here as the third speaker.
Well, thank you all for coming, and thanks for participating. I'll just take a broader perspective here, since we're talking today about both consumer protection and competition law, and try to give you a sense of how I think the First Amendment applies across the board. The case that I would start with is 1945, Associated Press. The Supreme Court dealt with a case where the Associated Press was essentially operating as a cartel. It had member newspapers, and generally one in each particular market. And the question was whether that violated the antitrust laws, whether they were excluding competition from participating in the Associated Press. And ultimately the court allowed an antitrust claim to go forward, saying that the companies involved, media companies, newspapers, were not immune from the antitrust laws. They are engaged in business for profit exactly as are other businessmen who sell food, steel, aluminum, or anything else. The fact that the publisher handles news while others handle food does not afford the publisher a peculiar constitutional sanctuary in which he can, with impunity, violate laws regulating his business practices. Those are the critical words, regulating his business practices. So the question is, when are we talking about regulating business practices, and when are we talking about regulating speech? Now that case clearly would have been different if instead of excluding a newspaper that wanted to enter the Associated Press in the same market, if the Associated Press had given a veto to the local newspaper to exclude a new competitor, not just for economic grounds, which is what the court found was happening in that case, but if that was happening on substantive grounds, because the newspaper that wanted to join the Associated Press was publishing, let's say, Ku Klux Klan content, that clearly would have been a different case. That would not have been a regulation of business practices. That would have been essentially an editorial judgment that would have had the same effect, the exclusion of another newspaper from participating in the Associated Press. So to me, that's the line, and we're going to see that drawn in case after case. 1951, similar case arises at Lorraine Journal, where local newspaper can be sued because it refuses to carry ads from local advertisers who refused to join in a boycott that the local newspaper had organized of the new radio station in town. Same practice. The refusal to carry ads rested not on the nature of the ads, wasn't about the Klan wanting to run ads on the newspaper or radio stations. It was because the newspaper was trying to block a rival, right? So that again was a regulation of a business practice. But many scholars have understood, even Eugene Volokh, who has supported many regulations here and attempts to regulate fairness in social media, recognizes that the rules set forth in that case doesn't authorize restrictions on speakers' editorial judgments about content being available to readers. So that's the baseline for all of this discussion to me. And then just to go through some of how we get here today, a lot of the regulations and interventions that are being proposed today are said to be justified because they would promote speech. Well, the FCC, back in 1960, and I have Bob's excellent paper to thank on this, so I'm riffing a lot from him here, 2009 paper about regulation of digital media. Bob notes that in 1960, the FCC said that the First Amendment forbids governmental interference asserted in aid of speech, as well as governmental action repressive of it. The protection against abridgment of speech and of the press flatly forbids governmental interference, benign or otherwise. So even the FCC, which was involved in trying to regulate speech in the public interest, even the FCC understood this. 1974, we have the Miami Herald case you heard about, where the Supreme Court said that you couldn't compel a newspaper to carry content that it didn't want to carry. The Supreme Court in that following decade decided a number of cases, a Virginia Pharmacy Board, Central Hudson, recognizing that commercial speech gets protection. And that causes the Federal Trade Commission to have to issue two policy statements that you'll be hearing about again and again today. First of them governing its unfairness authority in 1980, and then a second one in 1983 governing its deception authority. And what the FTC, had to grapple with in those cases was, where is the line between effectively business practices and speech? And the court informed the FTC's approach to those things. And mainly what we'll see is that the FTC stuck in the following years in applying its consumer protection authority to holding companies to their promises. We'll talk about that more on the next panel. But even there, they were very careful not to get involved in editorial judgments and speech, to stay on the side of business practices. So for example, most analogous to today, in 2004, the Federal Trade Commission was asked to bring a deception claim against Fox News for allegedly deceiving consumers for using the slogan fair and balanced, because if Fox News says anything, it's not fair and balanced. And so even though that in some ways would seem like a fairly easy case, of course the Federal Trade Commission refused to get involved. Of course the Republican chairman at the time said that doing so would, quote, require evaluating the content of the news at issue, which was, as Tim Urias said, a task that the First Amendment leaves to the American people and not a government agency. So the FTC was very careful not to get involved in speech matters and to stick to policing purely business practices. And that's why in the example that I think Bob mentioned, in that time period, the FTC was being asked not merely to study violent video game content, not merely to encourage the industry to develop a rating system, but to enforce that rating system. So the idea was that the FTC would be the cop, so that if a company certified that its video game was appropriate for kids, let's say under 13, but someone decided that actually it wasn't, then it would be the FTC that would enforce those judgments. And the FTC refused to get involved in that role. They very carefully stayed on the side of merely studying the issue and commenting upon it. And so that's why in 2020, when Chairman Joe Simons was pressured to get involved in the debates we're having today for the first time, he refused to do so. He told Republican lawmakers that the FTC's authority focuses on commercial speech and not on political content curation. And so in the Net Choice case, when the Supreme Court said that the First Amendment offers protection to private entities that compile and curate other speech, because the editorial function itself is an aspect of speech, it essentially said that the same rules would apply to social media, that those are editorial judgments, they are themselves a kind of speech, and they're not business practices that are subject to regulation. So I would wrap up here by just saying that the general rule here is media companies are not immune from the enforcement of the antitrust laws or consumer protection laws, or for that matter, new laws about transparency. You can imagine laws that could be applied to those companies, especially if they are laws of general applicability and are not applied to specific speakers and they're content neutral and viewpoint neutral and so on. But the key is that the agency or the government has to be regulating business practices and not speech itself.
Well, thank you. So I want to make sure that we have as much of a debate as we possibly can, because we've got a bunch of free speech advocates up here. Let's pull on this thread that I think Scott flagged, and that Barron also noted there. the possibility of basically regulation of some kind or action by government of some kind that would push for some form of transparency, some form of disclosures by platforms. Does anyone want to take the opposite side on that and sort of make the case for why that might be itself constitutionally problematic?
Sure. So compelled speech is just as big a violation of editorial discretion oftentimes as censorship directly. And so the point is that the First Amendment is designed to disarm government of power, in this instance, over the press. Now, that doesn't mean that to the extent that the press function, of editorial function, is not implicated, does the government lack power. But it does mean that if the editorial function is implicated, it does lack power under the First Amendment. So that if either the intended purpose of the statute or regulation is to alter the editorial content, or its effect is to alter editorial content decisions of that media enterprise, it necessarily implicates the editorial function and then raises the First Amendment issue. So while it's perhaps an academic exercise to invent some sort of disclosure that might not implicate editorial function, I think in most instances there is an underlying motivation to influence content by imposing disclosure requirements. That may not always be the case, but I think it is generally the case, and I think that's fair to say.
I would agree with that, but to take on the point that Scott raised about transparency, I would say that it was an understatement to suggest that this will be an area for potential litigation. This will be where quite a bit of litigation is going to be focused, partly because the Supreme Court has yet to draw that line about how much disclosure can be required. Compelled speech as a general proposition is anathema under the First Amendment. Just as censorship is prohibited by the First Amendment, so is compelling speech, and perhaps on more compelling grounds than just simple censorship, because forcing someone to speak when they would prefer to remain silent is very basic to the constitutional order, established in cases like Barnett, when it involved school children being forced to salute the flag and recite the Pledge of Allegiance. But it extends beyond just that political realm. It also applies to the recitation of facts, and the Supreme Court was quite clear on that in the National Federation for the Blind case. Even if a disclosure may determine whether or not you're willing to give to a charity, it's beyond the state's authority to compel that disclosure, as the court held in that case. Now, there are certain limited exceptions in the business context, and you've heard mention of the Zauderer case, Zauderer versus Ohio Consumer Commission. I forget the exact title for the state agency, but nonetheless, it was a regulation of lawyer advertising. Now, there were two parts of that decision. One that struck down a restriction on lawyers advertising and using an image of an IUD and taking cases involving intrauterine devices. And there was a second part where the lawyer's advertisement said that you will pay no fee and didn't disclose that a contingency fee meant that the lawyer would collect part of whatever the settlement was, and also the person might be required to pay expenses that were involved in the litigation. And so the court held on a very narrow basis that disclosures can be required if necessary to prevent the ad from being misleading or deceptive. Now we're seeing modern applications of Zauderer, and we've seen sort of a mission creep over the years with the Zauderer standard. It used to be confined just to preventing consumer deception. We have had decisions by later courts, most notably the D.C. Circuit, the Ninth Circuit, the Sixth Circuit, have held that it doesn't have to be limited to a government interest in consumer deception. It can be a broader interest. I guess the Second Circuit has also said that. But the Supreme Court has not said that you can use some interest other than correcting consumer deception. And so that remains to be decided. The Supreme Court did make a nod towards Zauderer in the Moody case, but I'd say stopped well short of endorsing Zauderer as the standard, as the lower courts had done for requiring certain kinds of disclosures. That was the issue, by the way, in Ex Corp versus Bonta, where disclosure of terms of service and how they're enforced was being defended by the state as purely an exercise of transparency under Zauderer. And there the Ninth Circuit said, no, it goes further than that. This is a requirement that they disclose how they enforce their editorial and moderation standards, and that violates the First Amendment. So the questions that we will face as more and more states and potentially the federal government try and regulate in the name of enforcing transparency, we will see ultimately, with any luck, a Supreme Court decision limiting the extent to which Zauderer can be stretched to cover whatever kind of disclosure policymakers seem to think they'd like to see.
And is this, so on the difference in Zauderer, right, you actually have a sort of what people would normally think of as a consumer. You've got someone who is exchanging
Buying services.
I'm paying for services here. Very often in the social media context, especially in the tech context generally, you don't have that, right?
That's right.
How much does that matter to the application of the law here? And do new things like X premium and issues like that, like how much does that potentially change the analysis such that disclosures in that context might be different?
Well, if paying X for premium service involves a commercial transaction, it might make a difference. But the reason why disclosures in that commercial setting are treated differently is because false commercial speech is not protected by the First Amendment. It's outside the First Amendment's protection. And I think there's a strong argument to be made that you can only require a disclosure if necessary to prevent commercial speech from being false, right? It is the least restrictive means of allowing the speech to happen without censoring it or without prosecuting someone for it. But if you extend the Zauderer principle beyond that context, then you open a real can of worms under the First Amendment, because compelled speech is treated very much like viewpoint discrimination in terms of being almost a per se prohibition under the First Amendment. I can't think of an example of where viewpoint discrimination has ever been upheld. And if you see the cases, and particularly going back to Barnett, talking about compelled speech, you find a lot of language from the Supreme Court and from lower courts treating compelled speech, compelled disclosures, almost on par with that kind of constitutional prohibition. But it does make sense to have a very limited exception where you're talking about a commercial transaction, because there, the disclosure is the least restrictive way of actually allowing the speech to go forward without falling into the unprotected area.
If I could address, so, you know, this idea that there has to be some kind of, you know, monetary exchange, a subscription of some kind, I think that's too narrow here, because when you sign up for an account on any one of these social media platforms, you are agreeing to terms of service that provide that you will make certain content available. The platform can use content that you provide in various ways, that the platform can use data in various ways to generate revenue. And so the notion that that's not a commercial transaction, I don't think quite holds. But there is that, so you know, I think that, you know, Zauderer has several preconditions in order for the lower level of scrutiny even to apply. And I would argue that the notion of a commercial transaction is satisfied by a platform that requires you to agree to terms of service. And by the way, those terms of service always pretty much incorporate the community guidelines, which is how the platforms kind of specify the types of content that they generally will not accept their policies. Now, you know, even if Zauderer applies to that, there is then a question about just how far do those requirements go? How burdensome are they? And I think that there are many cases in which you would see an undue burden. So let's go back for a minute to the Florida and Texas laws at issue in net choice. And although the Supreme Court did not grant cert on the majority of transparency requirements in both of those laws, the court did grant cert on one provision in each law, which they call the individual, I'm trying to remember their term for it, but the individual explanation provision in essence, where each law said when platform you take an adverse action against user content, you have to tell the user what you did. Now, the Florida law went much further than that, and it required a detailed explanation and used a lot of language to specify just how florid the language had to be explaining the reasons for the removal, and it imposed very significant financial penalties. And so, obviously the burden there is very high. The Texas law was much more vague. I think it was much more akin to the European Union's requirement in the Digital Services Act of, it didn't specify how much detail. It just said explain. There was no monetary penalty. So I think that would be much closer to an acceptable disclosure requirement. That just gives an example of what I mean when I talk about what an undue burden might be in a disclosure requirement. I think another important thing to focus on here, and this is where I think the New York law that you've been challenging comes in. You can't tell a platform what policies it has to develop. That is not transparency. And I think the New York law, the hate speech law, goes way too far, because it doesn't just say, publish what your policy is, period. I'm sure we can get into a discussion about whether that goes too far, but it doesn't just say that. It really is telling the platforms what the policy should be, in essence. And that is clearly a violation of the right to editorial judgment. So these are, I guess, the can of worms that was mentioned is it is real here, because as I think what I've just said illustrates, these are careful. This would require, the application of Zouderer would require kind of very careful judgments, kind of provision by provision. It is not as straightforward as when you have viewpoint discrimination, and that clearly qualifies for strict scrutiny. So this can of worms that has been opened and is, as you say, already being propagated through the courts is going to be very interesting, and it will really be up to the Supreme Court to draw these lines. And I think that those few footnotes or mentions in the net choice case of the Zouderer decision indicate that the court is kind of open to considering that in a future case, if the right case presents it. What I mean there is just open to considering it. Whether it rejects it and how far it accepts it is very much open to debate.
Yeah, but the problem with Zouderer is that it is essentially a rational basis test. If it's not crazy, then it's permitted, as long as it's not too burdensome. And then you're just into constitutional balancing. Let's look at how much of a burden it is case by case, which is basically an open invitation for legislators to push this as far as they possibly can. The Zouderer test is no test at all.
And for those that are playing along at home, right, we're talking about the 3 levels of strict scrutiny, or rather constitutional scrutiny, that applies. Strict scrutiny being the highest, the government essentially almost always loses. At the other end, you have rational basis, the government almost always wins, no test at all. And in between, you have intermediate scrutiny. So that's a distinction you're going to hear talked about a lot here today. But to abstract a little bit from this conversation, we just went down the rabbit hole about transparency, which is just one part of what is at issue today. And I think, not to my mind, it's not the most important part. It's a part of what's at issue. But in the net choice cases, the Texas and Florida laws, we're only secondarily trying to require both disclosure about content moderation practices in general and then individualized explanations in particular cases. They were moreover trying to regulate the fairness and consistency and neutrality of editorial judgments. And that's the real ballgame here. The transparency stuff is, if you will, only a consolation prize if the government loses on those other grounds. So I'd like to just abstract to the higher level of analysis here and return to my earlier point about, in principle, the government can regulate business practices if it does so in a neutral fashion, but not always, right? And not even generally, right? I just mean to say, in principle, it's possible. The antitrust laws do apply to media companies, and so do the consumer protection laws. They're not categorically immune. But you have to ask questions about, for example, chilling effects. So again, I'm riffing from Bob's excellent 2009 paper, but he notes a case that seems to me to be pretty analogous, where in 1978, Community Service Broadcasting of Mid-America versus the FCC, the DC Circuit struck down a statutory requirement that non-commercial broadcasters maintain an audio recording for 60 days of any program that discussed an issue of public importance. So this is sort of a rule related to the fairness doctrine, which is about issues of public enforcement, public importance. And Judge Skelly Wright, not the biggest fan of Judge Skelly Wright, but in this particular case, I think he got things right, where he said that chilling effects can exist when regulatory requirements, quote, neither create any new content restriction nor establish any new mechanism for the enforcement of existing standards. Because to the extent that the measure is adopted for the purpose of exerting greater control over content, the court's ultimate concern is not so much what government officials will actually do, but with how reasonable broadcasters will perceive regulation and with the likelihood that they will censor themselves to avoid official pressure and regulation. That is, of course, precisely what the court was getting at in NetChoice, that the purpose of the transparency requirements in the Texas and Florida laws was to change the editorial practices of tech companies, right? To encourage them to change their practices in a way that would better comport with the views of content moderation that were held by the states of Texas and Florida. And I think the question we're going to explore today is that what's happening? Is that the goal of the Federal Trade Commission in its current inquiry into content moderation practices? Or are they trying just to bring some due process to content moderation? And to be charitable but fair, I will just note at the outset that if you look at the concerns that the request for public information has raised, and at the things that the commissioners at the FTC and the FCC have said, they are describing practices, many of which seem pretty reasonable on their face. And in fact, if you look at the Digital Services Act, there's a lot of overlap between what they are talking about here in the Federal Trade Commission, the FCC, and the Department of Justice, even what Texas and Florida have talked about, and what the Digital Services Act requires in providing some kind of due process in content moderation. I'm speaking particularly of Article 14.4, if you want to play at home and look at what that says. So those are not crazy ideas, but that doesn't make them constitutional. And the problem is that when you try to import those ideas to the United States and you try to have the government enforce them, and particularly when you try to have agencies do it that have, let's say, general consumer protection and competition authority and don't have clear statutory requirements, it becomes very difficult to see how you actually get there. And we'll discuss this on these following panels in detail, but I will just say in general that it's not so clear even there that the agency seems on its face to be regulating business practices, that they can do so without having the kinds of chilling effects that I just talked about. Because in fact, the effect, if not the purpose, of what they're doing may be to change the editorial judgments of tech companies, as has already been happening. Tech companies are already changing how they moderate content because they're being pressured to do so by this administration. And that's likely to increase as these agencies start taking more action on content moderation, whether it's through consumer protection or the antitrust laws.
Well, the effect is the point, right? I mean, and the case that you mentioned, Community Service Broadcasters of Mid-America versus the FCC, is really a good explication of that. that taken from the 1970s and FCC law. But then the FCC is an agency that was essentially designed for job owning, and something we'll talk about a lot more tomorrow.
But you should define the term, right? Job owning, as Derek Bamauer
job owning
tells us.
is the act of government officials essentially threatening or insinuating there will be bad consequences or regulation if someone doesn't change their editorial policies or their speech in the way that they prefer. The Supreme Court has repeatedly held this to be a violation of the First Amendment, including just last term in NRA versus Volo, where New York State authorities were leaning on insurance companies not to do business with the National Rifle Association because they didn't like the NRA's political message. The court unanimously reaffirmed the principle that job owning is a violation of the First Amendment, first articulated in Bantam Books versus Sullivan in 1963. And this is something that is endemic at the FCC, given the degree of control that the Commission has over broadcast licensees, and that was the principle that the DC Circuit was talking about en banc in the community broadcasters case. In terms of the FTC and applying these principles, I'm not sure that European law is something that we should see as a model for how we regulate tech companies. Maybe we can take a hint from the fact that there's no huge tech sector in Europe, and there's a reason for that. The Digital Services Act is something that I think, as Barron mentioned, would not fare well in American courts. The Age-Appropriate Design Code Act in California was expressly patterned on the UK's Child's Act, and it so far has been enjoined. When it comes to the regulation of moderation practices, we see the failed attempts of Florida and Texas, at least failed so far. The court didn't reach a final decision, and it's because of that distinction between regulating business practices and regulating editorial practices that was unclear to the court, because those laws were very broadly written. They were, as according to the record from the lower courts, could have been applied to services like Uber and Etsy and other online services where it wasn't clear that an editorial decision was being made. And so the court held that it needed to go back for further development of the factual record to determine where that line is between editorial practices and business practices. But it went out of its way, and there's an interesting backstory to that, but went out of its way to say that the Fifth Circuit had completely blown the constitutional analysis, because when it is making some sort of editorial judgment, that is protected by the First Amendment.
And if I could, so on the line drawing point there, the court, I think, this was what's called a facial challenge. The two laws were challenged by NetChoice in very broad terms, and as Bob just said, the court very, very expressly explained that because it was a facial challenge, it could apply to services like Uber, and it just wasn't clear, which services were covered and the extent to which there was editorial judgment. But the line drawing was even finer than that, which is that the court suggested that Facebook, you had to look at the specific elements of the Facebook service, like the feed would be one of those. You have to look at a sort of element by element to determine if editorial judgment is being exercised. And I think that's very important, which is that, yes, the protection of editorial judgment is extremely important. It has a significant history, and we have, there are very good reasons to protect editorial judgment. But figuring out what is an exercise of editorial judgment is not always very easy, because this analogy from the Miami Herald newspaper, this case from 1974, to social media platforms is not straightforward. Although the platforms argued in NetChoice that it was basically one-to-one, I think the court was was reticent to say that. The court pointed to certain things that are editorial judgment, like deciding what you will and won't publish. That clearly is. And the laws were clearly up against that. And as Barron said a moment ago, the FCC is not being coy. The request for comment expressly has sentence after sentence that are based on content, clearly calling for a violation of editorial judgment and inviting that. And in that sense there, I think the chilling effect is extraordinary precisely because it's so open and brazen in what the FCC is suggesting it has the power to do depending on the comments that it receives.
You know, there's another aspect of this that's very important, which is that in the advent of Loper-Bright, the overruling of Chevron, we now have, in this instance, not only a First Amendment violation, but there's no statutory foundation in the Federal Trade Commission Act in Section 5, 12, or 45 for the Federal Trade Commission to engage in this kind of an inquiry in the first instance. So there's really an absence of both statutory authority, so it's ultra vires. It is also implicitly carrying on Chevron, because it's saying that we don't need any specific statutory grant of authority. We just have this inherent ability to progress beyond the statute to reach these things. And then there is the obvious First Amendment problem, which arises when they overtly state in their solicitation of comment that their intention is to look at content. So I mean, it seems to be the hand grenade has the pin pulled. They're just holding it. And so the inevitable course should be, I think, to either have them come to that realization on their own, they lack such power, which would be a delightful turn, or if they bend to political pressure, as would be expected, to produce something that would be immediately challengeable on multiple grounds.
Yeah, and Chairman Ferguson has not been coy about describing the purpose behind this proceeding. I heard an interview where he was saying that what he wanted to make sure was that there were no more January 6ths. Now, by that, he didn't mean we shouldn't have more examples of hooligans storming the Capitol. What he was talking about is not having social media companies canceling the accounts of politicians who supported the January 6th rioters. And so, you know, the purpose is really laid out there. There's really no question about what the FTC is hoping to do. But let me draw a distinction between what the FTC is doing here and the state laws that were at issue in Texas and Florida in the Moody case. And that is, here you've got a focused proceeding specifically on moderation. And so there is no question but that this proceeding is targeting core First Amendment protected activity, and the Supreme Court made it clear that that's what we're talking about when it comes to moderation. With the state laws, it was much more in question because, you know, you had these broad, sloppy laws written that could apply to pretty much any internet business. And it's one of those rare instances in which governments have benefited from being imprecise and being sloppy about what their coverage definition was. Now let's be clear, in Florida and Texas, they weren't interested in regulating Uber drivers, and they weren't interested in regulating Etsy. They were regulating for one purpose, and that was the editorial judgments that were being made by online social media companies. But because they expressed this law in such broad terms, it potentially could cover these things that the state legislatures had no interest in. And so when the Supreme Court looked at it, it tried to decide, okay, which parts of these laws do affect First Amendment interests and which don't, and now it's required further litigation in the lower courts to try and sort that out with these very broad, imprecise laws. Again, it's one of those few examples of where that kind of imprecision really doesn't often work in government's benefit. And this is what distinguishes it from older internet regulations, in that it used to be when Congress or state legislatures were passing laws to restrict content online, they were focused on a particular kind of speech. There can't be indecent speech online in the Reno case, or speech that is harmful to minors under the Child Online Protection Act. And so they were focused. They were like rifle shot regulations directed specifically at speech. But now we have regulations designed and focused on the internet in general, which can be a whole lot of different things, and it can include, in some instances, business practices that are regulable. But in most instances, what the regulators are looking at is finding a way in so that they can regulate speech.
Well, I think it's so interesting to see how these state laws have progressed, because with the Texas and Florida laws, of course, although the laws don't say this on their face, unlike the invitation to comment in the FCC proceeding, the governors of both states were very clear of the purpose of the two statutes, and they pointed to the deplatforming of President Trump. Specifically, they also pointed to the Hunter Biden laptop. They used words like the oligarchs of Silicon Valley. They talked about this sort of this kind of very biased thought process happening in Silicon Valley, and they wanted to counter that. So in that sense, you could see what they were really getting at, and I think Justice Kagan did point that out at one point in the NetChoice case. But they carefully drafted the laws trying to make it look like they weren't sort of viewpoint based in that way. Here in the FCC proceeding, the FTC proceeding, it's quite clear.
The chair is saying precisely the same thing. I mean, if you watch the workshop that the Antitrust Division held 2 weeks ago with the FTC, the FCC, and the Antitrust Division heads, it was precisely the same complaints about the Hunter Biden laptop story being blocked, about editorial judgments, et cetera, et cetera. So just to explain what I meant earlier, there is to me a chasm between what the agencies are saying when they talk about the need for regulation and what the RFI, the request for information that's been put out by the FTC right now says, because the agency heads are talking about editorial judgments and changing them. The staff at the FTC, presumably, that drafted this request for information, were thoughtful lawyers, as is generally the case for the FTC, and put some effort into thinking about what might theoretically be grounds for the agency to get involved in regulating business practices. And they asked about things that on their face are not unreasonable. I think most people, this is why I bring up the analogy of the Digital Services Act, not that it's a model, but it essentially reflects what many people, if not most people, would agree should be the general operating principles for how content moderation works. I mean, those are things that if you held yourself out as offering X, Y, and Z practices and then failed to do so, it's not unreasonable to think that there might be a deception claim that could be brought, because that's what the FTC generally does. And when you actually start to think about that, and we'll talk about this on the next panel, I think that breaks down pretty quickly, because we're not talking about easily objectively verifiable things. It's not, if you look at the RFI, it's not like you said you would offer an appeals process and you didn't, right? That would be simple, objectively verifiable. It's a lot more like the PragerU case. So PragerU sued YouTube under the Lanham Act, which is essentially analogous to the FTC Act, for allegedly that YouTube had deceived consumers by making statements about being balanced, and just like the Fox News case, much analogous to that, that YouTube had promised to create an open space for users to have a public dialogue and so on, but then allegedly failed to do so. And what the Ninth Circuit said was those statements you're pointing to are just not objectively verifiable. It's not like enforcing the label, the nutritional label on a product that says you have X number of grams of magnesium and Y grams of calcium. Those are objectively verifiable. If you fail to deliver upon those, that's deception. The FTC didn't get involved in the Fox News case because it would have required getting into subjective judgments, not business practices. And I think that in general, that's the same problem the agency is going to run into here.
So we began. I know we're running up on time here, so I'm going to try to ask a question and let people take it down the line here. So the title of the panel: How the First Amendment Limits Competition and Consumer Protection Law. I think we've heard several ways in which it should limit consumer protection or competition and consumer protection law. We've also heard that there are significant chilling effects that are happening sort of despite that. And I think part of that is because the FTC hasn't done anything yet. The FTC has proposed to do some things. It has raised the prospect of doing things, but it hasn't actually gone and done something that makes it easy to be able to go to court and test how does the First Amendment apply to what the FTC has done. I'm curious for thoughts on sort of that dynamic, whether the First Amendment, in the context of these fights that we're going to be fighting in the next few years, most likely, whether the First Amendment is an effective obstacle if agencies generally, but the FTC specifically, or state regulators, can sort of raise questions, suggest things, sort of Murphy-like, being the change they want to see in the world, and sort of putting thoughts out there and encouraging companies or pressuring companies subtly to alter their behavior. Is the First Amendment an effective answer? Will it be an effective answer? And if it's not, what else can we do to try to protect First Amendment values?
So yes, it is. It's really our salvation if you believe in freedom. But on this chilling effect question, you have a conflict in the circuits as to whether or not the doctrine that applies in the chilling effects is applicable in the commercial speech context. What we have here is actually a hybrid. We're looking at something that may at least superficially be called commercial regulation, but really is actually classic content-based regulation of political speech. And so they're attempting to shoehorn this into a commercial context. It will then again raise this issue of a chilling effect. Years ago, and Bob and I are very familiar with this, Newton Minow mentioned how regulatees would respond defensively by eliminating areas of objection for the commission if there was regulation by, he called it, raised eyebrow. Yeah. Simply the notion, the issuance of this RFI, is in and of itself sufficient to cause a chilling effect on the speech of those who are affected by it. And so, yes, it may be that is viewed by the administration as sufficient, depending on the changes that take place by internet service providers and so forth in response to it. But nonetheless, there is this fundamental question. Many, many years ago, I wrote a piece for the Cato Institute called Commercial Speech, Contrived Distinctions, the Doctrine of Commercial Speech in First Amendment Jurisprudence. And I believe that most of these distinctions, if we were to look at it from a framer's standpoint, now purportedly a majority of the Supreme Court is originalist, you would have to say that commercial speech doctrine in and of itself is illegitimate. And that everything should be subject to strict scrutiny effectively in its assessment. But it gets back to what is speech, right, ultimately. And here, the very purpose of the RFI, the very purpose of the FCC's activity, the very purpose of the Department of Justice is all responsive to these political pressures, and it is specifically designed to attack the content that is deemed objectionable. So I think that the First Amendment will be a major cudgel that will be brought to bear against those who will make this, if they wish to, a real formidable problem in the United States.
But that's the problem, if they wish to, right? That whether the First Amendment will matter here assumes that the companies that are being jawboned will actually stand up for themselves and will fight in court.
That's right. I mean, the First Amendment is, I think, the answer, but not in every case, because first, you have to have a case. You have to have someone who's willing to stand up, and where you have compliance in advance, as you have with certain of the law firms that have been trying to avoid executive orders, or if you have people who own networks who change their editorial policies or settle lawsuits they easily could have won, then in those cases, it's not going to be an effective answer. But I believe that there will be enough people and enough businesses that do stand up in key cases and forge the precedent that will be the bulwark against this kind of abuse.
Yeah, it kind of depends, who the administration goes after. If they go after Wikipedia, Wikipedia might stand up for itself. If they go after some of the bigger tech companies, we've already seen that they seem unwilling to fight back against the administration. So that may be your answer, and we may not get clarity on this. I mean, the Federal Trade Commission has been very successful in building what it's called a common law of consent decrees in other areas of the law, like privacy and data security, for years, even, decade or more, with zero litigation. And if companies won't fight back in those circumstances, what would make us think that they'll fight back here, where the stakes are so high? And just to wrap all this up, I want to note that one of the central problems here is there are some big doctrinal distinctions here. Jonathan called them contrived, and maybe not unfairly so, such as between commercial speech and uncommercial speech, that are really not clear. And in particular, I would just note that the Supreme Court left a lot of questions unanswered in 2003 in its Nike versus Kasky case, where you have a business like Nike that makes what it says is non-commercial speech statements and representations about its business practices, specifically about whether it uses sweatshop labor. And that's kind of analogous to what we have here. So Fox News, when it described itself as fair and balanced, it was marketing its services. Is that commercial speech about non-commercial speech, or is it non-commercial speech about non-commercial speech? I mean, those are the kinds of questions that have to be answered here. And if you think that what we're talking about here, when, for example, the agency in the RFI today says that it's trying to hold companies to their promises, if those representations are considered commercial speech, that's the only way that the agency is going to be able to regulate this, to justify getting involved as regulating business practices. But if the courts recognize that what's really at issue here, whether you call the statements about your content moderation practices, whether you call those non-commercial speech or commercial speech, but what's really at stake is the underlying non-commercial speech, then you recognize that these distinctions don't matter, and that what's really at stake is trying to reshape content moderation. And there are lots of cases in the FCC context where the FCC over decades has tried to effectively reshape non-commercial speech through regulations that might seem like they're regulations of business practices.
Well, and by the way, when you say that the government is claiming all it's trying to do is hold businesses to their promises, that was the precise argument that California made in the Age Appropriate Design Code Act, saying it could require companies to enforce their community standards, saying that was something they had promised. But again, it's not like the companies are marketing their community standards as a product. It's just not the same thing.
So I have to admit to having engaged in a deceptive practice. I told you that we would have time for questions. It was a complete lie. We do not have time for questions. We've reached the end. But please do join me in thanking the panel.
So we'll take a short coffee break and then get into the details about the consumer protection law, its application.
Okay, thank you. Thank you for joining. This is the second panel of the day, Consumer Protection, Analyzing Potential Claims. Let me first introduce the panel, introduce myself again. I'm Bilal Sayed. I'm with Tech Freedom. Moving from closest to me, the furthest from me, as participants, as panelists, Ian Barlow. Ian is presently counsel at Wiley Ryan, and prior to that, most recently, he was the Deputy Director of the FTC's Office of Policy Planning, and he has held other career positions, senior leadership positions in the FTC's Bureau of Consumer Protection. Next to Ian is Neil Gilson. Neil is presently head of AI policy at the Abundance Institute. He is a former chief technologist at the FTC and attorney advisor to FTC, former FTC commissioner and at one point acting chair, Maureen Olhausen. Next to Neil is Laura Kim. Laura is a partner at Covington Burling. She is former attorney advisor to former commissioner and acting chair of FTC, Bill Kovacic, and she also held various senior leadership positions in the Bureau of Consumer Protection. Drill down a little bit on possible claims the FTC may be thinking about. It may be maybe the request for public comment gives some of that away, but maybe there's some unstated messages in that request for public comment. The FTC enforces Section 5 of the Federal Trade Commission Act, which prohibits unfair methods of competition and unfair acts or deceptive practices in or affecting commerce. We will focus on the unfair acts, deceptive acts, and practices prong the statute this morning. Ian will give us a quick framework for thinking about unfairness claims. Laura will give us a quick summary of the framework for thinking about deception claims. Neil and Baron will sort of comment on those quickly, but then we're going to move quickly into discussing what we think the RFQ is getting at, both sort of explicitly in its questions and then perhaps implicitly in some of the language around the request for comment or the statements that commissioners and the chair have made. I had wanted to touch, or I just wanted to mention, of course, the FTC can only prohibit conduct that is in or affecting commerce. There's not a lot of case law on what that means with respect to FTC actions, and so to some degree we're going to hold that discussion in abeyance, but I will note that the panel earlier suggested that there might be a real question about whether enforcement actions with respect to speech, real question about whether that would be in or affecting commerce. So it is something to keep in mind. It's just sort of a question of how much law is out there with respect to the FTC's scope of enforcement authority. So with that, Ian, can you give us a short summary of what matters when thinking about an unfairness claim?
Sure. Thanks, Bilal. And so, look, there are three elements under 15 U.S.C. 45N that outline the cause of action for unfairness under the FTC Act. These are drawn on the deception policy, the unfairness policy statement from 1980, but then Congress later codified them in a statute. So this is the law. It's not just a policy statement that the Commission could theoretically vote to change. So the first element is substantial injury to consumers. The two key terms there are substantial injury and consumers. On substantial injury, I think in this inquiry, there's a real question about whether the harm, if any harm did occur, whether it's substantial to, run-of-the-mill users who may have been, if they were deplatformed or shadow banned or had their content moderated, whether that amounts to substantial injury under the FTC Act. Traditionally, unfairness cases alleging substantial injury revolve around monetary loss. You see this in unauthorized billing cases, and where there's an economic harm. As it gets more speculative on the harm, the statute does say likely to cause substantial injury or cause. And so you see in FTC data security cases where the breach is likely to cause some kind of economic harm to consumers if they have their identity stolen, if there's financial impact of that. And then I think probably the cases on unfairness with the least amount of injury to consumers are the FTC's recent data broker cases for allegations that it was unfair to transfer or sell consumers' sensitive data without their knowledge or permission. And in one of those litigated cases, Kochava, the FTC initially lost the motion to dismiss on this. They were granted leave to amend, and they later prevailed on this question of whether the injury was substantial. And the difference in the two opinions between losing and winning was very slight. And but overall, the injury there was reputational, potential stigma, discrimination, and outcomes from having your data disclosed. I think in this inquiry, there are significant questions about whether injury would be substantial. The other thing about substantial injury is there's a line of cases that say if it's a very small harm, but to a lot of people, the FTC can still bring the case because that's substantial. The law shouldn't incentivize $1 harm to 100 million customers, right? That shouldn't be a business model. But here, you would have to look at it, the percentage of, say, a platform's 250 million users who suffer harm compared to potentially the countervailing benefits, which is a later element, for the other, 249.5 million users or whatever. And so the percentage of consumers harmed could be really, really an incredibly small number. Then the next term in this first element is consumers. And to the extent that the FTC is concerned about harm to small businesses that may have lost a venue to market their services on platforms, I think there's a substantial litigation risk here about whether consumers under 5N include businesses seeking to commercialize their use of these platforms. The second element is the FTC would have to establish that the harm is not reasonably avoidable by consumers themselves. And here there's a long line of cases that say where consumers have free and informed choice, the injury is reasonably avoidable. And so in a market where consumers have many different platforms to choose from, there are good questions about whether this potential harm, could be reasonably avoidable. And then the third element that the FTC would have to prove is that any harm to consumers that was not reasonably avoidable is also not outweighed by countervailing benefits to consumers or to competition. And this is a little bit of proving a negative, but in practice, it may be that the burden is shifted to a defendant to establish the countervailing benefits. And in the cases of these platforms, they may say the benefit is to maintaining the kind of platform that the overwhelming majority of our users want to have and maintain. And that raises a real question of who gets to decide, how the business should promote itself and market itself, and what type of business, environment it wants to have for its users. And then the other factor in unfairness and evaluating countervailing benefits is and harm is there could be a lot of issues with the unique nature of content moderation, where each user's moderated content may have different equities that need to be balanced under this prong, and look, aggressive speech towards another user may have very different equities than removing sexual exploitation material or users known to be affiliated with that. And then there's a whole line of different types of content moderation that occur. And I think each one of them would probably have to be analyzed uniquely and this same countervailing benefits test applied. And it gets really tricky. So with that, I'll not go on forever and turn it back to Bilal.
So let me ask a quick question, or maybe make a statement to keep in the back of our minds before Laura touches on deception. I think about an unfairness claim as rooted in a duty to do something or a duty to not do something, and not tied like deception is to an act that has already maybe occurred. And if there is a duty to do or not do something, if that's the way to think about it, it does run into the question of, would an unfairness claim be remedied, right, by compelling speech in the area we're talking about? So I just ask people to keep that in the back of their mind as something we may discuss. And then I'd also ask, just on the commerce question, the unfairness framework requires sort of a balancing, including this calculation of countervailing benefits. And I do wonder if that prong of the unfairness claim might bring an analysis of speech practices within the test for in or affecting commerce, right? I think we heard earlier that speech was not necessarily in commerce, but this prong about countervailing benefits, I wonder if that brings it into commerce. So those are just things to keep in mind, maybe in the background as we talk. So, but Laura, why don't you just give us the framework for deception claims?
Sure, happy to do that. Great to see you all today. So the deception framework is actually, I think, a more straightforward theory for the FTC, generally speaking. And it really goes after like what we think of as sort of the bread and butter of the FTC's enforcement, looking at deceptive representations or omissions. And I think we have a slide, if you go back, there's a slide that just lays out, this is the deception policy statement. Yeah, it was actually the one that had unfairness on it as well. It just shows the, I'll just keep talking. So to show that an act is deceptive under Section 5 of the FTC Act, the Commission has to prove that there's a representation or omission that either misleads or is likely to mislead a consumer acting reasonably under the circumstances. And that representation or omission has to be material. So let me just break that down a little bit. Okay, here we go. So this is articulated in the deception policy statement. There's also a lot of case law on deception. It's been more heavily litigated than on fairness in terms of what Ian was just walking through. And I think an important point here about the deception framework is that it covers not just express claims, but also implied claims. And so the FTC is going to look at how reasonable consumers interpret the messaging from, let's say, a platform about what their practices are, not just in terms of the specific words on the page, but the overall impression of what's communicated to consumers about their practices. Now, the implied claims, that sort of claim interpretation is subject to a reasonableness test. So you're not just protecting like the one individual who took away a particular implied claim, but whether a significant minority of consumers took away that implied claim. And that's sort of the threshold for what a reasonable interpretation of that claim is. The other thing about deception and the application of it in the law is that whether a claim is communicated by either the express claim or the implied claims is interpreted in terms of a reasonable person in the target audience. So, classic example is messaging that's directed to a business audience versus an individual consumer audience. The FTC is going to look at who's a reasonable consumer in that target audience that's receiving or the subject of those claims. One other point here is on materiality. Now, under the case law, materiality is presumed when there's an express claim, as well as in other situations where there's a claim, for example, about a core characteristic of the product or service. So in many cases, I think materiality is not a real, is not a major issue on which a case is won or lost. In a lot of cases, the FTC is challenging express claims where they're entitled to a presumption of materiality. But of course, the defendant can put forward their own evidence to rebut that presumption in litigation and defeat that third prong as needed. And of course, looking at deception, you're looking at whether that claim is either false or misleading. And misleading can also include a lack of substantiation for that claim. So it covers both actual falsity or lack of substantiation. In other words, a reasonable basis for the claim that's being communicated. So I'll stop there. That's sort of a bird's eye view of deception law under Section 5, but I'm sure we'll delve into more specifics as the discussion proceeds.
Okay, I hope we will. So, again, deception is a much narrower claim, much narrower focus than an unfairness claim. Neil, when we were preparing, I think you wanted to raise, I think I have this right, I think you wanted to raise how one may expand into the other, or how they may overlap, or under what conditions they may overlap. So why don't we, if that's correct?
Sure.
Let's.
So if we think about like what the commission, what the staff will do when they're looking at a fact pattern, right? They'll look and see, like, can we make a case here that this fits deception or that it fits unfairness? And they're going to always prefer, for the reasons that both of my colleagues have said, they're going to prefer deception if they have the facts, right? If they have an express claim that's not true, that does cause harm, thus it's material, they're going to prefer that type of case. But if they can't quite squeeze it in there, they'll try to put it in an unfairness frame, where they'll have to do that balancing analysis, where they'll have to look at the harm, see if it's substantial, and they'll look at the benefits to consumers and competition to see if it outweighs it. So you can sort of think of deception as a subset of unfairness. Now, one of the things that has happened, I think, this has happened for a long time, but there's an aggressive move that you can have if you have a settlement where you'll bring a deception claim, but then you'll also bring an unfairness claim on the same fact pattern, right? And the reason you might do that is because you want to set a sort of precedent that maybe in the future, when we can't quite get all these facts, but we have something that looks sort of like this, that there's also an unfairness claim available. And so I just want to point that out as a strategy that might be used by the commission when it's looking at fact patterns, including maybe some of the really wide range of fact patterns that I suspect they'll receive in response to this request for comment.
So
Can I follow up on that?
Yes.
So I want to piggyback on this concept of, number one, double pleading, and in a particular context, it's really interesting. I don't know, a dozen years ago or so, there was this old flashlight app case before we all had flashlights on our phones, and this app offered, quote, the brightest flashlight, but it was also transferring and selling to advertisers consumers' precise geolocation data and unique device identifiers. And the FTC brought this claim as deception, as a material omission for failing to inform consumers of this policy. But you see now in the data broker cases, that same kind of activity, and in other cases, is pled as unfairness. And so it's an interesting overlap, and I think it's really smart to think about both.
Yeah, just to add to that, I think in terms of the intersection or potential overlap between unfairness and deception, as we've said, deception is usually based on an express claim and potentially implied claims that are conveyed as a result result of the express claim. You could have a misleading implied claim based on a statement that's true but partially misleading without additional information. That is a type of deception claim, but you can also move into the unfairness realm if there's no claim at all and the omission of any information about, you know, some aspect of the product could be pled as unfairness. That's sort of a pure omission case. But as we've said, the standard is higher for the commission. They have to prove actual harm or the likelihood of substantial injury as a result of that. Whereas in a deception case, where your hook is some claim, you just have to show that it was material. You don't have to prove actual injury that's not outweighed by countervailing benefits. So that's another area just to keep in mind in terms of the theories is, you know, a pure omission versus a partially true claim that needs additional information to be non-misleading.
So this is the critical point this morning, is that in general, the FTC Act is concerned with consumer injury, but you only have to prove consumer injury in unfairness cases, because in deception cases, you get to presume that there's injury if it's material. It's the first presumption. You get a second presumption if the claim is express. Then you can presume that it's material, which in turn means that there's harm. But the critical point to note here, if you go to slide 11, is that all comes from a context in which the court noted, in the absence of factors that would distort the decision to advertise, we may assume that the willingness of a business to promote its products reflects a belief that consumers are interested in the advertising. In other words, in a normal circumstance where it's just an ad, if you say, buy my product because X, it's logical that that's material and that consumers will be harmed if they don't get X because it's an ad. The problem is that we're now going from a world of the FTC policing normal advertisements where that makes sense to the world in which the FTC is policing all kinds of statements and representations and maybe claims where that doesn't really hold, where it doesn't necessarily make sense to presume that just because somebody said something, for example, at a congressional hearing, so this is something that comes up in the request for information. There's a specific question we'll get to about what did executives about the company say publicly? What has the company said publicly? Well, that may have occurred in all sorts of circumstances where there is a, quote, absence of factors or there's a presence of factors that would distort the decision to advertise. In other words, if a member of Congress says to you, well, Mr. Zuckerberg, is your service neutral? And Mr. Zuckerberg says, well, yes, but of course that's complicated. What does that mean? We try to offer a forum for everyone to speak, but we have terms of service that govern that. Those are important distinctions, and normally the commission would look at all of those in evaluating overall the impression that's created to consumers. But one thing you see that the request for information is trying to do here is essentially to say, well, you said once in one circumstance that you offered a neutral service or you didn't try to censor political views or whatever, but now you're censoring political views and that's a misrepresentation and we're going to find that to be deceptive. That really is a non sequitur. It misapplies deception law and takes concepts that were developed in normal advertising law and tries to apply them in a very different circumstance. So what would be required there would be evidence. You'd have to actually show that the thing that the consumers were promised was actually material to their choice, which meant that they would have made different choices if they had known something different.
So let me comment and then maybe open up for some questions. Look, I think we should be careful in one respect, right? The FTC has announced this sort of request for comment. They have not taken an enforcement action. You know, is it reasonable to open up this kind of request for comment, given some of the hurdles of bringing a case with respect to speech-based conduct? Maybe not. But so far all we have is this inquiry and some general statements of interest and concern about content moderation policies censorship and bias. And I say that because I think there is largely, but not entirely, a difference in the rhetoric we've heard and the scope of what they're asking for comment on, right, or support for. So I think what I think we want to do is look at the the request for public comment, and ask ourselves, what kind of theories are they heading towards in terms of identifying, harm or illegal action, and can those be expanded into other areas, right, or another framework? So I think if this is right, I think even a general reading of the request for public comment suggests they're largely focused on a deception claim, right? Deviations from publicly announced terms of service, maybe claims, but it is possible under some conditions to turn those to turn those actions into a perceived duty, or to do or not do something. So I don't know if this is really the right way to do it, but I think a close analysis of the service, theory one, right, speech-based service denials, right? I mean, they are asking questions about under what conditions have you as a commenter been denied service. So can I just ask, Ian, maybe I'll start with you if you'd like. Well, let me start with Laura for a moment, right? Theory one, speech-based service denials. Let's talk about that as a deception claim, and then maybe how it might work its way into an unfairness claim, right? And then I'll ask Ian to follow up on your comment there.
So this one, I think, is most straightforwardly analyzed as a deception claim, because you're looking at denials or downgrading of users' access based on a claim that might have been made about how the platform would be operated. So on the one hand, I think that's a fairly straightforward approach for the FTC to take. But on the other hand, I think you run pretty straightforwardly into First Amendment concerns, because I think it would force the Commission to evaluate the content of the speech, which prior leadership of the FTC has refused to do on multiple occasions because of the First Amendment concerns. I think former Chair Muris responded accordingly on an issue like this, and
That was the Fox News case.
Fox News, exactly. And even in 2020, when there was a request under the first Trump executive order on content moderation to examine denials of content moderation and the impact on certain views, former Chair Simons also said, the FTC is in the business of commercial speech, not moderating non-commercial speech. And so I think, on the one hand, like I said, it's pretty straightforward, but I think it presents a lot of issues for the Commission and is going to be very challenging. I think the other issue is, whether claims about neutrality, platform being neutral, whether those are even actionable claims. I know that there's the Prager case that found that those claims under the Lanham Act were non-actionable puffery. So I think that's another legal hurdle. I'll pause there.
And we should explain, but puffery, right, in general is things like, this is the best product ever, this is fantastic. They're things that consumers, don't take as literal claims that you can be held to, especially when those claims are not objectively verifiable. That's what the Ninth Circuit said about Prager's allegations about YouTube. It said that when YouTube talked about offering a space for users to talk and have a discourse open and so on, that those were not actionable in the ways that, again, saying that my product contains X number of grams of fat is an actionable claim.
Can I just make this really concrete? So if the Commission was asked, if the Commission was looking at a claim in terms of service that the company takes down hate speech, and somebody said, hey, they took down my content, the commission would have to look at that content and decide whether or not what they said was hate speech, right? That is content-based analysis, and that seems very problematic under the First Amendment.
Right, so even though the claim is sort of a violation of what you might call terms of service, you quickly run into the question of evaluating the content.
Exactly.
Right, and I think that's what the first panel was suggesting, that even what looks like a content-neutral analysis of a claim in this situation just devolves into an analysis of whether the content itself was appropriate or not, in a sense.
And this is, again, I referred in the last panel to this chasm between rhetoric and what the RFI actually asks about. The RFI doesn't make clear exactly what the legal theories are, but in the first set of questions, it asks about adverse actions based on speech and affiliations, right? Without really tying that to a particular legal theory. I mean, it's not as if, let me put it this way, if a platform said, we will not make content moderation decisions based on activity that happens off of the platform, but then they did, that would seem like an actionable claim that the commission could evaluate without having to evaluate the content of speech. But that's not what we're talking about, right? Instead, they're trying to get to that goal of stopping the platforms from making content moderation decisions based on offline behavior, based on what? It's not clear. They're asking questions. Some of the questions are things like, how did the representations change? So if you're trying to parse what's really important in the responses to the request for inquiry, which are due on the 21st, I think in some ways the sleeper issue is not people saying, I was banned, I think this is unfair, but what you might see about people saying, well, the terms of service changed, right? The terms of service used to say X and now they say Y. And I think what you will need to pay attention to is there something along the way in what the companies said about their practices that might be inconsistent with what they actually did? And then in particular, you'll see that one of their claims is that companies might be changing their terms of service and then trying to apply them retroactively, which in general, consumer protection law is a problem, right? If you say one thing, and then warranty is a classic example, right? Where you make a long-term promise to a customer, and then you change the operation of that, or you offer them unlimited service forever on their plan, and you don't deliver upon that. In general, that's deception.
It's unfair.
And indeed, it's also unfair. Indeed, right?
Yes.
It can indeed
The
be both.
retroactive change, yeah.
Right, and so that's the kind of thing that the commission is going to try to hang its hat on here legally.
Can I make a point about the process? And, when we're talking about whether something's deceptive, you want to know what happened. And, Bilal has run these kind of RFIs, and I did in the policy shop at the FTC. And what we have to think about here is also who is commenting and how reliable these comments are and whether they're based on actual knowledge of what happened, too. If you look at the RFI docket, in most RFIs, I think a third of the comments at least are going to be anonymous. When I checked this one last, there were a ton of anonymous comments. It's unclear to me that users of a given platform actually do know, and this might be part of the unfairness question, but it's unclear that they know exactly what content was moderated, how or why. And I saw one anonymous comment I just happened to click on, and it said, well, everything here is based on my knowledge except for the things that I didn't know, which I guessed, right? And so the FTC just shouldn't be basing enforcement policy on things that anonymous consumers guessed. And so it's really hard to identify specific deceptive practices based on that kind of record.
Which is probably why, just on this slide, for the first set of questions they ask, they're clearly not actually thinking about a deception claim, they're thinking about an unfairness claim, which is why they ask about countervailing benefits, and they're not asking here about representations.
Yeah, that was the point I was going to make. I mean, I think that one of the most notable things about the RFI is actually the number of questions that I think get at building an unfairness theory. So they're asking questions that would take this outside of just, take it more into the realm of actual harm that can substantiate the substantial injury prong, looking at actual financial injury, and looking at whether that harm was avoidable. For example, being able to respond to notice. If the user doesn't even know that they've been, that they're not getting access to their followers, or that their content isn't being displayed, how can they actually respond? And so I think we see that's a very heavy theme in the RFI, is building each of those prongs, maybe because there's a concern that there won't be specific representations to tie this to, or it could be because there's a thought that maybe looking at the process and the injury created by the process itself might be a more viable theory under unfairness. Either way, I think you still run into some really significant First Amendment challenges, whether under unfairness or deception. But that, I think, is question by question, you see a number of ways that the FTC is trying to build a potential unfairness case.
Can I add on that? One specific way that they do this on the harm prong is footnote 2 talks about the harm not just being to the person whose speech was censored or suppressed, but also to the listeners who would have seen that. I think that's interesting, but I think that I'm not sure that that weighs totally in their favor, especially since there is the cost-benefit analysis, the benefit prong, which would suggest that you also have to take into account not just the benefit to the individual, but to the full ecosystem of content moderation. And I think that barrier is very high for the commission, or for the commission to show that content moderation of certain types of speech did not outweigh countervailing benefits to many other people on the platform who were probably screaming about wanting that content taken down. So I'm not sure how that factor is going to weigh in their favor.
I think legally what they're going to have to do is try to focus this on particular groups. And this gets very messy because, so in the deception policy statement, which is what the second set of questions focuses on, there's a note that says, this is not a statute, this is just something the FTC said back in 1983, but they said that if a representation or practice affects or is primarily directed to a particular group, the commission examines reasonableness from the perspective of that group, right? And normally that's about like the elderly, right? So you make a claim to the elderly, they're taken advantage of, you don't look at overall how consumers respond, you look at the elderly. The rhetoric here, the entire framing of this is that a particular group is being disadvantaged, which is that it's essentially the president and his supporters. And the answer to your question, Neil, it has to be that they're going to try to import that concept also into the substantial injury prong to say that there's a particular group that's being disadvantaged, and when we weigh countervailing injury, as the statute requires, Section 5N, we have to weigh particular injury to those particular people greater than the overall benefits, alleged benefits, countervailing benefits that are alleged to occur. And this is where I think they run into a First Amendment problem, because it's one thing to weigh, to refer to what I said in the last panel, business practices, right? Where you weigh economic, quantifiable harms and benefits. It's quite another thing to start getting into the subjective weighing of good speech and bad speech and who likes what. This is precisely what the courts have said again and again. The First Amendment bars the government from doing. So even though I think, conceptually you can sort of imagine what they're trying to do, I don't think it works in First Amendment doctrine.
I'd like to pick up on something you suggested, which is both you and I have experience doing these requests for comments, requests for information. And you talked a little bit about some of the comments, and I don't want to cast aspersions on any of the commenters. I've read, a couple hundred of them, and some folks are pretty upset. But we're going to talk maybe later in this discussion about next steps, but what is the what is the standard for opening an investigation, right? And would you look, a law enforcement investigation, would you look at these comments and say, you know, the comments received are a sufficient basis, you know, to seek authority to open an investigation and send out, you know, subpoenas and similar to a subset of companies?
So I'll start, because I've been on both ends of this, from the RFI process, but also as a line staff attorney like Laura too, like opening the investigations based on consumer complaints. And first though, the RFI seems pretty clear that comments may be used to inform enforcement decisions. And I think it's a very clear statement about what staff or Chairman Ferguson intend for this. But second, you know, when staff typically open an investigation based on consumer complaints, there's often a lot of verification of the complaints that goes on before staff decides to send a civil investigative demand to a target or to third parties. And as a line staff attorney, that often looks like going into the FTC's complaint database and along with an investigator, interviewing the consumers who have complained and trying to, you know, verify some of the facts and see how they fit into the legal framework, see if there are consistent patterns or if it's just random consumers who are angry about one thing and angry about another thing. Here, the overwhelming number of anonymous comments can make that hard to perform that kind of analysis. The large number of platforms can make it hard to perform that kind of analysis. A single commenter may complain about 3 or 4 platforms. Which I saw a few comments that had multiple platforms addressed. And then the volume, I think there were 2,500 comments last time. And you know, the FTC likes to say it's small but mighty, which is true, but it's small, right? And there are resource constraints, and verifying that kind of number of comments is really hard. So it calls into question how easy a task it is to properly vet the comments in order to base a decision to open an investigation.
I'll just add to that. I think it's interesting that the RFI clearly is soliciting informant comments too. You know, complaints from people on the inside, and from my experience working at the FTC, those can be quite valuable. They do have to be vetted, but I think if that's one avenue that could be fruitful for them. I recognize there are a lot of anonymous comments that have been filed already, but if there are some of those informants who you know, are willing to give the FTC a little bit more to go on, that could be valuable. And I assume that they are, given that this is a public proceeding and the comments are all public, that they will also be relying on the complaint database, as you mentioned, where that's not publicly available and gives informants more of an opportunity to kind of share more openly. But I agree, they've made it clear that this is going to be helpful to their enforcement efforts, and I would expect that they'd be trying to comb through this for things that they can actually validate through interviews, et cetera.
As a legal matter, the statutory bar is very low. So Section 5 is the key statute here. 5B says whenever the commission shall have reason to believe that any person or whatever has been using an unfair or deceptive act in practice, and if it shall appear to the commission that a proceeding by it in respect thereof would be of interest to the public, it shall issue and blah, 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 complaints, et cetera, et cetera. In other words, it can invoke open investigation. The commission can do whatever it wants, frankly.
That's actually for issuance of a complaint, not even issuance of a CID. So I think you're about to go there, but for the issuance of a CID, it's even lower, right?
And actually, the commission has broad powers to investigate entire industries, right? So Section 6B of the FTC Act gives the agency the ability to request information from companies as long as it's fewer than 10. They have a really easy time doing that, which is why you'll see them send out these batches of 9 letters at a time. So in terms of what happens next here, to sort of skip to the end, I think step one is you see a slew of those 6B inquiries going out to all these companies. You'll see a broad number of investigations open upon this, and you'll see complaints filed just based on this very low bar, right? If it's, people have complained, we think it's in the interest of the public to do something about this. And what will this actually be based on, right? So Laura mentioned that they're looking for internal informants. Well, you can imagine them doing a few things with those, right? One could be that the informants tell you that something's happening. It wasn't clear, right? So the thing that's happening is either unfair or it's inconsistent with their public statements, right? In theory, that can be very helpful because it may not be apparent what's going on. But I suspect actually that a lot of what's going to happen, if you look at this slide here, you see they're asking in particular about the public-facing representations, right? That's normally what enforcement actions are based on under deception. But also internal or external statements of executives and employees, right? That's what I was alluding to earlier when I talked about things like, well, you said X at a congressional hearing, but you didn't deliver upon it, right? That's different from your content moderation practice. Your terms of service say something. It's not a generally intended marketing claim. But in particular, I think what they're really looking forward to finding here is what we call hot docs. So hot docs usually come up in antitrust cases. The famous example of this is in the antitrust case with Microsoft and Netscape. There was an email internally where I think it was Bill Gates who said something like that Microsoft would just bury its competitors, would try to destroy Netscape, right? Those are examples of internal communications that can make a company look very bad, but it's not clear what weight they actually have or what relevance they actually have in an unfairness analysis. I mean, what does it matter what the company says they're doing, except that it certainly makes it easier for you to coerce the company into settling because it may impose a political cost. But I don't think it really changes the analysis. If you're bringing an unfairness claim, you still have to show that there was injury. The injury wasn't outweighed by countervailing benefit, and consumers couldn't reasonably avoid it.
Can I just weigh in? I think there's one other more benevolent explanation for getting docs from informants. That is sometimes, in some instances, finding out what the actual policy was. There may be a public-facing policy, and if the FTC wants to establish that the actual policy and practice was different, internal docs can help establish that.
That's
the
what I
relevance.
meant. That's what I meant by the first point about
Yeah.
there being a disconnect between actual practice and public statement.
Yeah. So.
Let me, Neil, did you have something?
I mean, I can always talk, but.
Let me take it back a little bit to the list of inquiries of interest in this comment period, in this comment process, and maybe I'll ask it sort of an overarching question. I mean, do firms have to have a content moderation policy? And do they have to have an appeals process, right? These go to sort of the unfairness question and not so much the representations the company has made. And of course, that's where maybe there's a little bit of ability to impose some kind of remedy. But let me just ask those simple questions. Do firms need a content moderation policy? Do they need an appeals process? Do they need to give notice, advance notice, multiple, opportunities to violate some standards the company may have, the platform may have? Do they need to do any of that with respect to their decisions to publish or not comments?
On the content moderation policies, whether they seem to think that they need one for market reasons anyways, or maybe other types of reasons, but because all of them have them. In fact, some of the when I think about platforms that change their policy in a direction that was maybe unanticipated, I think about Parler's early rollout where they promised like this was going to be the free site, right? That was going to be totally free speech, and they quickly identified that that was not appealing to their customer base and that they needed to get it under control. So they issued a content moderation policy, which gives them, it sort of lays out the path for which they're going to try to comply in the future. So
With very broad discretion.
right, with very broad discretion. All of them have very broad discretion in their written policies. And so when it comes to the appeals process, I think that's more of an interesting question because I think the appeals process is less spelled out on many platforms about what exactly is there. And we would expect in spaces where you were removing something that would cause like real substantial harm to a person, that an appeals process would be something that market forces would drive companies to have, because there would want to be an assurance on that. Does that mean that it would be unfair to not have an appeals process? I think that I think actually the answer is that it would not be unfair to not have an appeals process, especially if you spelled out very clearly, like, hey, like we can do whatever we want on our site, and we can take down whatever we want at any time, and you have no recourse.
Newspapers don't have an appeals process when they refuse to run op-eds.
So let me touch on that. Neil, you talked about market forces, right?
That's what I do.
We're sort of in the, what I'm getting at is we're sort of moving into a discussion of unfairness and the scope of duties to do or not do something, right? Deception, while not as straightforward as it seems, is I think a bit narrow. But you mentioned market forces. Of course, also within this request for public comment, there is a question about whether there is sufficient competition in whatever marketplace they're defining. And so, maybe I'd ask this, I wouldn't ask this to the folks on the antitrust panel because it's a little different. If a firm has market power, are they held to a different standard with respect to an unfairness claim? Or is it something that you just take account of in the sort of in the injury discussion and the countervailing benefits weighing?
Yeah, I would say it's more the latter than the former. Competition and consumer protection, complementary authorities, but one works on the micro level, one works on the macro level, much more so. And so I think that to the extent there's a different standard for someone with a large business, I would say that's very much in the weighing of the countervailing benefits to consumers and competition, rather than a different standard, substantive standard across maybe the other factors. Yeah.
I think about it a little differently. I think that what they're getting at is reasonable avoidability. So if you look at this set of questions 4, when they ask about whether the tech companies were colluding or doing the same thing, could users find adequate substitutes? Were users able to reach similar audiences and achieve similar goals, especially on monetization on competing platforms, which are all ways of asking about the level of competition? I think they're really asserting that companies couldn't reasonably avoid content moderation practices, especially being demonetized, because there weren't readily available equivalent substitutes.
Can I tag on that? Because I think the demonetization point is a type of injury, and I was saying this in the pre-discussion. That's a type of injury that looks a lot more like typical FTC injuries. The loss of money. There's even like business opportunity, a whole set of prosecutions around business opportunity scams, where this is a very familiar type of consumer injury. I'll just add, I think the biggest single demonetization event on social media platforms was the FTC's settlement with YouTube over COPPA violations, which made it actually demonetized a whole bunch of content producers on that platform. And so yes, demonetization can be a problem for people who are using these platforms, but there's a lot of finger pointing that could happen probably.
There's a lot of difference between a COPPA claim and an unfairness claim, right? Where
Yep.
COPPA doesn't specifically apply to consumers, for example. There's not the countervailing benefits issues. So it's a very,
And again,
makes this
that
a
was
much tougher.
And that was the settlement, which,
Right.
many of these, we haven't really talked about that, but given the sort of ability to bring a 6B or put a complaint out there based maybe not on that much verifiable fact, but then drive a pretty, light settlement with a company, you could see that would be a very possible avenue here as well, is that we end up with settlements that everybody can claim as a win, or the FTC can claim as a win, and it doesn't take that much skin off of the company's back.
Well, we talked a little about 6B studies, and I think that's a reason that people might want to stay tuned for 6B also, because nobody loses generally, other than the company.
Lawyers certainly win, I'll tell you.
Right, yes. And the company's burden of producing is a loss, but they're not litigated. There's no loser in the 6B studies. And it's
Au contraire. The whole point here is winning and forcing other companies to lose. And indeed, a company can lose quite a lot just by being the target of a 6B study, because the investigation itself imposes a cost.
Right.
And indeed, it may produce documents, especially those internal documents, those hot docs, that make the company look very bad.
Yeah, and the commission typically issues a report that, while it is industry-wide, or, the nine recipients, I mean, I agree, I mean, it is also a very substantial investment for companies that have to respond to those. They're often very, very broad, pages and pages of requests. Yeah, as this panel knows well.
and the commission anonymizes the 6B report, but I think there are, sometimes there are limits to how well things can be anonymized. And there are very interesting questions that come up about what the commission can report if, there's only one company that has a certain practice and another company that has a different practice, and they can't truly be anonymized, what the commission can report on a 6B study.
Yeah, I just note that you cannot use 6B material to initiate an investigation, and so sometimes the 6B process is used to avoid an investigation or a law enforcement investigation. And in some sense, it's a sign, of an unwillingness to pursue a claim, right? Because you realize you don't have the legal authority, but you may want to, as they say, shine light on a practice. But I think I want to be clear too. We are generally avoiding some of the hard questions here, right? Which is how much of this touches on activity that would be protected under the First Amendment, right? We're discussing unfairness and deception in the context, or usually in the context of matters that do not raise First Amendment questions, right? So notwithstanding, there might be an unfairness claim or a deception claim, there may still be a First Amendment issue here, which we are generally alighting over in this discussion, right? I cannot think of a FTC case, an unfairness case based on speech or the content of speech. Is that fair? I mean, certainly there are lots of advertising cases based on the statements of the respondent.
But of course, that they would frame it as not being about speech, right? They would frame it as being about
of course.
a business practice that's regulable and conduct that's not protected by the First Amendment. And I would just note here that if you go to slide 25, that the clearest statement of this is in the chapter on the FTC in Project 2025. Adam Candu, who's now the general counsel of the FCC, he wrote that chapter, and he claims that when internet platforms refuse customers based on their political or social views, which remember is the first set of questions that's inquired about in this inquiry, that can be an unfair trade practice. Now, I don't think this is, there's a lot of, let's say, dots to connect between the RFI and this theory, but this is at least one of the theories that is permeating the commission. So there's a set of thinking that basically says this, and I think that the logic has to be that there is an injury, there's a unique injury, especially in the case of demonetization, and it's not just demonetization of individual users, it's demonetization of, for example, journalistic outlets. New York Post, for example, the Hunter Biden laptop story, there are allegations that particular stories were suppressed, and also with the suppression of those stories, also suppressed was the ability to make money. So one question that this raises that I don't think we really discussed is who counts as a customer? So the commission in the past, in the unfairness and deception policy statements, it talks about customers. It does, at least in one place in the unfairness policy statement, does make clear that the customers could be broadly construed. So customers might include other businesses, for example, being harmed when one business lies, that its competitors suffer, because that's unfair to them, right? That makes sense. You can see this in some of the ways the commission has applied its deception authority in some very narrow circumstances to small businesses that might be deceived by large businesses. But one thing the commission's going to run into here is when Congress codified the unfairness policy statement in 1994 into what is now Section 5N, Congress just used the word consumer, excuse me. It didn't talk about businesses. So there's a real statutory question about whether someone who's not an end consumer qualifies for that at all. And if they don't, then it's not clear that even though there are some people here who might seem to have some quantifiable injury, if they're, if it's an influencer or the New York Post, if they're not acting as a consumer, even though their injury might be quantifiable, it's not clear that that actually qualifies under Section 5N as an injury to consumers.
In the there's a real interesting example of this in the Amazon Flex case, where the FTC pursued Amazon for basically not directing tips to the drivers, right? And the way it was framed was an injury to consumers, but by not allocating their tips properly. It wasn't framed as a harm to the business. And I think this underscores the litigation risk on the definition of consumers under Section 5N.
I mean, I think it raises an interesting issue in light of the executive order that directs agencies to withdraw regulations that don't reflect the best reading of the statute. I think there's some tension here between that executive order and taking an expansive view of unfairness applying to small businesses, which, the commission has done that in the past. I just question, in light of the executive order, whether, how they will sort of reconcile those things.
One thing on the demonetization point, I think one hypothetical the commission should test against any theories that it's going to bring on these is how would the fact pattern of X.com suppressing the traction that posts that link to outbound sites affect this? Like how would this theory affect that fact pattern? Because that's one that I don't think has been clearly disclosed anywhere. I think it does have monetary effects on lots of businesses. It has, including lots of people who use the platform. And so, and it happened without, there's no recourse to that really. You can't avoid it. So one fact pattern the commission might want to test.
So unless someone had a further comment on that, I've taken this time to read this non-economic motive statement. I don't think there's any support in the law for just about anything that's referenced here. I mean, if this is the level of, argument that the FTC will bring, or the FCC, to this effort, I don't think it will get very far. I'll ask others, but there's no support in the law for any of this. And I don't think there's anything in the law that leads to this, right? That this approach is sort of, foreseeing where a court may go.
Well, Intent and motive are not elements under Section 5 deception or unfairness claims is my sort of legal framework.
When I clipped this from the Project 2025 chapter, I elided in the first, when internet platforms, I elided the word when banks and internet platforms refuse customers, because I was trying to focus on internet platforms. But of course, banks are expressly excluded from the FTC Act. So, one might think that there's a reason that Adam Candu wound up as general counsel of the FCC. He's actually sort of a telecom lawyer, not the FTC. And so I don't think that this, I agree, Bilal, I don't think this really corresponds at all to the law. But the commission staff is being asked to find some way of doing something that looks like this. And it's going to be some version of an unfairness claim. And I think it's most likely going to focus on demonetization. Because again, that is the clearest quantifiable injury that you can point to. And if you listen to the panel at the Antitrust Division's Big Tech Censorship Forum, that's a lot of what they were talking about.
Yeah, I think that's right, to the extent they want to proceed with a, what you might call a consumer protection claim. Unfairness is the only one that has any likely meaningful remedy, except for the question of what would be the remedy. And that seems to me to run right into First Amendment concerns, but I'm not the expert. So,
Wait, Bilal, can we just unpack that? Because maybe that's an important point that may have slipped by everyone. The problem with remedies and deception claims is you can always just change your representations, right? So if the commission, somehow managed to cobble together some kind of vaguely plausible deception claim based on statements saying that you would be neutral or do consistent content moderation or whatever, the company could always just qualify how it described its practices, and at least going forward from then on could avoid a deception claim. So that's, I think, what you mean when you say that the only really satisfying remedy would have to be tied to unfairness. And to return to your earlier point, Bilal, every unfairness claim in some ways implies that there's a duty to do something. It's like tort. It's like a regulatory version of a tort claim.
Well, I just to underscore Bilal's point, because I agree with it very much, I think they're aiming toward an unfairness theory. I think the RFI makes it clear they're trying to bolster the evidence on that. But it's hard to imagine how you don't run afoul of the First Amendment when you're going after process or content moderation decisions, which have already been addressed in cases like NetChoice versus Moody. So I think they're doing their best to try to piece this together. They're under strict instructions to do that, but I think it's going to be a very difficult road.
So again, some of that, as the panel before us pointed out, depends on the companies litigating such things. And so we could see that even more so in even if they don't bring a specific case around these practices, I would suspect there will be some pressure, curiosity, as other cases perhaps against these companies come up, or settlements of ongoing cases come up, that there would be provisions in those settlements that try to get at some of these concerns, right? Probably carefully, probably not sweepingly, because I think those are negotiated settlements, but you could see a gray line where we're getting pretty much into First Amendment space, but because it's a settlement, nobody's going to litigate it, it slides through.
well, how would you enforce a settlement that raises sort of First Amendment questions, right? I mean, I think, look, I can see, and I might even advise a client to settle on, a deceptive claim with respect to an appeals process, to avoid further, investigation. But a remedy that focuses on, not curating content, not censoring content, has got to be anathema to any business, just for general business reasons. And so, like any other behavioral settlement, where a company or respondent commits to do something, there will be compliance obligations. And how you evaluate a compliance obligation not to discriminate with respect to ideas and content, just again runs you right into I think runs you right into First Amendment concerns. And companies may settle, but I don't think they can even safely settle right here, because there will be a compliance obligation, somebody reviewing compliance, and the commission or whoever will take, in a sense, either whether it's testimony or complaints. I mean, you just have to set up a complaint database for compliance with the order or decree Company X has signed, committing to do something. And this is an area where people feel aggrieved if they are, deplatformed. So I don't.
That's a great point.
Well, Bilal, before we wrap up and take questions, I just want to point out that I think what they really want, if you think about this from the perspective of what's the real prize? This is it, right? So the RFI asks, have the platforms acted in a consistent manner in response to analogous conduct by different users, and have they applied a consistent challenge or appeals process with respect to analogous content, et cetera, et cetera. This is precisely the same language as Florida tried to require in the bill that went up to the court in the net choice case. This idea of requiring consistency is what we mean when we talk about common carriage. This is what Texas tried to do. It's what the Ohio Attorney General tried to do in declaring these services to be common carriers. It's what we'll talk about tomorrow with respect to Section 230. This is what they really want, is to require services to be consistent, not to discriminate. And essentially that's the answer to your question, Bilal. What duty are they trying to argue for here? This is it. There's some sort of implied duty of effectively common carriage. I don't think you can get there from unfairness, but that's the goal. And I think if you work backwards from that, I think you have to ask yourself, well, where would that claim be most plausible? And again, I think it's most plausible where you're dealing with business users who suffer some kind of economic injury.
I'm not 100% sure that's the goal. I think there's quite a lot of evidence that they would be happy for it to be inconsistent in their favor. But I do think that consistent with the First Amendment, this is their approach, right? And so, yeah.
This is not required under the First Amendment, though. Consistency is not required. I'd also note this is highly regulatory, and given the discussions on getting out of the way of by decreasing regulation, this would be inconsistent. My sense is actually something different, which is that what they would like is some kind of wedge to require some kind of restructuring of the large platform companies, and they can use whether they can use sort of a consumer protection type action to do that is an open question. But I think they are wise enough to realize that a remedy here that requires oversight is just not possible to manage, and they are looking for ways to just suggest we need more competition, right? And one thing we have here, right, is a loss of views. I mean, we'll talk about this in the Antitrust panel, which is they are treating speech as sort of a non-price factor in competition, and I think the effort here is to increase competition by restructuring some of the larger platform companies.
Well, that's
I
precisely
could be wrong.
what-
I could be wrong.
That's
about
precisely what the chairman has said, that a lost diversity of opinion is a consumer injury, a substantial injury that the FTC Act is concerned with.
So let me ask if folks have closing thoughts. I think we're close to stopping time, so if people have closing thoughts, I'd ask you to get them out. I think this will go on for a long time, though. That's my sense, and I think they're reaching for claims, but there's probably no downside to the agency to reach or overreach as compared to what they otherwise might be doing.
I'll share a super quick closing thought. There's no reason the FTC can't pursue both policy initiatives on this, like 6B and a workshop, at the same time as non-public enforcement through a CID. And so it's very possible that both can occur at the same time.
Go ahead.
No, go ahead.
No, I was just going to add as a very quick final thought that I very much agree with what you said, Neil, about the commission potentially trying to push this, even where the law is, not fully supportive. If they can get a win in terms of a settlement, they will then point to that as, this is what the law is, even though we all know that's a settlement, not, litigated case law. That could be a strategy that they'll pursue, and I think this is a first step to help them build that and see where the potential lies.
Yeah, and to Bilal's good point about the enforcement of such orders, it really depends on what the commission's goal is, or the leadership's goal is. Is it to actually change the practices of the companies? I think that is a goal, but also getting wins is important as well from the political aspect of this, and so they may do settlements that they can't quite figure out how to enforce just because it's a win they can not.
Right, not necessarily a litigated win, but a win that they can point to publicly, yeah.
And this would not be unprecedented. This is what they did on privacy and data security. The commission in these new cutting-edge areas of technology generally operates through unlitigated building of so-called common laws over the course of many years or potentially even decades. That's actually normal. And you could imagine them doing exactly the same thing here, precisely because these companies don't have an incentive to litigate. If there's no
The
money,
challenge, of
it's
course,
safe.
being that there's much more consensus, I think, around across administrations about what privacy practices should look like, and probably a lot less consensus across administrations about
But
what
why
content
would
moderation
that? Why would
practices.
that matter? I mean, for the purposes of this administration, that they could continue to build that common law, and maybe it ceases if there is another Democratic administration. But at least for the time preceding, all of these issues we've been discussing today may be just entirely abstract and theoretical, and may not matter if companies are willing to sign consent decrees, just like with law firms, right? Law firms have been willing to bend the knee to the administration, regardless of what the law is. Why would we expect that social media services would be different?
I think, I think that firms are willing to settle when they understand the risk of their compliance obligations with respect to that settlement. And so in this context of a settlement with respect to content moderation policies, I don't think any of us as lawyers would be able to get our clients comfortable that they don't face future compliance penalty issues, right? And so I just, again, on deception claims, I can see people settling. Don't do it again. But on obligations not to discriminate, I cannot imagine a law firm or an internal lawyer that will tell, the board that this resolves the issue.
I suspect there are some small platforms out there who do not have as good of legal advice as you're willing to provide, and who would be very likely targets for such things.
Okay, maybe, but I just remember, there will be compliance obligations. You cannot easily make this go away. And I also think the agencies recognize that, and why I believe the effort here is to tie an unfairness claim to a desire for more competition and a restructuring of the platform.
So can we close by playing the clip from Better Call Bilal, which is going to be launching this season?
No. I
The NGL case is sort of this, right? Like, it's a small platform. There's a lot of terrible things in there, but there is a fact pattern in there about them making claims about how they did content moderation with AI, which was clearly not true. Like, I don't think this one moved the ball that much, but this is the pattern that you might see if you were trying to shape content moderation practices across larger platforms.
I just also note that to the extent, and I'm not sure that it is, but to the extent this is an issue only for the current administration, I just think they're going to have limited ability to do what they want to do, which is restructure this industry, and a settlement that doesn't do that just doesn't get them what they want.
Well, I would also not assume that the next Democratic administration wouldn't love to continue some aspects of these legal theories. I mean, it's just worth noting, we touched upon this in the last panel, but you have these First Amendment issues working in both ways, right? The New York State case involved New York attempting to force social media services to moderate hate speech. California has attempted to force social media services to moderate harms to kids. This sort of thing could go both ways, right? You could very well see if the commission succeeds to some limited degree even in bringing some settlements here that might be intended to reduce content moderation. You can see the same claims being brought under Democratic administration for essentially opposite purposes, which is a reason why I would really encourage this commission to really think very carefully before it acts on any of these ideas.
Well, that sounds like a good place to end.
Okay, well, in that case, we'll break for half an hour, and we'll start again at 12:30. We're having a fireside chat with Commissioners Bedoya and Slaughter, and Bill Kovacic, moderated by Bilal, at 12:30.
And Jess. I think we're back. Thanks for joining us again. So this is styled as a fireside chat with three FTC commissioners, two in limbo, one clearly a former commissioner. So.
Not by my interpretation.
So,
Maybe
so
we'll get to that.
starting closest to me, extending out. Bill Kovacic, who is presently professor at GW and director of the, what's the name of your center? Competition Law Center?
You got it.
Okay, yeah.
Thank you.
And also many other things in between or prior to that. Was a commissioner, was acting chair of the FTC, was general counsel.
I was not acting.
Oh, that's right, you
yes, I
were,
was not
sorry,
acting. I
I'm
got
so
the
sorry.
part. I did.
I'm sorry. Good, because you deserved it, absolutely. You deserved it, I mean, I like.
The most hateful participle in the world.
I like Debbie Majoris a lot, but you and I know that you were Tim's first choice to replace him. I don't know if that's public, but now it is. So it's good. And we have Commissioner Slaughter, who was acting chair in the first 6 or so months of the Biden administration, who is now sort of in abeyance as a commissioner. If that's a fair, I don't want to call you former, because I don't think it's right.
You can say whatever you want.
No, I don't
Alvaro
think
and
it's right.
Commissioner Bedoya and I will say commissioners, because
Yeah,
that is our
that's-
legal position.
Yeah, exactly. No,
and
that's exactly
substantive
right. That's
position.
exactly right. I don't think it's right to call you former. I mean, until it's litigated, I don't think that's right. And of course, Commissioner Bedoya.
I was
also
never
joins us.
chair, acting or otherwise.
Yeah.
It was just a
So
line.
you had the gavel in your drawer, and
I
the
was,
call ever
well,
came.
I would have returned the gavel, I think, but, yeah.
There's a lot of fun in I assume, in just being a commissioner and not
Oh,
having
yes.
as much responsibility.
That's
And then, of course, Jess is on the far right.
Also not a chair of the FTC, for
No,
those of
no.
you following along at home.
But you know what? They could do worse, and they have done worse. So look, this is going to be an unstructured chat, and I think it's worth starting with sort of the status maybe of your legal case. I mean, as I think viewers know, let's see, I think in late April, President Trump fired or purported to fire Commissioner Slaughter and Commissioner Bedoya from their position as commissioners.
March 18th.
Yeah, I was
March
about to say,
18th.
yeah.
we know the date,
Okay,
March
okay.
Yeah, we
18th.
feel the full
Remember.
On the commission, and you're challenging that firing. I would like to give you a chance to discuss that case and however much detail you would like, and why you think the firing was illegal. The question I will pose, and Jess will also ask questions, and we can all talk amongst ourselves, is I think most of us understand that the firing is in contravention of the decision in Humphreys. There is a view that Humphreys was either wrongly decided at the time, or if not wrongly decided at the time, would not be decided the same way now, either because of developments in the law and doctrine, or because the FTC looks a lot different today than it did 90 years ago. And so, putting aside what I might call the policy preference as to whether the president should have the authority and right to fire a commissioner, I do wonder about the strength of your legal case, and how you might get around changes in the law and perhaps changes in facts. So, Commissioner Slaughter, maybe I'll let you start. Let us all know where we are, and then how you guys intend to proceed.
Sure, so short chronological update is that our case is pending on a motion and I guess cross motion for expedited summary judgment in the District of DC, and we have a oral argument in that case is next Tuesday. So that's the most immediate timeline question in front of us. I think actually a legal question that is really important to go into, Bilal, you mentioned that there's a question about the validity of the Humphreys executor precedent. The case actually isn't really just about that precedent. It is about the plain language of a statute passed by Congress. And I think we really have to start there. Under our system of constitutional government, Congress structures the operations, the institutions of government. And Congress structured not only the FTC, but basically myriad other federal agencies to be multi-member bipartisan commissions with terms of years and protections against removal, also protections in the appointments process so that no more than 3 members could be of any one party, that they serve for fixed terms, and they take slightly different, those protections take slightly different forms for different commissions, boards, institutions, but the general import is the same, which is that Congress intended a number of these institutions to be represented by or governed by multi-members from different political parties who served over staggered terms. And what Humphrey's executor did was say, yes, that's what the statute does, and yes, that's constitutionally valid. And so I think that is where most good litigation starts and ends with the language of the statute, and I think that is what we are pointing to fundamentally. There's also lots of great information about sort of text structure and historical constitutional arguments, including the history of commissions given to individuals who had government appointments dating back to Marbury v. Madison, the structure of multi-member boards coming from the Interstate Commerce Commission, and more. So, all of that, we can get into the weeds of all of that if you want, but at the end of the day, I think what we are arguing is that there is plain text of a statute passed by Congress over 100 years ago and replicated in many other institutions, and that both the administration and the courts need to respect that statute, and that it does not deprive the president of the ability to administer the laws and execute the laws. The president still exerts enormous control over the Federal Trade Commission and other independent boards and commissions, including by designating chairs, requesting budgetary allocations, doing a lot of the personnel operations, and more. So I think it is not a dispute about whether the president should be able to execute his policy. It's a dispute about whether the laws that Congress passed should be respected.
So, of course, the courts do find congressionally passed statutes unconstitutional. And so in that sense, it is sort of for the judiciary to review. And that sort of goes to the heart of the question, right? I mean, the court in 1935 did review the constitutionality of the underlying statute, found it to be constitutional, I think because, and distinguished it from the earlier Myers case by finding the FTC acted in a quasi-legislative, quasi-judicial manner. I think avoiding sort of the executive functions that it found in Myers. And so while I agree it's important to look at the statutory language, it is up to the judiciary to interpret that language. And so I just sort of reiterate the question, which is the agency has changed. What appears to be the underlying rationale for finding the firing of Humphreys illegal seems to have changed over time, right?
So I actually want to push back on that a little bit because I think and first of all, I will leave the lawyering to better lawyers, of which we have many, and I commend to you the briefing in the case because it tackles all of these arguments very head on. But I will try to do a sort of layman's summary, which is that if you read Humphreys, there are actually a couple of different rationales for upholding the removal protections. One is that it is a multi-member, bipartisan board, governance structure, et cetera. And the second is it sort of breaks down the functions. And as you say, the court in Humphreys describes some functions as quasi-judicial, quasi-legislative. That is not, the functions that they were describing are many of the same functions that the FTC does today, and we have long since abandoned those sorts of terms to describe those functions. And even at the time, I think they would have been understood in similar ways. So I think that's like a vocabulary problem, where the vocabulary has changed over time more than that the agency has changed. Certainly the agency has changed over time, but not in ways that change its fundamental character, I think. Obviously this is going to be a question that's litigated. Other people have different opinions about it, but I think it's not entirely accurate to say that the nature of the functions of the FTC are so different today as to render the agency described in Humphreys unrecognizable today. And then the question is just, it becomes more, should they have upheld the removal protections then? And I think then you get a little bit more into what are the constitutional checks and balances at play, and what are the policy arguments, for Congress? And then I think really, really importantly, what are the consequences of the Supreme Court saying now that either Humphreys was wrongly decided or that principle doesn't apply to the FTC or indeed any other agency? And I think that's the thing that in a very academic debate about unitary executive theory is going to get lost, because it's not just the FTC, it's the FCC, it's the SEC, it's the CFTC, it's the NLRB, it's the Federal Reserve. And I think it is very difficult to make the assumption that Congress would have imbued all of these bodies with the same authority that they execute today had they understood those both removal protections and the related appointments requirements to be constitutionally infirm and non-viable. And so then the question is, can these agencies even continue to exist?
But don't you think, just in either one of you, any of you, please respond just for the sake of conversation, people advocating on the other side would say, specifically, there's a lot more executive function at the FTC than there was in 1935. So now you have an FTC who can go into a federal court and ask for an injunction. That seems to be a little bit of a differentiation from the other agencies that I think, and let me also say for the group, now is, for a lot of people, not a great time to press on this issue. And I won't even take your point. I'll make that point for you, right? I don't think this is the ideal administration where a lot of people who have been working on this for a long time wanted to see it come to fruition. So I think that's a really valid consideration and all that. But I do think, just on the letter of more technical parts, the FTC, one thing it does different is it acts much more in a law enforcement executive way than it might have the last time the Supreme Court looked at this specifically.
So I prefer not to go into technical stuff and actually just ask why we have these for-cause removal protections to begin with. Because I think the purpose behind those protections is as important today as it probably has ever been since these protections came into effect. So I'm sure there's lots of folks in the room who know these removal protections were not born in 1914. They were basically copy-pasted from the Interstate Commerce Commission in the 1880s, I think, which was created to curb the influence of people like John Rockefeller, who, and if you know the history of Standard Oil, as I suspect lots of folks in this room do, got rich in significant part by cutting sweetheart deals that benefited Standard Oil versus its competitors on the railroads. And so when Congress created the ICC, it wanted to insulate it from that corrupting influence of people like Mr. Rockefeller. And so for me, the idea that I think we're pretty clearly in a new Gilded Age, that these protections are important, could not be clearer.
Can I
Please,
just
Bill, go ahead.
address Jess's question about the change in the agency? In 1935, the FTC had virtually no independent litigating authority. Its law enforcement activity consisted of going through the administrative process at the commission. That pie chart of activity has changed dramatically. The typical description that FTC leadership gives of what it does is that we are a law enforcement agency. And almost all of that law enforcement, not all, but a dramatic percentage of it, if you looked at the pie chart of what's now called Part 3 administrative adjudication and federal court adjudication, that has changed in a dramatic way, especially since 1973 when the Pipeline Act recognized on a broad basis the FTC's independent litigating authority. So if the court were to come back now, and I'm talking ultimately about the court because all of these matters and the related ones are teed up for the Supreme Court to come back in on this, they would notice a dramatic change in the role of the agency, a change that the executive branch and the Congress thought to be highly desirable. And they changed the nature of the agency from very light touch remedies, a norms creation process, to a more traditional law enforcement body. And they made that change. That was not the conception in 1914 in any way. So you can, if you simply lay out the numbers, it jumps at you. There's one quirk in the way the court discussed this in 1935 that I can't reconcile. All of those administrative cases that the FTC was bringing through its own process were originated by the commission. They didn't come from nowhere. They didn't come from third parties. Someone had to set that in motion. So what would we call the function of initiating an administrative complaint? That could be called prosecution. Now, it's prosecution and a specific challenge, but there are hundreds of those matters between 1915, when the agency opened for business, and 1935, when that's before the court. I don't know how that was briefed to the court. I don't know in oral argument whether or not the court's attention was focused to this. That is to say, are you only concerned with executive control when it is litigation in federal court, but litigation through the administrative process doesn't matter and the president doesn't have any authority? Well, that power and concept was enormous for the commission because the mandate was very elastic. So wouldn't you want to have more control over that perhaps than going through federal court? So there's a striking anomaly in the court's own treatment of this in 1935. But if you look at what the agency does today, especially since 73, compared to what it did in 35, federal court litigation, mergers, getting temporary relief, injunctive relief in consumer matters, it's indispensable. And everyone was on board with that except the Department of Justice, which has never been fond of independent litigating authority for so-called independent agencies, but everybody else was in on it. And yeah, you can point to a big difference in the pie chart of what the agency does. But if that administrative mechanism, which I think is very unfortunately been attenuated, with far too few matters going through that process in norms creation, far too few. I think the FTC has taken its eye off that ball for a long time now. But if you look at those matters, can you have a system where the ultimate adjudication authority can be removed at the pleasure of the president? I don't think that's a legitimate judicial function. So the dominoes that start to fall, if Humphreys falls, not only include maybe the Federal Reserve Board, but administrative adjudication, you take that away and you've taken away the essential reason that Congress set up the agency and the whole thing. You end up with a single administrative body.
Can I also make Bill makes a very good point about Part 3 administrative adjudication, and I will just say from my experience, one of the reasons over the course of the time I was at the FTC that focus was on federal court rather than administrative court was because of the depth and breadth and how effective the challenges to administrative litigation were. And many of them are coming from the same litigants that are also challenging the agency's ability to go into federal court because it is not an executive agency. And so those are two sides of the same coin, all of which result in what Bill aptly concludes, which is the sort of fall of the entire project of again, not just the FTC, but these other agencies.
Cases like Axon are a real headache for administrative adjudication. What's painful, though, and again, this is a chart that's easy to come together with, and you do the bar chart year by year by year, coming from, say, 1960 forward. Let's take a big round number and come forward from there. And you look at the frequency of direct filings in federal court, not just for mergers, but other mergers, and you look at the frequency of Part 3 adjudication, which can really be powerful, CEG Illumina Grail. It's a striking, for whatever reason, you can see the Supreme Court saying, wow, it doesn't seem like it matters that much to you because you're not using it for all kinds of reasons, and if it doesn't matter to you, why should it matter to us? That's a vulnerability.
I have one more question on this, and you can actually avoid it if you want. But Bill has this media study here, and so I do want to jump to the topic of the workshop. But is it possible to distinguish the Federal Reserve from the FTC? I mean, is a ruling in favor of the president having the authority to fire commissioners, can that be cabined in either to just the FTC or some set of agencies that does not include the Federal Reserve?
Look, far be it from me to doubt the ability of particular justices to engage in the kind of mental gymnastics it would require to make that distinction. If the governing principle is all governmental power is either legislative, judicial, or executive, the Federal Reserve is clearly not legislative and it is clearly not judicial, so therefore it must be executive. And if the philosophy is executive agency principal officers must be removable at will by the president, then I do not know how you make such a distinction. I doubt that some people will argue for it, but if you go back to the principles that are being argued, the philosophy that is set up, that these are the three operations of government, and if you're either one of those three, and if you are an executive, you must be removable at will, then you cannot in good faith distinguish the Federal Reserve.
Yeah, I think you have to do magic tricks to set it aside. And the main argument as a matter of policy has always been monetary policy is uniquely important. And for that reason, you can't allow the chief executive to manipulate the money supply in the face of a pending election for the purpose of re-election in the chief executive's own right or the party's candidate. You can't allow that discretion to be exercised that way, so you have to create insulation. I mean, that's not a rationale that appears in the Constitution. So it's basically saying, you basically have to say, monetary policy is so distinctively important that deserves separate treatment. I'm familiar with the huge literature that says that the FTC is an inherently dangerous institution because it has so much power. That is, its power is enormous. It's the only authority on earth that has consumer protection, competition, and data protection authority in the same package. It is the principal U.S. data protection authority. So, to the extent that interventions that distort the operation of the national economy might be seen to be important, and I'll concede, maybe monetary policy is more important, but the FTC's functions are, and by what basis do you say not important enough to deserve the protection that you give the Fed? I think the court's in a real box trying to come up, and they can come up with an explanation there, but I also wonder, on Jess's point, is the court going to sit back and say,
really my point.
your question. Maybe the court will have the same question. Is this a good moment to reinforce a broader conception of executive authority? Is this the time to do it?
Can you avoid that by focusing on the functions of the body, the actions or the powers of the body, and not this sort of tripartite judiciary, legislative, executive
Well,
branch?
I'm just citing what is in the government's briefing in our case, so I don't know, maybe you can, but they are focused on, there are three operations of government, and you're one of the three.
Okay.
I think you tow down the Fed with you. Or you can have a distinction, but it's going to be a distinction that examined in great detail is going to seem to be instrumental and not deeply principled.
Well, Myers was about 100 pages and Humphreys was about 12, so I can see a very long opinion.
They
here.
can do it. They can do it.
And anyway, look, this is in litigation. I have lots of questions. I sort of expressed my views on my own podcast once or twice about, where I think this might come out, and have general uneasiness with a executive with so much energy, but I do appreciate some energy. I do want to turn, if you're willing, to maybe what the subject of this full day is, and maybe the way to get into it is some of the commentary I've seen with respect to your purported removal from the commission has focused on politicization of antitrust and maybe consumer protection law. Part of that would be, your removal as perhaps adopting policies inconsistent with what the president wants or what the chair wants. Other commentary has suggested the focus or some focus on censorship and content moderation and political bias is an example of the politicization of the agency, or both the FTC and the Antitrust Division. Do you have broader thoughts on that? And then I will ask you if you have thoughts on the censorship question in particular.
Can we start with vocabulary? So I find that this conversation can often get muddled because people use the term politicization to mean very different things. Politicization, I think in its most pejorative term, can mean using the tools of government to go after perceived political enemies or disfavored groups, and I think that is very problematic if it is done because I don't like you, so I'm going to use the tools of government at my disposal to enforce against you. That is the kind of politicization I generally worry about. Sometimes politicization is used to mean adopting policies with which I do not agree, you do not agree politically, and I think that that's a very different animal. I have always found it a little weird that antitrust is the one area of the administration of the law where the idea of having a policy perspective and viewpoints and priorities is seen as political rather than responsible. I think any decision of how to administer the laws in some ways is inherently political in the sense that it is policy-based. It is not inherently political in that it is not inherently targeted at political enemies. And I have always thought it is appropriate and important to be transparent about what those policies are, rather than sort of pretending there's this patina of sort of objectivity in the administration of the laws that doesn't reveal the sort of underlying policy preferences. So I think politicization is a huge concern when it's a question of doing, having government operate with fear and with favor, when it should be without fear or favor. But to the extent that there are strong policy views about how the antitrust laws, for example, should be administered, that's a good thing, and we can have healthy debates about them. So
where would you put your purported firing? Into which bucket of politicization?
Well, who knows? Because on the one hand, they did not tell us why they were firing us. I think the effect is very concerning to the extent that it sent a message not only clearly to myself and Commissioner Bedoya and other Democratic members of other boards and commissions, but to the Republican members of those boards too, that if they don't do what the president says, and if they do not do potential political favors for his friends and allies, including dropping cases, settling cases, then he would remove them too, right? It doesn't say, the theory isn't you can only remove minority commissioners. So that is something about which I am deeply, deeply concerned, especially when paired with many, many well-documented reports of people currying favor with the administration through direct financial contributions and engagement. And so that's something that I really worry about. Alvaro has a lot of clearer, strong feelings about
No,
this.
they're not clear. Along the same lines. So Bilal, my main focus and concern is not on politicization, but rather corruption and the overt appearance of corruption. So I've had my differences with Chairman Ferguson. There's areas in which I agree with him, areas in which I don't. One thing which I credit him for is being consistent that he wanted to continue the lawsuit that began under Chairman Simons, that continued under Chair Khan, against Meta, the antitrust case against Meta. And so he's been pretty clear about that. Then Mark Zuckerberg donates $1 million at the inauguration, January 20th. 9 days later, Meta settles a lawsuit for $25 million from the president, $22 million of which will go to the presidential library. We are fired March 18th. On April 2nd, Mr. Zuckerberg is in the Oval Office overtly lobbying, according to the Wall Street Journal, the president to drop the case against him. And soon thereafter, Chairman Ferguson goes to the press, or is interviewed, I think, by The Verge, and says, or maybe he was saying this somewhere else, says, I will follow a lawful order to drop this lawsuit if that's what the president says. That is, I don't know what to do with that. That to me is shocking.
Wouldn't you like to have asked, sir, what did you mean by a lawful order?
I will just interject
please,
here that
yeah.
Commissioner Bedoya and I have both had occasion to say appending the adjective lawful to something does not make it so. We have seen many examples of the use of the adjective lawful to manifest lawfulness. That is not how it works.
And let me be clear. I'm not talking about Chairman Ferguson right now, so leave him out of this for a second. This is vulgar. This is a vulgar use of the American justice system. And the Oval Office meeting itself is vulgar. And that is what that's what worries me, and that's what gets under my skin.
So I want to be careful because I don't know that I and maybe others do, but I don't have any reason to think Chair Ferguson will drop a lawsuit because Zuckerberg contributed to the inauguration. I mean,
that's not what I'm saying.
I know,
That's not what I'm saying. I'm saying,
look,
let me be very
hold
clear.
on.
I'm saying he will do it because the president orders him to do so.
Yes, I get it.
Okay, because I'm not disparaging Ferguson.
I want to, right. But I do want to be careful that, if the president directs a certain law enforcement policy or economic policy with respect to competition law, consumer protection law, that seems consistent with an approach where the Commission tries to follow the economic policies or law enforcement policies of the president. And it may be of a different type. It may be of a different type than the relationship between the previous commission or the previous chair and the White House. It may be very similar to at least the charges, allegations of the relationship between the Obama administration and the tech companies. I am trying to distinguish between the president. Economic policy and even legal policy can be directed by politics, by the president, and picking enemies and awarding favors. I mean, I think that is it is a tough distinction to show, and so I just want to be very careful that look, if the president's economic policy is we don't punish American companies with breakups, it's not clear to me that that's a problem.
So I think
under your sort of acceptance of political involvement in the setting of legal or enforcement policy.
I think there is a really clear distinction between a general policy approach, like President Biden's executive order on competition, which was a widespread policy approach, or even this president's order on anti-competitive regulations, right? That's a broad policy approach. That's very different from take a particular action against or in favor of a particular company. A, that's a distinction in of itself, and B, layered with the acceptance of gifts from that company or from that company's competitors or opponents. That is a very, very different, to me, I see a bright line there.
I
We can
see-
respectfully
I can-
disagree
yeah,
about
yeah,
it, but
no,
I think that's a bright line.
I can see it being a problem, but I am unclear where that line might be drawn.
I guess I would like the discussion of political influence at some point to include the role of the Congress, where in my lifetime there have been painful instances of destructive political intervention, motivated by campaign contributions, motivated by a servile response to the demands of business enterprises affected by FTC matters, especially the FTC. And in effect, the position Congress has taken over time is that we object to intervention from one end of Pennsylvania Avenue, but we're going to do it as much as we want, and we will do it. And in a sense, you go back to the original legislative design in 1914, it's Albert Cummins who's asked, isn't there a problem giving the FTC so much authority? His answer is, I'm at peace with it because we've created the commission. If the commission strays, we can destroy it. His words. So what Cummins in some ways is saying is that the ultimate political control will come from us, and we mean to use it if we feel we must. Yes, there is going to be review through the courts, but when Congress talks of independence, it does not mean independent from it. If you sit in a confirmation hearing and they say, you recognize, don't you, that you are, the words they use, an arm, a creature, an extension of the Congress, don't you? The correct answer is yes, Senator, with great clarity. It's not to give a lecture about the dangers of political interference, especially using the decision to prosecute. If you say that, they'll say, why don't you step outside for a while and think about that and come back in? I mean, it is unmistakable that they want the prerogative to be able to intervene, and in so many painful instances, that has been driven by the underlying concern that Alvaro mentioned before about where the money's coming from, where it's coming to the committees, how it ultimately affects what they do. I think a possible byproduct of this discussion about political intervention and what it means could usefully be focused on both ends of the avenue.
Well, I'm certainly not going to defend Congress for what I hope is obvious to everyone who lives in America. But walk with me through this example. A few years ago, we had a bunch of big tech antitrust bills in Congress, right?
Yep.
And all but one pretty modest one was defeated. A little bit later, after a change in administration, a lot of those same concepts popped up at the FTC and the DOJ. No law had changed, right? But you had an agency full of not directly elected individuals, and leadership changed, and now you had
Jess,
cases
you know what
that-
it would mean to have direct election
No,
of
I'm
every
not.
civil servant?
No, I'm
or
not.
every agent,
Well, I'm
senior
not
official?
I'm not
What a
ad-
process.
I'm-
So of course they're not elected.
Right, and I wouldn't advocate that. I would say that there's a problem with that much power being kind of outsourced to these agencies when you see something very directly constitutionally rejected in Congress, those laws not passing, right? Discussed, hearings, debated, and then you see those same legal concepts appearing in agencies, months after they failed in Congress. Isn't all of this conversation come back to the question of the legitimacy of these agencies one way or the other? And you can talk about
Well, I just...
statutory or whatever,
you
but
are-
at some point it comes to those larger questions.
I think you are familiar with the same literature that I am about what might be going on in the background. That legislators, a coalition of them, tell the agencies, you keep working on these things. You have broad authority. Use your discretion to do this. They do. Business complains and comes forward with the different points of pressure that they can apply. Congress comes back to the agency and said, oh, we never meant you to do that one, but keep doing things, because that is the churn that will continue the unworthy cycle of agencies being urged to act, business responds, Congress responds to that, and you have the perpetual motion machine where, especially an agency with the FTC with a very broad mandate, an elastic mandate, is told to keep doing different things. So I'd rather not accept that very doubtful view of our legislative process, but there's a lot of behavior that's consistent with it.
Well, I actually also just reject the premise, Jess, of your question respectfully, which is that if Congress tries to pass a law, it must be to direct agencies to do something that they were otherwise unauthorized to do. It may be direct them to do something that they were otherwise unwilling to do or unfunded to do. And so I think it's a much more nuanced question. Look, Alvaro and I both worked in Congress for a while. We have firsthand knowledge, and I have seen a lot of what Bill has described that is, not your most appealing view of the operation of a parliamentary democracy, but I've also seen lots of really earnest efforts to try to encourage agency action, incentivize, facilitate agency action. Sometimes it's just about saying, look, if you operate under the current statute, you're going to run into these challenges and these roadblocks that may not make it impossible, but will make it take longer or be too expensive or be exhausting. And so we'll try to pass a bill to make it easier. So the premise that if agencies did something that Congress did either considered and rejected directing them to do or didn't explicitly direct them to do, that authority is inherently invalid, I think is not correct. It might be. There might be things that agencies do, and that is why we have courts, and agency action is checkable and has been checked and will continue to be checked in courts, because they're not just running roughshod over the legislative body or the U.S. code. They're having to operationalize it.
I think an interesting episode to examine your point, which is, I think, worth a lens that's helpful to go back and look at different episodes, is the 1970s, where Congress had before it a number of legislative measures to deconcentrate major American industries. One measure was called the Industrial Reorganization Act. Another was the Petroleum Industry Competition Act, which would have taken the leading integrated petroleum companies and disaggregate them vertically and horizontally. These were fairly bold measures that never gained the approval of both chambers in Congress. At the same time, in parallel, you had powerful legislators, where you had a very intervention-minded majority in the Senate and in the House, telling the FTC vividly in hearings that it's your bounden duty to keep working on these kinds of cases, and that helped begat the FTC's shared monopolization cases involving petroleum, cereal, big point of pressure for the AT&T case for the Justice Department. The agencies were being told by the legislature, you stay on the job, in effect saying, we can't act, but you have authority to act and go do it. I'm not always sure what I would conclude from the fact of legislative inaction when you have powerful factions, maybe not majorities, but powerful factions saying to the agency, you've got to act, or these are the kinds of things we'll do to you. And maybe it raises questions about the ultimate sustainability of a broad, elastic mandate, which is deliberately scalable, deliberately adjustable. But if you have an unvirtuous political feedback loop from either end of Pennsylvania Avenue, I don't know if it is sustainable.
There you go.
Well, let me make maybe one comment, and then maybe we can move on unless people want to respond to it. I mean, and Bill, you're I think a proponent of this. What has allowed the FTC to be effective over time, and people will define that time differently, right, is the adoption and adherence to norms by the Commission and by the folks at either end of Pennsylvania Avenue, right?
I'm borrowing from
Congress and the
the
White House.
famous political science text that is named both ends of the avenue. So
So
credit to that earlier contribution.
And of course, some of the stress appears to be on with the fact of a president who does not want to follow norms. That, you know, so let me pause there. Now, both Commissioner Slaughter and Commissioner Bedoya were still at the commission when the chairman released the request for public comment, and so no opportunity to vote on it, no opportunity, or maybe you didn't take the opportunity to issue a public comment about it. I do wonder what you think of that request for public comment, both maybe the specific questions laid out and what I would call the preamble to the specific questions. You know, do you think it's well, the request for comment seems like an appropriate use of the commission's, you know, authority, or the chairman's authority, really. But do you see a message in there, and do you think the direction that the commission or the chair is suggesting he may lead the commission, and the department, you know, may lead the antitrust division? Do you see that as an appropriate role for the commission and the antitrust division to play, or not?
Sure, yeah. Look, I think there's three questions here. There is the facts, there's the law, and there's priorities. So, speaking for myself, I take seriously and valid some of the claims on the right and the left to censorship on social media. And when social media is the main square in which people express themselves, especially young people, but pretty much everyone, I would say nowadays, they have something to say, they go online and say it. I understand why that gets under people's skin. I understand why they see it as really an affront. And so I take those concerns seriously. That is one question. The separate question of whether there has been a law violation under the consumer or the antitrust laws is a totally separate question to that first question. It is a fact and law specific question. It's just lining up. Do we have the facts for this claim? Do we have the facts for that claim? Is there a world where a social media platform says, we shall not do X, you know, on their policy, and then they just flat out do X, where it's just a simple deception case, right? There might be, right? Is there an antitrust case? I don't know. I have not seen that case made, yeah, I would need to see all the memos. I would need to see everything, the whole record, in order to make that legal finding. But finally, there is the entirely separate and I think much clearer matter of prioritization, which is you have a president who, on his first day in office, says that the cost of living in this country is an emergency. You have, I think it was last night, CBS Evening News highlighted new research showing that 3 in 5 families don't earn enough to make a basic living. This is in the wealthiest country on earth. You have a commission with elastic powers, exactly as Bill described it, with this broad mandate that can do any number of things to help people in this economy. You know, my main concern is how can this be the top priority or a top priority when you have this degree of suffering in this country? So again, I take seriously these concerns. I understand why people are furious on both sides. The legal question is a wholly separate question. But for me, the priorities, it's hard to see how this is, given what people are going through right now, how this is a priority.
I will echo everything Alvaro just said very well and add 2 things. I think the interesting question on competition and speech isn't about whether it's illegal for companies to censor. It goes to how do we consider the market power of companies that have the ability to control speech, and what does control of speech tell us about their market power? And then you have to interject those questions into exactly what Alvaro said: the facts, the law. What are the actual elements of an actual case? That's much more important than sort of hand wavy, like this feels bad. competitively. So I think that's an interesting question. I will also tell you, and maybe a little bit more pointedly, I have a really hard time squaring this broad concern about censorship with the fact that one of the first all-staff emails that went to the FTC under Chairman Ferguson's leadership, and one of the first EOs that came out of this administration talked about dangerous ideologies of wokeism that needed to be stamped out and avoided, and there were words that are no longer being allowed to be used by government agencies. The First Amendment does not talk about commercial speech. It talks about political speech, and it talks about the government's control of speech. And so I think where we have examples of the government directly controlling speech, it is very hard to get exercised about companies possibly controlling speech in a much less direct and explicit way. So that's something that I have a really, really hard time reconciling in the context of this conversation. And I just think a really important note to make, and just bringing us back to the question of why our removals matter, why Humphrey's executor matters. When Chairman Simons was the head of the FTC, I think one of the most admirable things he did was, and there were many, to be clear, very many admirable things that he did, and I learned a lot from him and really enjoyed working with him, and enjoy seeing so many colleagues who also worked with him here. He said he did not think that the FTC had the authority to police speech. And he said he would not do it because he did not think it was an appropriate use of the agency's authority, which is a reflection of the fact that we keep losing sight of, that officers of the government take an oath not of loyalty to the president, but to the Constitution and to the laws of the United States. And I take that oath very seriously. I know Commissioner Bedoya takes that oath very seriously. And in order to appropriately execute that oath, you have to be able to say if something is not, suggested or directed action is not consistent with those things.
I'll just note a few things. I think every employee of the U.S. government takes that oath.
Yes, that's true. I've
and-
taken it
and-
multiple
and-
times.
And look, my admiration for Joe is, probably very, very high.
I join you.
And in part for just being willing to be straight, I think, with the president, and just saying I can't do it, rather than putting him off and hoping he would forget it.
He was a superb bureau director, too.
Yeah.
Yeah.
But Alvaro, I wanted to touch a little bit on your point about priorities.
Sure.
I mean, I can understand the idea that, the cost of living, the cost of products is important. The ability
And how
to
much
earn
people make. Yeah,
a
exactly.
wage is important. But of course, the Constitution treats speech differently by enshrining certain rights with respect to speech in the Constitution.
Fine.
And so I think, I think it's reasonable for an agency official to focus on speech rights of Americans. Now, I'm not saying there's a legal basis for this, or even a factual basis for these concerns, but I think my position is sort of a minority position, but I think speech rights are important to people, and we shouldn't rank, different rights, different needs, different, differently, and rank one over the other, right?
Yeah, I'm not. Yeah, I think it's. Chairman Ferguson wants to issue a request for comments on censure. I don't have a problem with that. And I think I was still a commissioner when you did that. As you said, I didn't come out and say, this is silly. I didn't do that.
To be clear, we didn't get any advance notice that it
Yeah,
was
no, we
happening.
learned about it on Twitter.
But
And so, neither here nor there. But look, I mean, you've got people, when you get a cancer diagnosis, one of the first things you do in this country is set up a GoFundMe to plead with your friends and family for money. You've got people who buy fish antibiotics to treat their infections because they don't have insurance and can't pay full freight at the doctor. I mean, I think that should be the top priority.
I also don't think Alvaro's saying it's
no,
inappropriate or illegal to set this as a priority. He's just saying it's a bad idea. That in the universe of things that people care about, right?
Well, I don't even know if it's. I mean,
Well,
what I'm saying is, right now, I think for me it's very clear the president got elected because people thought he was their best bet to pay the rent. I think that is why Donald Trump is again the president of the United States. Given that, given the emergency, his words, I agree, we're facing on cost of living. I think that should be a top priority. Is there a world where the FTC, let's say, again, let's go to just that simple deception case. Let's say a company says, we shall not take down political posts. And then it just goes out and systematically deletes all political posts. Is there a case to be made? Probably there is. The First Amendment would probably weigh in there somewhere. I don't know. But so I'm not even saying it's a bad idea per se. I just don't see how this can be a top enforcement priority.
I meant that you thought it was a bad idea to make it a top enforcement
priority.
Sorry,
I cut you off,
not that doing it. Yeah, no, that what you
Yeah.
were saying, and this is the kind of political debate I'm actually really happy to engage, and I think is important to have. How do we set priorities? What are the right priorities for an agency with limited resources and a fixed budget? I actually always found really hard when people asked me what I thought the priorities of the FTC should be, because I think so much of the work that it does is really important, and it's difficult to pick and choose between it and amongst it. So what I understood you to be saying isn't, there may be questions about the validity of the law and the exercise of it, the application of the law to these fact patterns and how it's exercised, but just that it is not a good priority from your perspective, which I share, for the use of the limited resources of the agency. Some of these questions are very different if we're imagining a universe of unlimited resources that didn't begin to exist before this administration, and certainly doesn't exist
Has
now.
anybody ever imagined such a universe?
I try to as a thought exercise sometimes.
When
I'm
agencies
unfamiliar
speak
with
of
it.
limited resources, I think, name me one public institution in the U.S. that has no cap on what it spends.
Yes, but if you look at, everybody
we all-
says this about the FTC, it punches above its weight in terms of the resources that are directed to it, its staffing, and especially as I've been looking at cuts from other agencies and thinking about how those kinds of proportions apply at the FTC. It is clearly under-resourced to begin with.
I think it's a enormously useful focus for discussion, much more transparency and debate about how an agency such as the FTC decides what to do and what it does, and to put that into clearer public view. If the question were posed, we'll give you $10 million more, what are you going to spend them on? Because you've got three major functions that you can perform. What will they be? What are you going to invest in? That's a debate worth having. It's just interesting to me that variants of the topic that Andrew Ferguson has singled out for discussion, not precisely so, have come up a lot in the FTC's history. The FTC has had a long recurring concern about this kind of issue. John Leibowitz had a set of proceedings on the future of the news and newspapers because he was concerned about what was happening. I'm going to give you a quote from, I won't tell you when, but this is a quote from an FTC chair talking about a symposium that the agency convened to look at the question of media concentration. And here are his comments. The symposium has been convened by an agency concerned with competition policy because our competition and free speech laws and policies flow together in that broad confluence of American tradition which harbors a deep distrust of excessive concentration of power, distrust of the suppression of the diversity or the independence of economic and political entities in our society. That's Mike Burchuk in 1978. The FTC, in the midst of crushing concerns about inflation, cost of living, and a host of other things, Mike said this was worth spending some time on. So I don't have a view about what the exact rank order of specific priorities would be, but I just mentioned that a lot of FTC chairs over time have thought this was important. I would feel much better about launching this one if the current FTC team that's working on this knew about this document. And it's 2 volumes. And had some idea, had read the proceedings of John's proceedings on the news. There's a history here and a weakness of an agency, especially one that's trying to make the case for its continuation and its protection, is its inability to draw effectively on what it's done before. The FTC, this document, these proceedings, lots of the very same issues and anxieties expressed during the first 2 panels about what to do, how to do it. Are we just going to publish a report and a document? That's all they did. Are we going to bring a case? Are we going to pursue rules? What about all the constraints that the first 2 panels discussed very carefully?
So Bill, at the time, what were the concerns?
There are no new themes, only recycled material.
So what were the concerns at the time?
That you are going to have a narrowing in the number of conduits for information that citizens would rely on to make basic decisions about the governance of their country. It didn't say that there was filtering of view A, B, or C, or different perspectives. It didn't say that, but it said as you shrink the number of outlets, you're going to have, Mike's words here, less diversity in the perspectives that individuals can choose from. And this is a theme that John's hearings on newspapers brought up. And by the way, I do remember as John was launching, I was finishing my time at the FTC, John thought the newspapers issue was very important for a whole host of reasons. He wasn't wrong. But a lot of people said, why on earth are you doing something that is never going to go anywhere? Why are you going to convene proceedings on that? It reminds me, Mike Perchak's comment about launching this one was, and this is a quote from another commentator, he speaks of a novice lion tamer stepping into the ring with a bunch of experienced lions who say, welcome to a venture that promises problematic rewards and immoderate risks. This was a question posed to John about it, but he said, this is an important issue. It's about speech, and we're losing the number of channels of information through which people can get news about what to do.
This is before government officials weren't allowed to use the word diversity. The thing that I think is an interesting thread here is everybody cares about speech, right? Even the people who think the FTC has no business talking about it say that because they care about speech. That is not a one-off concern, and I think one question, and you just raised it about John's hearings, is what is the goal of an agency action? What is its purpose? What is it going to achieve? And I think one of the questions that's been raised today or in recent times is, and actually was raised with the Biden administration too, again in a sort of ironic way, is are you trying to bully companies into how they control speech? Are you trying to use the power of government to exercise control over speech, directly or indirectly? I think there's actually a very good argument for saying the FTC is going to use its study authorities to provide transparency about an area where it does not have law enforcement authority, or where the rules of the United States do not prohibit particular conduct. I think that's a great benefit that the FTC provides again and again and again. And I love our study authority, and I know Bilal shares that view, sort of, sometimes. So I think that is important. And the final point I'll make on this is one of the value of having minority commissioners, or a diversity of viewpoints among commissioners, if you will, is when something comes up for a commission vote, to have that debate about whether it's the greatest and best use of commission resources aired publicly and transparently, and have whoever's purporting to do something have to advocate why it is good use of resources and answer questions about why not. That transparency and accountability, I think, really helps foster public debate and discussion. I don't have a problem with an RFI going out without a vote. That is allowed. But if the commission were ultimately to take some sort of substantive action, that would require a vote. And the ability to say, at this moment, I don't think that's a great use of our resources, even if I think this is an important issue, or I think it's so important an issue that it is worth those resources. That's a good debate to have aired in the public, and you don't necessarily get that debate if commissioners are afraid of being fired for having a perspective that differs from the president.
So I think we're running up against time now, but I would ask, notwithstanding, and look, I am supportive of the study function. I
And
sometimes.
I think as the earlier panels were saying, there are a menu of possibilities here. You convene proceedings, and you have the proceedings as a forum. You issue a report. You bring a case. There's a range of possibilities here. I think it's for the commission leadership to define what they're going to do. I think they paint themselves into a corner if at the outset of the process you say you can measure us by our doing X, and if you can't deliver X, you've got a problem. And in this whole area, maybe one thing before we close to mention, a reason many of us were very wary about this is, do you want to put the commission in the position of ultimately refereeing the accuracy of speech and political debates? Do you want the commission to have to handle that? This is quicksand, I think. Ultimately, it can be, into which an agency goes to die.
So that sort of was leading, or leads to what I was going to ask, which is the FTC with this request for public comment, and I think similar things that the Antitrust Division or the DOJ is doing, sort of in a fact-collecting mode. I think what I would have liked to see, and what I hope the function of this workshop, two-day workshop, is to think about the legal constraints on the agency before they upend companies and others' either hopes or fears, because it doesn't seem to me that there's very much that the agency can do in this space, even with a reporting function, right? Because it's not clear to me that the Congress can do anything with a report that says, yeah, people are picking and choosing who they platform, right? I mean, it does seem to raise First Amendment issues all up and down sort of the chain of government.
Wait, can I provocatively push back on that a little bit? Because I think, right now what we have in this concept of media censorship is a lot of allegations, maybe some substantiation, but when a government agency puts its imprimatur on a topic by publishing a report and saying, this is what our research has found, this is what we have concluded, that actually does change the conversation. Maybe it doesn't change what Congress can do, but it may change the behavior of the companies at issue. I think it does have an effect on the public discourse that is substantive and real, and I say that without any opinion about whether I'd agree with the conclusions, whether I think that they're valid substantively or legally, but I do think, I think your report on non-reportable acquisitions was a really valuable contribution to public discourse about how big companies got so big. And that was really important, even if it didn't change the laws or change enforcement action. So I think that there can be an effect there. I don't disagree with you about the importance of understanding the fundamental law to begin with, but I guess what I'm saying is I think that the reporting function has value in and of itself.
So I agree with that in many respects, but then I'd ask you to distinguish between, sort of a report at the end of the process and what might have been referred to as the bullying at the front of the process. I mean, it is clear that the president and some officials in the government believe some level of censorship is occurring, and that level is inappropriate. A report may or may not say the same thing, but it's the same point of getting into the discussion, affecting the conversation, and maybe effectuating change without, in fact, a law. So the fact that the FTC chair and the Antitrust Division head and the president and other officials are concerned about this and maybe bullying companies to change policy strikes me as potentially more efficient than a long investigation and report. Look, I'm not supportive of that. I think they should leave this space alone, and companies should adhere to the law and, follow norms. But, my sense is the participation of the agency in this process is a problem, whether it's a long, thought-out, thoughtful process, or, I wouldn't say off-the-cuff remarks, but just initial remarks expressing concern about it. I would prefer, the reason I suggested the agency sort of go out look, it's a request for comment can be a factual request, but it should also be a request for, okay, what are the legal theories that work here, right?
Sure.
Inform us of the problems. I mean, there is not a lot of First Amendment expertise at the FTC and the Antitrust Division. I say that not as a slander or slam on them. And I would have liked to see some questions about what authority do we have, how would we use it, how would we create a remedy? And that, I think, is sort of the bigger loss here, right? Which is that maybe they are just closed to hearing that at this stage. And, you know, that's, I don't know if that's something to respond to, but that's my disappointment here.
Well, I think during our shared time at the agency in the aughts, we spent a fair amount of time on the First Amendment issues and the use of the right tool. You remember Tim Muris gave a speech to a group of media organizations and said, we are struck at how willingly you take advertisements that are patently false on their face, where people are being offered miracle cures for serious diseases, weight loss remedies that simply can't be believed, no science behind them, and you take the money and print them, and you shouldn't do that. And this was exhortation to them to look for specific types of claims that are patently unbelievable and shouldn't be run in media organizations. Now Tim mentioned, you know, what do we do about it if we see you doing this? Well, there's not a whole lot we can do, but this is something you shouldn't be doing. That was exhortation as a way of saying, here's our understanding of the science behind these claims. It is fraudulent in the extreme. It is dangerous if people rely on it, and you take the money and print it. Why are you doing that? There's the do not call rule. There was a powerful First Amendment question there for us to address about the appropriate role of the government in filtering speech of certain types. I mean, Bill, just because you mentioned do not call, would you distinguish in, you know, the newspaper example and do not call between commercial and non-commercial speech, right? I mean, because I think that was relevant at the time. It was, but there was a wonderful 1970 Supreme Court decision that said that the Postal Service could indeed be asked by a user to filter the delivery of certain types of mail. But there was a subsequent flow of Supreme Court jurisprudence that had elevated the protection that was being given to commercial speech. And the real question was what vision of the First Amendment would ultimately prevail. The Court of Appeals ultimately liked ours. The Supreme Court didn't come in on it. But there was, it showed a couple of things. One is a continued engagement with some of these issues at the time, but framing the kinds of questions that would be useful to address if you're going to do if you're going to do proceedings on this, and look at this.
Okay. We just have a few minutes. I don't know if there's other thoughts people would like to get out. I mean, I appreciate you coming and discussing this. I have some conflicted views on what the president's firing of either you two personally or commissioners generally.
I hope you don't have conflicted views about us personally, Bilal.
No. Well,
I'm
I
just
think
no.
In front of Bilal and say, personally, I'm very sorry you're going through this.
We've never met, really.
Well,
I feel like you got to give me a chance, man.
Sorry, I'm just teasing.
No, look, I think this is not personal to you, and I'm sympathetic, or I understand the argument about dissenting voices, maybe improving the ultimate product. I also think they can slow action, and somewhere in this process, I said I like energy in the executive. I think even Judge Wilkinson's wonderful opinion recently suggests there is a reason that we like to see energy in the executive. I believe that holds true for any governing official, and of course, dissenting commissioner, and it's not dissenting commissioners can slow things down. So I understand the effort to move quickly, and so that's why I have some conflict, right? You add dissenting minority commissioners, however you want to do it, add value, right? A multi-member body can also slow things
So
down.
I actually think it's not just minority commissioners. I actually think your objection is to a multi-member body, because my experience both at the FTC and in other places is sometimes the biggest debate, discussion, and slowing happens among members of a majority rather than between
I agree
parties.
with you.
And again, I think that there is a benefit. It's a feature and a bug.
The deeper FTC vulnerability is that there's precious little professional diversification on the board. There are lawyers. There've been a handful of lawyers, non-lawyers in the history of the agency. Not a single computer scientist, not an engineer, none of the kinds of people that, well, Congress isn't talking about computer scientists, but a real vulnerability is that you look at the monochromatic backgrounds of so many people on the board, and there've been 4 economists on the board in 110 years. I mean, that wasn't the original design. So that's not the professional diversification Congress was thinking about. That's a real vulnerability. I think in many ways, the agency is seeking a renewal of its status. It's seeking a continuation, saying, here's our potential to realize a certain vision, and at some point someone can say, you've had 110 years to realize the potential. How are you delivering in practice?
Okay.
Alvaro and I are both on childcare duty
Okay.
right now.
No,
with
thank you.
employee
Look, thank you.
spouses,
Thank you very
so-
much.
The service we
Yes.
provide
very
in this
much.
limbo.
Yes,
Look,
exactly. It doesn't
again-
pay very well.
Again, I think everyone appreciates you coming, and I think in the end, I wish you luck in your lawsuit. I do.
I appreciate that enthusiasm.
We think we thank you, Bilal. We think we thank you.
That's how you win the moderator.
It's I see the value, and look, you may be right that what I object to is a multi-member commission, but I think there is some. I think there's some reason to be concerned about what happens if you lose with the rest of the government.
Yes, we agree. Well, thank you for having us.
Thank you for having us. Yes, please. Thank you.
Thanks, Paul.
Yeah, thank you. We're back. This panel is on competition law and analyzing potential claims with respect to FTC DOJ involvement in content moderation, bias, censorship claims, or theories of harm. So with me, again in order of seating, Dan Gilman, who is with ICLE now, right? You're a senior fellow of some type?
Senior scholar.
Senior scholar.
Incidentally, the oldest, but that's
Anyway, so next to Dan, we have Doug Melamed. Doug has many things to his name. Maybe most important, acting Assistant Attorney General for the Antitrust Division late in the Clinton administration, and prior to that was Principal Deputy Assistant Attorney General for Antitrust. He was General Counsel at Intel. I think now is a professor of the practice at Stanford Law School. What's that?
It's close. My title's changed.
Oh, okay. His title's changed. We'll get that out during the discussion. And Alden Abbott, presently at Mercatus, previously, or most previously, General Counsel of the Federal Trade Commission. I think we'll end up linking to everyone's bios, and you can, read up on that if you like. So, look, I think again, we're going to focus on we're going to try to focus not on some of the questions we've already talked about today, but how would you apply concerns about censorship, political bias, content moderation in the context of an antitrust case, an antitrust claim? Or is it possible? Does it make sense? What would they need to look like? Can they be remedied? And so maybe the way we'll start, because this is a little bit of a new, I've been practicing near 30 years. Others here have practiced longer than me. I think for me, and I think true for most of us, the overlap between antitrust law and First Amendment claims, or I shouldn't say claims of censorship, bias, choice of content is sort of new, notwithstanding Bill Kovacic's mention that the FTC has been thinking about this type of issue for some time. So to maybe help set the stage, we have a clip from the current chair of the FTC, Andrew Ferguson, just to identify why this has become an issue that we're thinking about. So I'll ask them, the group, to play that.
I often hear the criticism that what I'm describing is not a, quote, traditional concern of antitrust, end quote. Yes, it is. Yes, it is. Of course it is. If you wield market power to injure consumers, that is a traditional concern of antitrust. And antitrust is not just limited to price and output. And I think drying up access to ideas is an injury to consumers that the antitrust laws care about. And if the wielding of market power unlawfully makes that possible, that is what the FTC Act is for.
So that's another
Position. I don't know. Do we have that second clip? Do we want to use that too, or? Okay, we'll play a second clip. Maybe more of the same, maybe slightly different.
Practice censorship, they inflict harm not just on those users whose opinions are excluded altogether or limited in dissemination, but also on any user who is attracted to the platform because it facilitates a genuine marketplace of ideas. To be sure, antitrust law cares about the mistreatment of the speaker, but it is no less concerned with the injury inflicted on the user who wishes to ingest ideas on a platform. If part of the attractiveness of a social media platform is that it facilitates a genuine marketplace of ideas, a highly concentrated, less competitive market will make it easier for social media companies to degrade the quality of their product through censorship without facing any competitive consequences. If a social media platform can
I'm against censorship generally, but maybe not totally. I mean, just to state my priors and bias. So in that sense, you know, the concern is reasonable. But I think we want to talk about it in the context of application of the law to specific facts. And at least as an adjunct professor, I like to write up hypotheticals. I hope we have not posted them, but I'm gonna read one because I just think it's sort of helpful to start the discussion. And we're going to start in the context of a merger, which I think highlights some of the difficulties of pursuing claims based on foreclosing speech or access to speaking or speech opportunities. So just imagine media company A, which has a news program, many local and national newspapers, both online and a hard copy, and publications on, for example, sports, lifestyle and culture issues, history and current events, proposes to acquire media company B, which has a similar product portfolio. Programs and publications are differentiated, different editorial spin, different writers, but advertisers consider them to be an effective way to reach an overlapping set of eyes and ears. There are many media companies offering similar but differentiated publications with somewhat overlapping readership. So we'll define the relevant antitrust market as a market for national newspapers, markets for local newspapers, general sports magazines, general lifestyle and culture magazines, et cetera, each with a digital and offline form. I mean, the relevant market I think doesn't matter, but I just wanted to define something so nobody focuses on that. 2 years ago, media company A decided it would not allow comments, whether video comments, oral comments, written comments, in reaction to its stories or coverage, because the board of company A found many of the comments objectionable, although each of the board members found different comments objectionable and had different reasons, right? Some comments were perceived as raising safety concerns, others advanced positions incompatible with the board members' personal beliefs, others advanced objective falsehoods, others were believed to stoke religious and cultural disharmony, others were personally cruel to figures in the news, others expounded positions that board members had no desire to be associated with. Now, there's no evidence, at least in this hypothetical, no evidence of an economic motive to the adoption of this policy. Media company B allows for comments and does not in any way moderate or police the comments. It expends no costs on comments and considers itself an online town square. The ideas expressed in the comments posted to, on their platforms are diverse and not monolithic. After the merger, media company A will operate media company B as a wholly owned subsidiary, will not change the brand or change the editorial direction of the company, but it will extend to media company B its no comment policy. Media company A is public about this proposed change, and the DOJ or FTC is flooded with expressions of harm from readers and writers and organizations that believe this is a restriction on the free expression of ideas, both their own and others, and their ability to easily access opinions and information on issues of interest and even importance to themselves and the nation. The Antitrust Agency, whichever one is reviewing this hypothetical merger, understands that media company B was a relatively unique town square, with 1/5 of the U.S. population having read or drafted at least one comment on a media company B platform in the past year. The Federal Antitrust Agency believes that post-merger plan of media company A to move media company B to a no comments policy will lead to a significant restriction in the creation, dissemination, and consumption of information and ideas, and generally harm free expression. This harm is the effect of media company A imposing its no comments policy on media company B post-merger. DOJ can show this harm, notwithstanding there are other means by which ideas are disseminated and received and even created. So, simple question, I think. Maybe not. Can DOJ or the FTC successfully challenge this transaction under either the Clayton Act or the Sherman Act or the FTC Act, right, as any one of a, substantial lessening of competition, agreement and restraint of trade, or an unfair method of competition. So the first thing I'd ask the panel is, does an antitrust challenge to the merger, right, or the agreement to merge, meet the in-commerce or affecting commerce requirements of Clayton Act Section 7, Sherman Act Section 1, or FTC Section 5, right? I mean, this is a core requirement of an antitrust challenge, or challenge under any of those laws. Earlier this morning, look, I thought this might be an easy question, since I almost never dealt with it in private practice. But earlier this morning, I heard some commentary that speech, restrictions on speech, might not meet the commerce requirement. So I may have totally misunderstood that, and I didn't get a chance to ask the panelists. So, is the commerce requirement met?
Look, first I want to thank Bilal. I mean, there's been a lot of stuff about antitrust and labor in recent years, and I want to thank Bilal for inviting me as a representative of labor. I mean, we've had all this like agency management up here, commissioners, chairs, and stuff. I was a mere staffer for 16 years, and anyway, so thanks, solidarity. Two.
Power to the people.
Yeah. Or at least a person. Look, as a recovering academic, I appreciate the detail, if not the duration, of the hypothetical. But I want to push back a little bit to the extent Bilal will let me against the setup and, in a sense, hate the game, not the player. I mean, I don't. We're going to do rule of reason analysis on a law exam, hypothetical paragraph or two. Are we going to? I mean, is it in commerce? I mean, I think it's in commerce. I mean, media mergers are scrutinized in commerce. They take place in. I mean, there's publicly traded companies, stuff trades hands. Is the conduct? I mean, is it censorship? I mean, Supreme Court jurisprudence, appellate jurisprudence on First Amendment grounds focuses expressly on government censorship, and at least in some cases, not so long ago, Moody v. NetChoice and so forth, reminds us that it wants to focus on government censorship, not private censorship, if you want to call it censorship. Is the speech in commerce? I don't know enough from the description. The question, I think it's probably the operation of the firms is in commerce. It doesn't settle the question whether it's subject to first-tier First Amendment protection or second-tier. It doesn't settle the question whether the speech is commercial speech under commercial speech jurisprudence, right? Not all speech by commercial actors is commercial speech. And one of the reasons I want to push back against the hypothetical is I don't know if my fellow panelists, they're really smart people. I know Doug a little bit and Alden quite well. I think in abstract, could the speech be commercial activity? And in commerce, in abstract, you bet. Do media mergers get scrutinized? Of course. I don't know that the FTC has ever scrutinized a newspaper merger, but that's another thing, and there's the sort of common carrier extent in some areas. But I think that, does antitrust care about non-price competition? Absolutely. Are there facts and circumstances under which the FTC or the DOJ could bring a good case and block a merger based on these kinds of editorial decisions? maybe I think they're probably thin on the ground well before we get to First Amendment questions.
Look, I'll ask Doug and Alden to respond, but look, we played that clip because Chairman Ferguson is saying that speech is a variable that he believes the Commission and the antitrust laws take account of when thinking about the scope and the reach of the antitrust laws, what it can reach, and I guess what it can remedy. So, I put it in the context of a merger because I thought it was a little bit easier, but we have other changes. So, one question is it for the in-commerce or affecting commerce requirement, right? Do you look to the parties, operations, or would you look to where the effect is occurring, right, on speech, right? So,
let me.
Yes, please.
I think there's no question. The way you phrased the question initially was, is the in-commerce requirement satisfied so that the FTC might apply the antitrust laws to the merger? The answer to that question is yes. In fact, I think it's a trivial question. I think it's a trivial question because I think Chairman Ferguson's remarks, like others I've read from AAG Slater, reflect a fundamental and I think very telling misunderstanding of the antitrust laws. Now it's telling because let's be clear about what's going on here. This is not an antitrust problem at its core. This is part of the Project 2025 instruction manual that said go after the tech platforms, use antitrust, use whatever you can, because we don't like content moderation, and that in turn is obviously a part of the broad effort of the administration to control speech in this country by silencing dissenting voices and magnifying their own. And they do it by intimidating television networks, Bezos, and now they're moving on to the tech platforms. That's what's going on. It doesn't mean they can't come up with an antitrust theory, but they're weaponizing antitrust to achieve a very different political objective. Now, so that drives them to make silly statements, and I suspect even Ferguson knows it's silly. Imagine someone had said, Netflix raised its price. That's illegal under the antitrust laws. That's an antitrust problem we have to deal with. Raising your price, exploiting your monopoly power is not an antitrust problem. The antitrust laws are crystal clear. It's crystal clear in the statute. All three of the key statutes prohibit only the following: certain kinds of conduct that injure competition. And injuring competition means more than a de minimis insult to a rival, but it means enough of a harm to the competitive process that the discipline of rivals upon one another is diminished materially. In other words, market power is increased. Every antitrust violation is about anti-competitive conduct that increases market power. It is not about how the market power is exploited. So if the merger creates no market power because there are 50 of these media companies, and one of them says to the acquiring firm, like a car company says, I don't want to do blue cars, let's all do red cars, and they say, I don't want to have a certain kind of speech, I might call it a lie, others might call it a difference of opinion on my platform, we'd say there's no antitrust problem there. And you can't use the antitrust laws to regulate speech, because at that point, you're making a content-based regulation of speech, and that raises obvious First Amendment questions. And whether you call it in-commerce or not, I don't know. I don't know about the in-commerce under the First Amendment and all that. On the other hand, if the merger creates market power, because A and B are really big, and they've increased market power, the merger is illegal, whether they change the moderation policy or not. Now, to be sure, evidence of changing the policy, if it really did seem to diminish the value of company B's product, could be looked at. By the way, it might not. It might make the product more valuable for obvious reasons. People choose products for different reasons. It's like blue cars and red cars. But if it can be shown to diminish the value of the product to consumers and therefore the value of the product to company B, you could look at that and you could say, well, that's evidence that they think they have market power, which in turn can help the fact finder conclude that this merger is about creating market power. But that's an evidentiary matter. It is not material to the antitrust offense.
Alden, I'll let you jump in, of course, but let me reframe the question a little bit. I had originally thought I would suggest that the DOJ or FTC would be able to show both a price effect and a non-price effect, with the non-price effect being the curtailment of the comment policy of media company B, and was basically going to ask, can they, would they be able to withstand a challenge on both the price competition claim and the non-price competition claim? Price competition claim, sort of factual, but we assume it. So, what I'm trying to get at is this really a variable that antitrust cares about, or that antitrust can reach, right? And so I'll change the hypothetical a little bit for Alden's benefit. He can ignore it or not. But okay, let's say there were 5 or 6 firms, media companies, and the larger ones all would have liked to move to a no comment policy because they feel the comments are just offensive, right? And maybe even cause harm. But the 6th firm, what I call media company B, for whatever reasons, enjoys a comments policy and would deviate, would continue to offer comments even if the larger firms did not. So I would treat media company B as a maverick, or consider media company B a maverick, and media company A buys media company B just to basically shut down the comments function. Well, again, this is harm that the chairman has identified as within the scope of something he believes that the commission not only should take account of, but that it can take account of. And that's what I'm sort of trying to get at, right? Can they take account of this under the antitrust laws? And if not, why not? And if so, why? Where do all these other defenses fail? So, go ahead, Lincoln. You can answer whatever question you want.
Interesting. Well, what you're positing is some diminution in sort of quality competition. And the key dimension of quality competition, which existed, even though there was only that Maverick was engaging in it, somehow is being eliminated after the fact. Now, I guess there's a question, sort of a subsidiary question, or maybe not subsidiary, are there effects on advertising markets? Are there effects and other effects that would affect other aspects of downstream or upstream input suppliers or buyers of advertising space? Or are there other effects on consumers? If you assume that away, I guess there's a question it seems to me that a real problem here is that if this is a matter, there is a broad First Amendment right of any platform, to engage in its, curate a platform as it desires. So I think it takes it out of the purely commercial context. Whatever, and you haven't posited in any other specific monetizable or implicitly monetizable commercial harm. It seems to me that there's a broad First Amendment right of the company after the fact to do this. Was this known at the time of the merger? One question you might ask, going in, was it clear that they were going to do that? It wasn't clear from the hypothetical. Or did they shut down the platform after the merger? What about potential entrants? Are there any other, there's lots of room in cyberspace. Are there other potential companies that could enter and provide the services that we previously supplied? If so, there may not be any real harm to competition over quality in that sense. Are there any third parties, some other adjacent areas who might enter and give that? So those are some of the questions you might ask. But I think qualitatively this is different because again, there's a broad right, I think, of unilateral right of a platform. It's not a unilateral case though to operate, to offer its speech to third parties or to members of the public or not, and to curate. And I think that's clear from case law. And I think trying to make out a commercial harm here or harm to consumer welfare is, I can't. Is a very sort of strange situation. I think you have to go back to old cases. And I don't know if it's a good analogy. Think of the Associated Press case, 1945. Think about the Associated, where sort of a joint agreement affects entry, affects the ability to express a point of view. I think that was a joint venture case. So I guess I'm not really answering your question, but I think I think it might be said that this is a sort of harm that the consumer welfare standard or the antitrust laws as understood under consumer welfare standard cannot reach. If there's some other harm, that other aspects of quality, other than speech curation, surely you can reach that. And I think you need to know again more about the potential for entry. And potential that, in some sense, this is, I'm thinking about differentiated product. It's often, think of the paradigm of cereal company A by cereal company B, and eliminates one of the brands. And well, generally speaking, you wouldn't be concerned about that unless you believe in variety competition. So again, I think I'm sort of ducking the question here, but I doubt that this is really a viable antitrust theory.
So, I mean, I don't know that you're ducking the question. Maybe this follows up on both Doug and Alden, but I think it's somewhat responsive to Bilal's follow-up question. I don't want to marginalize the First Amendment issues here. I think they're important. I think the court was right in Moody. I think First Amendment concerns trump a lot of possible interventions here. But I also think that, even if we set them aside, we can make the general observation that non-price competition matters and can be a factor in both merger and conduct analysis, and yet appreciate why it is that pure quality cases are few and far between, right? There are circumstances in which we might think, for instance, the Phoebe Putney case, which was largely decided at the court on state action grounds, not on antitrust grounds. Was there a serious concern that within 2 years there'd be considerable price increases? Well, I mean, not if the major health plan and health plan sponsor has cut a deal on price for 2 or 3 or 5 years. It doesn't mean nobody's going to suffer on price, and not if we have some clear, consistent, and consensus metrics for hospital quality, right? What's the rate of post-op infection, surgical mortality, post-surgical mortality, things like this. If they all go up, that's bad. And so there are circumstances under which we might think qualitative aspects of service or good would decline, but at least for a time we would not see price effects, we would not see output effects, and we would not see necessarily even other non-price effects. But I'm looking at these products in front of me. I got a phone, I got a watch, I got a can of Diet Coke, my favorite diet soda, and so thank you. Thank you for having arugula, not mom's arugula, but still. Does anybody think there's one qualitative aspect to this? I mean, it's a little nuts to say, oh, the mean platform. I mean, I like Todd Zywicki. He's a Dartmouth guy, go green. He's done good stuff on finance and public choice. He's a bright guy. Did Facebook diminish the quality of its product when they declined to publish his views on COVID? Not so sure. Does everyone prefer the platform if he gets to view them there? Some people prefer one moderation policy to another moderation policy. But I think just from a competition standpoint, you know, it's like the Passover question. Why is this night different from all other nights? Why? If they really had, if this was really a merger to market power to exploit market power, what are the conditions under which, guess what? Now they've got market power in an extreme case. Maybe now they have monopoly power. Why? Right.
Well,
they're not changing the
stop.
price. They're not changing any other dimension of service. And in fact, output goes up.
Look, the answer to that, the answer to that is this. Market power, by definition, is the power profitably to increase price or take other action contrary to the interests of trading partners. There's loads of antitrust law, whether it's mergers reviewed ex ante or it's Supreme Court and Standard Oil and on and on and on, that say we don't have to tell you how this illegally obtained market power is going to be exercised, because given the fact that that's what market power is, we can confidently predict that a profit-seeking corporation will exercise it to the detriment of trading powers one way or another. So why does it matter?
Well, I think what matters a little bit here is, I think you're all treating speech as similar to any other non-price variable. And maybe that's the right approach. I mean, I think that's what Chairman Ferguson is saying. I think I'm not, now, it still may be,
Has any of us said that?
Well, it's a question. It's a question. I think that's what I hear in the response.
Well, what I was trying to argue is that even if you treat it as just another non-price variable, you're unlikely to find the facts and circumstances under which you can bring a strong case. I don't think it's right to say that it's just another non-price variable, because I think there are key constitutional values at play. They happen to matter to me, so I wouldn't say that.
I'll ask the question a different way then.
Okay.
Is harm to speech or harm to speech rights or the ability to speak antitrust injury or the type of harm the antitrust laws should reach? Sure.
So, I mean, I'll just try to be very brief and say I don't think that matters in a government case, because exactly how the market power is going to be exercised is immaterial. It matters in the private case because the private plaintiff has to show that he or she was injured by a violation of the antitrust laws, probably injured in property. There may be I'm not a First Amendment expert, but my intuition would tell me, a little bit like the Associated Press case, I think it really is relevant, that if this policy that we're talking about is material to consumers' evaluation of the product, it's an important attribute. It's like whether it's a convertible or a sedan for the car, and it's a degradation of the quality, which I agree with you, Dan, it's not at all clear to me that these kinds of policies are necessarily degradation as opposed to simply, I choose to sell blue cars and not red cars. But in any event, if those two elements are met, then I think the plaintiff who's complaining that I'm unhappy because I don't have access now to speech from the Republican Party or whatever, he has standing to challenge the merger. But the lawfulness of the merger depends on the market power question, not on the particular way that
but earlier you talked about a mere evidentiary problem. But
As to liability in the government case, not in a private
right,
case.
it's liability in government case. But look, I get it, market power, and I've seen the market power full stop, and, you know, Carl Shapiro and other people have pushed back against certain things, saying market power full stop, and yet he always testifies, as it turns out, about likely output or price effects. And I do think
It's
that
evidence.
yeah, I get it's evidence. I just would erase the word mere in front of evidence. I suspect we can all agree that there could be, right, there could be a showing that this is likely to enhance market power. And done, they haven't increased prices yet. We're screening a merger prior to the acquisition, but I don't think the evidentiary question is trivial.
Imagine a merger of monopoly, and it's proven because Carl Shapiro did a bunch of econometric tests and said, I can confidently predict that prices will go up by X%. Professor Shapiro, what do you think they're going to do with product quality, with innovation, and investments in R&D? I don't know what they're going to do. I just did a hypothetical, assuming they wanted to manifest their power, exploit it by price increases. Okay. The defendant then comes into court and says, Your Honor, I will give a promise that for the time immemorial we won't raise price. Is the merger legal or illegal?
I don't know the answer yet.
I think it's plainly illegal.
Illegal because you can't, they give it a promise, but so what after the fact they raise price?
Well, no, even if the promise is binding, they could make other changes. So like, here's the thing, they could lower the cost of production so that the product is inferior, and thereby exploit their market power. That's a perfectly legitimate concern. I don't see how it fits this case, but
The only point I'm trying to make is a particular manifestation of power is immaterial.
Okay, so Doug, I think
Immaterial.
And I think that's the way I've tried to set this hypothetical up, right? Which is that the manifestation of market power, and maybe we get that way by backing into it, but the manifestation of the market power is to impose on its now subsidiary, Company B, a no comments policy. Right?
Let me.
I mean, that is the only manifestation of the market power.
There's a great quote from Associated Press I had put down. If people recall, in 45, the court considered AP's policy gave its members the ability to block non-member competitors from joining the cooperative, gaining access to AP stories. So AP's position was enforcing antitrust laws against it would violate the freedom of the press by compelling the members to share their intellectual property. You could say freedom of the press, freedom of the platform to choose its own platforming rules vis-a-vis public comment. And there's this great quote from the court, quote, freedom to publish is guaranteed by the Constitution, but freedom to combine to keep others from publishing is not. Freedom of the press from government interference in the First Amendment does not sanction repression of that freedom by private interests. That would be what I would be trying to hang on to, that quote, if I were trying to argue that there's a violation.
Okay. I think it's worth exploring. Well, sure, go ahead, Baron. I think we talked about this earlier, but go ahead.
Yeah, I brought this up in the earlier panel. The key point in that case is that what was at issue was the business practice of a cartel allowing its members to exclude competitors. There was no contention in that case that the issue was about content. The member newspaper wasn't excluding a new newspaper because of the content of the newspaper. It's because the new newspaper would be a rival to the existing newspaper in that market. That was the issue. It had nothing to do with substance, that is speech, right? So it was clearly about business practices, not editorial judgments. So I take from the Associated Press case the very opposite point, that what the court is talking about there is exclusive business practices and not, I want to censor, so-called, certain speech.
Right, that's a good point, but the fact that you're just dealing with business practices, I mean, again, this is perhaps comparing apples and oranges, but look at Claiborne Hardware, 1963 Supreme Court, antitrust case. Looks like a per se illegal group boycott. Local businesses engaged in a group boycott of a hardware store, complaining that a hardware store has violated civil rights, violating civil rights laws, and they have sort of First Amendment right to express their views, and they agree collectively to a group boycott. Let's assume there that some of the parties to the group boycott also benefited commercially from that. Well, no matter, it had the First Amendment right to engage in that sort of action, which was highly commercial, was upheld by the court. So I think, yeah, you're certainly correct about the facts about AP, and I think some others would argue that AP was a joint venture, that maybe joint venture law has changed since that time too, but I don't think it's as clear. I think you can draw a principle out of AP that transcends the fact that the facts there were that you had a sort of quasi-cartel situation.
Let me jump ahead a little bit, because I think we won't come to agreement on this, and I'm not sure we are intended to come to an agreement. How would you remedy this merger if this is the effect or the predicted effect of the merger? Is there a remedy that the government could obtain either by agreement with the parties or in court? Could the government go to court and say, we would like, we wish to block the merger subject to the party, media company A, agreeing to continue to publish the comments on media company B's platform? Is that a remedy that a court would grant?
I hope not.
I hope not, but not because you can't remediate agency concerns pre-merger via behavioral commitments. I hope they would not approve of this behavioral remedy.
Why not? Why not?
Why not? For the same reason that there are important First Amendment concerns here, and for the same reason that I suspect there are very few good merger cases of this sort to be brought. You could have, of course, merger a monopoly in some well-defined, maybe you don't have to define it, you have direct evidence in some media market. You could have all kinds of concerns, and you could go to block that, and maybe you can look. You've had some pharma cases where, what was the Amgen case, right? We had all of this drama and expense, and in the end, the FTC's triumph was it got Amgen to promise to do what it had promised to do all along. That part's okay. I don't want the agency involved in this, and there's something. No, I'll leave it at that. I have another concern, but I don't want to monopolize the.
I get to that conclusion by a somewhat different route. I would say, take a different hypothetical. Let's imagine that the tech platform advertises, we're going to accept comments from everybody and every media company, whatever it is, and we'll never stop that policy. And because of that, it's able to attract all the customers because they love it and there's nobody else doing it, and all of a sudden it's got a monopoly and somehow entry barriers arise and it has an enduring monopoly. And all the other guys are driven out of business. And then it says, oh, never mind, we're changing our mind. Now, I can imagine a consumer protection case or a fraud case saying, look, they duped the customers for the purpose and effect of creating a monopoly as anti-competitive conduct, the Conwood and so forth. It's illegal. In that case, the decision to abandon the open platform policy is itself an illegal act, and it can be enjoined.
No.
You can.
Yeah, no, I think
it can be enjoined. But in the kind of merger hypothetical we were talking about now, this manifestation of market power is not an illegal act. And therefore, it seems to me it can't be enjoined, partly because of the First Amendment issues.
If you memorialize the remedy in an order, and they saw, you have a consent order, the merging parties are gonna sign a consent order with the scrutinizing agency and say, look, you can go after them for violation of an order, but that I think is.
No, but you have to have a legal predicate for the consent order, but it's gotta be the
Yeah,
merger's illegal.
yeah. If you have a legal predicate for the consent order.
Boy, you want to really unleash the government to shake down private
No.
firms if they agree to change their speech?
No, I don't want them involved in this at all. And I think there's a sort of an interesting sort of question. I mean, Bilal, I don't know if Bilal made the decision or you made the decision. Somebody made the decision to start this panel discussion. I can understand why people would want to delay hearing from me, but to start with these video clips of Chairman Ferguson. And I mean, I listened to those clips. I read his speeches. I read a couple of Gail's speeches. I looked at not only the RFI, but the framing material for the RFI that was released. And they're citing the Commission's study authority under Section 6, right? So here I think we're more 6F and H than the investigation authority. This wasn't an issue that I started to have with Chairman Ferguson. It's an issue that I had when I left the FTC, and I believe in the study authority, I believe in the research project, I spent a lot of years working on this stuff. In what sense was that a request for information or the opening of a study? When you say, I think there's conduct here that is fundamentally un-American and that is the most serious policy and antitrust issue of our time. And so just under the study authority, and I'm just asking, can people please supply me with some examples of terrible things
To corroborate the conclusion I made up my mind.
Right,
Yeah.
right. So, I mean, I think not for 1 year, maybe for 5 years, maybe you have antecedents in mind. There's a sort of flirting with prejudgment, and I use flirting here as both a metaphor and a euphemism. Make of that what you will.
Don't have too much to add to that. I noticed, do you think we should go on to the next hypothetical?
Yeah, I think so.
perhaps?
I think so. Look, I think what I'm sort of driving at is I think the agency has to think about some of these questions. First, how do you meet the in-commerce requirement, in-commerce or affecting commerce requirement, right? And does it potentially turn on the theory of harm or the form of harm, speech versus some non-speech characteristic? Is the protection of speech something the antitrust laws are intended to reach? Maybe that's an obvious question, but I'm not so sure. Third, of course, I think you do have the First Amendment question, right? Can you build an antitrust claim around changes to an editorial policy, given the First Amendment? And I think these are tough legal questions, but maybe not. But let's turn to another hypothetical, which I think raises the same questions, but in different form. During that same merger investigation, DOJ discovers that media company A adopted its no comments policy in response to an offline and online petitioning and picketing campaign by two civil society groups, Parents Concerned About Culture in the News and Parents for Science in the News. Each civil society group publishes and sells their own newsletter for a nominal fee, and each have a YouTube channel on which they each sell some advertising, branded respectively Culture in the News and Science in the News. Media company A adopts its no comment policy pursuant to an agreement that the two civil society groups will stop petitioning and picketing it although it cannot identify any economic harm from the picketing and petitioning, its board members did feel socially ostracized. DOJ believes this is evidence that Media Company A's policy of no comments was not a policy adopted solely, unilaterally, right, because board members found comments objectionable, but because of public pressure not to publish certain content that was objectionable to third parties. So can DOJ pursue a Section 1 claim here against either just Media Company A or Media Company A and one or two of the civil society groups, right? Is this, I mean, can we show antitrust harm? Or is Media Company A party to an agreement in restraint of trade, right? I mean, this raises the commerce question again, I think. Whether or not it is the decision by Media Company A to adopt the no comments policy protected under the First Amendment?
Well, the picketing parties, that's expressive. They're engaging in First Amendment right to express their views. You can't pull them into that. No, clearly, I think they're shielded. If that's the only form of joint agreement, where is your Sherman 1 claim? I think it also is a question.
Well, let me step back. They may not be liable, right, for violation, but they are party to. They may be a party to an agreement.
True, but how are you going to show that? There's a weird analogy here to government coercion, which is a gray area, which has been dealt with in a number of court cases over the years. But the government, for instance, claims that government is coercing particular speech by a private party, which is outside a regulated setting. You have to show that there's a direct, almost harm, direct link to the harm. Certainly, if it's a private antitrust case. And I think it would be very, very difficult to show, well, yes, there's a direct link. We can prove if it's just, this is in public, this is no contract. Section 5 of the unfair methods of competition doesn't really work either, I think. It's no commercial reason. So I don't see how you come up with an agreement. Let's say, well, we on our own we decided to do this, but it doesn't matter because we also have the First Amendment right to change our policies in this area, and we like to hear different views in the public. So I just don't see it.
I don't see it, again, because it didn't say the claim. Where is the market power being created? Has A conspired with or merged with or done a joint venture with a competitor? No. Has it entered into a scheme with these public interest organizations to somehow drive rivals out of business? No. It's not an antitrust claim, period. You don't have to reach the issues of whether the particular thing they negotiated over was the color of the car or the content being emitted from the radio.
No, I think Doug's right. I mean, if you got to court, all of Alden's problems would be real problems. I think there's a further question whether the purpose of these is to bring winnable cases in court. I don't know. You can get a lot of mileage out of other, right? I mean, the threshold for showing government, I mean, I just think Doug's right. I don't know what the antitrust claim is here, but I mean, to jump over that to get to Alden's point, I mean, we have a pretty high, some would say unduly high, threshold for demonstrating government coercion, especially in recognition of the fact that the first tier of protected speech is concerned not just with censorship, but with compelled speech. But I don't see the market power. I don't see the,
Well, I mean, what market power do you need in a Section 1 claim?
Oh, well, right. And I guess, DOJ plainly, I mean, we have agreements where, we have a big case with Google about their agreements with Apple, which is not party.
In a Section 1 claim, you need more market power than there would have been but for the conduct you're complaining about.
Yep.
That's true in a Section 2 case, too, and in a Section 7 case.
Okay.
And it's not happening here.
Yeah, and this isn't per se illegal. This is not per se illegal price fixing agreement.
Well, would you say the same thing, Doug, about a vertical Section 1 claim?
No, it could be a vertical claim
If
it was designed to screw some competitor of one vertical level or the other, but this one wasn't.
Right, you're trying to foreclose inputs or something.
Yeah.
I mean, suppose 20 customers come together and say to an individual firm, we're really unhappy with your price. They don't threaten to boycott, they just say, we're really unhappy with your price. And the firm says, I better lower my price. How could the firm have committed an antitrust violation? I don't see it.
Okay. I'm trying to imagine how the FTC or DOJ will bring these cases.
Well, I think
Maybe they
there's
need to
some
be more
suggestion they
creative.
think they can find an agreement among platforms or advertisers.
Well, okay, that's it. Well, okay, maybe that's, I mean, I think some people think that's an easy case.
And maybe it's
Agreement-
vaporware.
Agreement among the
Well, I
platform
don't know if
companies.
it's, I mean, is it an easy case?
Well, let me just state
Go
it.
ahead, sure.
But I agree, it's a question. But I think there's a view that it's an easy case. So if the major platforms agree not to publish certain comments or that are non-commercial in nature, right? Comments about the president or negative comments about the president or the Speaker of the House or the dean of a university, the public, the platforms just want to elevate discourse and agree not to publish negative comments about anybody. Is that an actionable antitrust claim?
I think it might be. It might be because you have to ask a question of why they felt they needed an agreement. There is a suggestion, I think, that each one of them was afraid to do it itself, from which one might draw a very tentative inference that maybe this is a change in the product composition contrary to the interests of their consumers. And if they're all acting together, that therefore they are creating market power that they wouldn't otherwise have to take an action contrary to the interests of consumers. If they were just doing best practices and not agreeing, that whole argument goes away. But even if there's an agreement like that, I think, as Alden pointed out earlier, they get a lot of mileage, I think, out of Claiborne Hardware. Claiborne Hardware expressed itself in terms of, was the motive political, public policy, call it what you will, or was it commercial? I think you can kind of get to the same result through the antitrust laws by, again, asking, is there some way that this scheme enables them to profit to the detriment of trading partners? Because if all they're doing is saying, we know you're unhappy, and we know it's not going to benefit us, you guys are all going to, go back to broadcast television or something, but we think it's in the public interest, then I think they have a very good Claiborne Hardware defense. But that's a closer case, I think.
I agree it is a closer case. I mean, are there effects on other, advertising markets, which then will affect downstream consumers? I mean, it could be a number of commercial effects. And if again, the hypothetical that they're real, there's evidence that there's really a purely commercial purpose to this. You still have the Claiborne and Harvard. So but I think it's sort of a gray area but it really cliche, but it goes without saying it depends upon the facts there.
Yeah, I mean, I am trying to read out in these hypotheticals a commercial purpose. I recognize that the antitrust agencies might be able to identify a commercial purpose, but I'm driving at is speech different? Speech as speech. But I appreciate the reference to Claiborne Hardware. I wonder if it's worth talking a little bit about the distinction between Claiborne Hardware and Superior Court trial lawyers, right? Where I think I've had I had long conversations with Tim Muris about Superior Court trial lawyers, and I also had long conversations with Will Tom about Superior Court trial lawyers, because I believe Will litigated that case, and believed the conduct was expressive conduct, right? The boycott, right, over willingness to accept cases for indigents. So what is the difference between the two? And I think in the in the appellate court, Doug Ginsburg, a good friend of the First Amendment, found that the Superior Court trial lawyers' conduct was protected.
Yeah.
And the Supreme Court reversed.
And I think DOJ believed it was protected too. DOJ was not, did not want to pursue it because of that. I mean, I think if you want to make the difference, even though it was decided many years later, the difference is, I think there was Claiborne Hardware clearly could say there was a major, if not, there was a major non-commercial related drive behind what they were doing. Certainly the parties had a right to petition in Superior Court trial lawyers, had a right to petition the government, even though it was crass commercial interest. They had the First Amendment right to petition for higher wages, even collective agreement, certainly NOR comes into the picture. But the problem was that if the petition fails, then it turned into really a purely, the argument goes, a pure cartel agreement to say we are going to withhold our services unless we are given the raise. So they say this is really, you can petition for redress, you can petition, but that doesn't justify subsequent per se or close to per se illegal joint agreement, which is really totally commercially based. I mean, I think the argument there is it's basically, understandably wanted higher wages, total commercially based group boycott. And although there could have been some economic aspects to Claiborne Hardware, there was a non-commercial purpose that was central there.
Yeah, I know my views are probably eccentric, at least in this room. I think that was an easy case. Superior Court trial lawyers. You had competing providers of services aggregating their market power in dealing with the buyer of those services and effecting a boycott for the purpose of increasing the price that the buyer, which was acting in a commercial capacity, would pay. The First Amendment doesn't apply just to speech to the government. It applies to speech among private parties. If that's not illegal, why is it illegal? Why would it be illegal for a bunch of customers of General Motors to get together and say, we're going to withhold, all the distributors are going to not distribute your cars unless you cut us a bigger deal? We're speaking about this matter of interest. I mean, come on. It's a trivial case. I think it's a very easy case. I never understood why it was considered a hard case.
Well, I'm with you on that one. I mean, I learned that at the feet of Tim Muris, so I agree with you.
Yeah, the FTC won, so it's
right. So can they find a case like this where you have a group boycott and leverage with a buyer? Because I mean, sometimes I look at the RFI and I think. There have been legitimate cases involving airlines. I mean, merger scrutiny, conduct scrutiny, and so forth. And you say, put out an RFI, you say, gee, I'm really concerned. I wonder if there are dozens or even hundreds of people who complain about the quality of airline service. Because if I can find several hundred of these, then there's an antitrust problem. I think so good luck.
I wanted to pick up on Superior Court trial lawyers.
It's probably right.
And Doug's comment, right? I mean, you don't get to claim free speech when you enter into an agreement, to restrain trade, right? I mean, the speech is the instrumentality. It's not the protected conduct. And so that's why I continue to think a harm that is focused on the elimination of a speech right is a little bit different than the, harm, other non-price harm. But let me ask a question in the context of the Knorr case, right? So the Knorr-Pennington doctrine protects certain anti-competitive conduct, right? The petitioning, joint petitioning of the legislature, the executive, in support of imposing a restraint on competition in some manner,
Yeah.
right? And it elevates one First Amendment principle, the right to petition. I'm asking a slightly different question, right, which is if a group gets together to diminish the right to speak, right, its competitors and the like, not competitors, it's consumers, it's customers, it's users on the platform. The remedy for that, right, is to force them to allow the speech. Does that, or Doug is shaking his head, or the remedy is just don't enter into the agreement?
Don't enter into an agreement. Don't aggregate your market power to the detriment of your trading partner.
And nor only applies if you're petitioning the government.
No,
Well, even then it has, right, there's a sham exception to North
What I'm getting at is simply the elevation of the petitioning right over the antitrust harm, right? That's all.
But if you look at Claiborne on the one hand, and Knorr on that hand, and Superior Court trial lawyers, the difference is that in Superior Court trial lawyers, they were exercising economic clout, creating market power by aggregation. In Knorr, they weren't exercising economic clout over the government. They were asking the government to screw a competitor.
On their behalf, yeah.
So, Bilal, we have maybe 8 minutes.
Okay.
Maybe you want to wrap up just talking about the suits against the advertisers.
Well, those seem like potentially easier cases just because they concern commercial, or at least the potential for commercial speech. But I actually wanted to do a slightly different question, since nobody likes my hypotheticals, as identifying a real issue for the antitrust agencies. And maybe that's fine. Maybe this is an easier case for the agencies than I anticipate. What about, again, the exercise of unilateral market power? For some period of time, Media Company A will host the websites of community news websites, right? It doesn't restrict their comments. It doesn't restrict what they publish. And over time, it obtains an 80% share of the market for hosting community news organizations, let's assume that's a relevant market. After an activist campaign with respect to the board of directors of Media Company A, Media Company A changes its policy with respect to what it will host, right? It decides that it will no longer host certain content that, it will no longer host community news organizations that print content that calls into question the safety of a vaccine, and it will no longer, and it will require that any reference to former President Biden on the community news website include an asterisk next to the word president, an implicit suggestion that maybe he was not legitimately elected. Now, and so some community news organizations refuse to accede to this demand, and Media Company A refuses to continue dealing with them. Now, assume for the moment that we're in the Fourth Circuit and Trinco does not apply, and so we are you know,
I kind of
does
think
this?
it does, Paul, because the whole.
Supreme Court.
Yeah.
Well, I don't know. I read this in, well, it doesn't apply because Media Company A is not regulated, right? This was the language in the ad tech case and the Duke Energy, okay? It may be questionable, okay, but do the community news organizations have sort of a Aspen Ski type argument? They used to deal with us, they now refuse to deal with us unless we put an asterisk next to the name of President Biden.
I think the outer boundary of Aspen skiing is wherever the ski patrol puts the tape. I don't know, but it seems to me, I would go back to the question, are we asking about either a single acquisition or maybe on this like roll-up theory, some series of sub-threshold acquisitions by which they acquired their market power unlawfully, or you're just saying, oh, they have market power, but
look, it's a firm with market power refusing to deal with firms who are in some manner a competitor, right? After a, let's say, 20-year course of dealing with them.
Well, I mean, what's the theory of harm to competition? That they created market power in the market in which they compete with these other news sources?
They are, again, the theory of harm is they are restricting certain comments from being published.
But, yeah, you have to have a gain in market power, right? And because you can exercise your market power however you want, as long as you are not creating a new exclusionary ability to enhance and prevent entry or increase your market power. So I don't see that. You'd have to have something in the hypothetical about how they're blocking entry. Maybe somebody else wants
right. Is this a foreclosure story that is, by making these speech decisions, they're foreclosing competitors?
Okay, no, I understand. And maybe it's too simple. It's a monopolist refusing to deal after a period of dealing with a competitor.
Well, first of all, even if you go to the outer reaches of refusal to deal law in Aspen skiing, you have to find a profit sacrifice.
Yeah, no economic sense.
And the profit sacrifice has to be pursuant to a scheme in effect to recoup by harming competition, and that's not a part of the story, as I understand it.
Okay, I didn't put it in my story.
Agreed.
It's not just prior dealing, at least.
I agree with that. Okay, I agree with that.
Yeah.
I agree with that. Okay, well, I feel like my hypotheticals have been a big failure.
They've been great.
No. Failure in this respect. I think the question is, have we said anything that would dissuade the FTC or DOJ from pursuing this type of case?
Oh, God.
And I don't think we have.
Not as long as Trump is in the White House.
Well, no. Look, I have a lot of faith, and I say this honestly, not just because we're on tape. I have a lot of faith, actually, in Ferguson and the other commissioners, and the head of the Antitrust Division, that they will not pursue non-meritorious cases. And I think pursuing a case like this would be non-meritorious on the law because of either the First Amendment right, maybe the question of, is this harm that the antitrust laws are designed to protect, or even, and I'm a little shakier on this, on the commerce question. But I think what I heard today was none of those seem like real bars to bringing a case outside of, that the law does not seem like a real bar to bringing those types of cases, but that there, of course, may be facts that would not support or weaken a case. And in that sense, I think it's a failure, because I think if we are concerned, not you guys failed, I'm saying my hypotheticals failed, because I believe these are real questions of law, and there was a lot of discussion here of factual thing. Not totally. I think Doug's point about, and everyone points, market power, accretion of market power, exercise of market power, how is it effectuated, are all valid sort of legal arguments within the scope of antitrust law. But I also think there really should be a First Amendment bar to these cases where there's not an economic motivation. And I don't think we really got to that, and that's a failure of the hypotheticals.
Well, I thought it was a success of the hypotheticals. You wanted us to march through these kinds of considerations without focus on First Amendment doctrine, whether that's commercial speech doctrine or not. I mean, commercial speech doctrine isn't the lowest scrutiny, right? And that's for advertising. But I do think you're right to point out, I mean, I don't know, how to attest to my, I don't know how to attest to my faith, but I do think there's a point to pointing out that they've not yet brought a case, right? There's a difference between all of this other activity and actually bringing a case, whether that's good or bad. Now, it doesn't mean that stopping short of a case has no policy effect and no effect on commercial actors, but they have not yet brought a case, so maybe that's a signal, and given what the other things we've said, maybe that's a good signal, but I don't know.
Well, I can't help think, Bilal, but that you're complaining about your inability to engage in content moderation. Yeah, I'm not sure they're going to bring bad cases. I agree with that. That would be kind of foolish. They may bring a case that would be more aggressive than people sitting at this table or in this room would bring. But I also think that the stridency of the announcement, the tendentiousness of the request for information, and it's existing against the backdrop of everything else that's going on in the administration of Project 2025. And in fairness, Biden FTC did this too. I can't help but think that one of the motives might be to deter conduct they don't like, regardless whether at the end of the day it's found to violate the antitrust.
Exactly, and regardless of whether they even bring a case.
Yeah.
It's always bad. I remember when Robert Bork became the straw man in the president's announcement of his executive order on competition, and I'm sure that Bill Kovacic was shaking his head, the double helix. But yeah, it's always bad when you create sort of straw man villains, I think. But whoever does it.
Okay, well, thank you.
Sure,
Of course.
I've had this notion. I actually wrote something about it 1,000 years ago and haven't looked at it carefully, but I think that there's at least a kernel of truth to it. So go back and look at antitrust law, the U.S. antitrust law over the past now close to 100 years. I think you will find that at any point in time when there was a seemingly dominant communications medium, radio in the 30s and 40s, motion pictures in the 30s, motion pictures in the 40s, broadcast television 50s and 60s, cable television thereafter, now the internet. Because of concern about variety and access to information and all, what has happened is arguably in each of those phases there has been an excessively aggressive application of the antitrust laws. You think of the Paramount decrees, you think of the what were the network cases about, I forget what they're called, not must-carry, but whatever it was, whether they could own their own suppliers, their own producers, some of the aggressive vertical theories in the cable area. So I think in a certain sense, while I think the particular context now of the partisanship is maybe it raises the temperature a lot, I think we're seeing a cyclical thing play out here.
Okay, well, maybe that's the right place to end.
No.
So thank you. I'll work on my hypotheticals.
Yeah.
We'll be back in a year.
Okay, well, thank you very much to everyone who's here. I was not supposed to be moderating this panel. Corbin Barthold couldn't be here, so I'm pinch hitting for him, but I'm happy to re-engage. So thank you to everyone who's stayed with us today. I'll introduce down from the end here. So Kate Rain, excuse me.
Ruan.
Ruan.
I know.
I'm sorry.
It's okay.
All these years.
It's a mess.
No, it actually makes sense. I should have known better. Director of the Free Expression Project at the Center for Democracy and Technology. Previously at the ACLU. Yes?
Yep.
Anything you want to add to that?
No, I think that's all right.
Okay. Manisha Mithal, right?
Yes.
I am really happy to have you on board for this panel because you do the best job of summarizing what the agency has been up to. And of course, you have a long background at the agency, currently a partner at Wilson Sonsini, and at the agency. You want to just summarize your work?
Sure. I was at the FTC over 22 years. For over a decade, I headed the Division of Privacy and Identity Protection.
And thank you. And Derek Bambauer, just another law professor, except also the author of the leading article against jawboning, which is funny because most people these days here in DC are for jawboning. So we needed to find somebody who was against it. Everyone claims to be against it, but actually they're really for it, right? I mean, everyone here, not necessarily you. Do you want to add anything?
No, just that it's a real pleasure to be in Florida because it's like living in a toy store for free speech concerns.
Well, welcome to DC. If you thought that was fun, welcome to Washington. Anyway, so we're here to just wrap up with a general discussion of, in a sense, what's next. And really, there are a lot of ways to think about that. We've talked about these on several of these panels today. What can the Commission, the FTC, and the DOJ, what can they do? They could investigate cases. They could write reports. They could pursue particular remedies in particular cases. And of course, they could always use the bully pulpit. So with that setup, do you have any, for those of you who've been here for the earlier discussions, before we get into those questions, do you have any general reactions to the earlier panels today? Derek?
So I think it's enormously helpful for those of us who are antitrust experts, and in particular, I appreciate Bob Corner-Viewer's point that old wine in new bottles, that merely framing something as antitrust, as consumer protection or whatever, is not effective as sort of circumvention for the protections that the First Amendment offers. So I thought that was enormously helpful, and also in some senses, and I know we'll get to this, the emphasis for the sort of substantive limits on the FTC's ability to employ, for example, its Section 5 power. I think that is the part that interests me most, is that there is, I think, in some ways, a kind of important and vast disparity. And Baron, you talked about this with the privacy and security precedents between what I think of as the Commission's ability to have a sort of interorum effect and its ability to accomplish things through the courts. And to me, I think that's kind of the heart of jawboning.
Right, and if you're playing along from home here, you're wondering about that image there. That image is Samson having slain 1,000 Philistines, and he's holding jawbone above his head. He's actually drinking from it. So in the biblical story, it's not just the jawbone is this all-powerful weapon, it's that the jawbone actually itself becomes this miraculous source of sustenance. So it keeps sustaining him, and he's sort of gloating in his victory triumphantly over there. You can imagine that it was quite a surprise last weekend to just stumble across this painting at the Bologna Fine Arts Museum and see it all brought together in such a spectacular fashion. So that's jawboning for you in a nutshell. But before we get into jawboning, any other general reactions to the subject matter discussed earlier today? No. Okay.
I think maybe I would just add that it's important to situate what's happening at the FTC and the DOJ in a broader political context, and I think that's pretty relevant to jawboning. So, I think there are some who might reasonably view the FTC's request for information as almost an extension or relocation of the efforts on the part of the House Judiciary Committee last year to investigate the weaponization committee, right? To investigate what it termed the vast conspiracy to collude between researchers, government, and platforms to censor constitutionally protected speech. You can look at the RFI as a next step in that process, an attempt to gather additional information to support that hypothesis. Will it be effective in doing that? I do not know. I have my suspicions. But I do think it's important to understand it in that political context and to look at how effective the Weaponization Committee was at jawboning, at using its authority, its investigative authority, to create a sense that there was some sort of censorship happening that was untoward or unwarranted or somehow unconstitutional. When you really look at the facts, there wasn't. So I think that that's an important thing to say as we seriously examine the constitutional authorities and the statutory authorities that are all involved here. I think part of what we're thinking about in this panel is broader context and how that can affect free expression and privacy and the general feelings about free expression and privacy that we all have outside of what the actual legal authorities are.
Thank you. That's really helpful. And just to be very concrete about that, I would note that in particular, Jim Jordan sent dozens of subpoenas regarding the Global Alliance for Responsible Media and the advertisers. And those subpoenas became the basis for the lawsuit that was filed by X and by Gab. The Gab lawsuit was written by Mark Meador. He was the lead counsel on that suit. Mark is now one of the 3 FTC commissioners. He's very committed to the FTC continuing to pursue that set of cases. But it just makes your point, Kate, that they were able to get discovery about what was happening inside these advertisers inside the Global Alliance for Responsible Media that would not have been available to a normal plaintiff, that allowed those suits to be filed, and in response to which the Global Alliance for Responsible Media shut down immediately. They're now celebrating that as proof that there must have been a conspiracy to silence conservative voices, and that proves that they had legal merit. In fact, the case has not moved at all. It's been rather unusual. There have been 2 federal judges who've recused themselves from that case. So even though the case was filed now something like 9 months ago, nothing's happened in the case. So we really have no discussion on the merits yet, but that's going to happen soon enough. And I expect we'll see the same sort of pattern happen where this investigation will lead to similar lawsuits in the future. But that's where we wanted to start this discussion. What do we actually think is going to happen next? We jumped right to the point for some of us, which is jawboning. But there are a lot of things that could happen procedurally. Manisha, you're here because you've actually been inside the commission. You can tell us, as someone who has the experience of seeing how things work inside, what do you expect really is within the realm of the range of options here for next steps?
Yeah, so it's interesting because I was at the FTC for over 20 years, as I mentioned, and so I went through a lot of transitions, including Trump 1, then to the Khan FTC, and now to Ferguson. I've not been at the FTC then. And so I think there's a similar pattern that's followed whenever there's a transition. A new person comes in and says, okay, here's the things I want to accomplish. And Barron started to allude to this, and I think there's a number of tools in the FTC's toolbox to accomplish whatever the new person's vision is. So there's enforcement actions, which would result in consent orders or litigation. There are 6B studies. So, for example, I think there was several years ago, the commission said, well, what are we going to do about data brokers? Legal authority wasn't clear, and so they said, okay, let's do a 6B study, which is an industry study, and let's kind of issue a report of best practices on data brokers. Another option that used to be used a lot but isn't used as much anymore is the workshop. So the FTC convenes a group of people together, gets input. Bilal presided over a series of hearings at some point. And then there's usually a report that comes out of that, again, with best practices. And then I think there's speeches, there's reports, there's guidance, and then we always used to joke, there's like guidance, workshop, report, conference. There's a wide variety of steps the commission can take. And so I think what tends to happen is that people start off very gung-ho about whatever the issue is that they want to address. And then I think as they move along, they get pushback from counsel in cases. As they're going through an investigation, they see things aren't really what they thought there were. And oftentimes what we'll see at the end is maybe not this like huge new body of law or this kind of development of unfairness or a huge new area. It's often kind of, okay, well, here's what we found. We found this one deception theory. So let's bring a case involving this like small deception theory, and then use that maybe as have fencing in the order that tells us that basically sets forth the policy guidance for the industry of where we want it to go. So taking that, again, a lot of times we say past is prologue, but I think all bets are off. We've seen this administration really kind of be aggressive and in some of these theories. So I don't know what's going to happen, but if I were sitting at the FTC, what I would be briefing the commissioners on is, here are going to be your difficulties when kind of espousing these theories. Here are some alternatives if you want to have something to show for this.
One really mechanical question that came up earlier. So I think it was Dan noted the difference between 6B and 6F. So remember, Section 5 is the operative statute, provision of the statute. 6 is about the other powers of the commission, including investigatory powers. So 6B is reports and so on that companies submit to the commission. As I understand it, 6F is making recommendations to Congress and writing public reports. Can you explain to us what are the limits, Bilal alluded to this earlier, about the ability to use information gathered under those purposes in enforcement actions?
Yeah, so the section, the 6B studies are truly that, industry studies, and they're not supposed to be used as a mechanism to kind of an end run around a CID or a subpoena. And so it's really just, hey, we're studying the practices. Now, if the FTC is doing a 6B study and gets information during the course of that 6B study that suggests there could be a law violation, they could do a separate CID to the company and say, hey, we found this during the 6B study, and so please give us more information. They would typically use the subpoena route to get at that law violation.
And there was a set of dissents last year, if I recall correctly, from the two Republican commissioners now regarding CIDs, I think, to the companies, saying that they should have asked more about content moderation, which suggests to me that we're probably going to see that happen now, right? That this inquiry is really just prelude to seeing those compulsory processes.
Yeah, I think that's the direction they certainly seem to be headed from their public statements. So we saw Chairman Ferguson's budget testimony today, and he again made this a centerpiece of his agenda. And so I do think that we are certainly going to see CIDs. Now, that said, CID is a very broad tool. There are a lot of companies who have pushed back and moved to quash CIDs, and those suits are very rarely successful because the FTC has very broad authority to seek information through CIDs, and it doesn't have to be a one-to-one correlation, like, okay, we can only ask about this particular unfair practice. They can use these CIDs as fishing expeditions, and so I think that the CID authority is fairly broad for the FTC.
And those are civil investigative demands if you're filling out your bingo card. So Kate, you talked about the political context here. Manisha noted that often, normally, administrations will start with a big talk at an agency about bringing actions and then bring fairly small claims. Do you think that's going to happen here, given the context that you've described?
Oh goodness, I don't know. I mean, if the FTC is concerned about the constitutionality of its actions, I would think it would proceed cautiously in actions that it brings and try to start with, I think some of what we heard earlier, like the more closer line cases where they have a company who has said it enforces something in one way, but then when you engage in a civil investigative man, you find out what they really do. They actually don't do it at all. So my go-to example is company says, we take down non-consensually distributed intimate images. But when you look at what they actually do when they get those reports and they don't do it, could that be a deceptive practice because given the harm to consumers? That's an open question, I think. If the FTC wanted to proceed cautiously, it could do that. Will it? I don't know. My other concern is what you brought up earlier, that there will be information that comes to light as a result of the investigations that are currently ongoing that are then used by others to bring other lawsuits that attempt to try to pressure companies, regardless of the merits of the lawsuit, to change how they moderate content in order to, because that really does seem to be the goal here, right? To pressure large social media platforms to host content that on their own they would decide to take down. That is my big concern, that it's going to lead to sort of an ecosystem of lawsuits that make clear to companies what would be better for them to do in order to avoid having to pay for the lawsuits going forward.
Yeah, and having to pay the political cost too.
Exactly.
So, Derek, is this just job owning? And just tell us just a little about your framework, your conceptual framework for understanding what job owning is and why you think tech companies are uniquely vulnerable to it.
So it's a good question. I tend to think of job owning, like I define it a couple ways. One is just that it's threats of action that are either right at the edges of or outside. Sorry, now I got to lean into the mic here. That are right at the edges of or outside a particular entity's, especially an agency's authority. And I also think of it as an attempt to use that authority or the claim of that authority to achieve enforcement ends, and in particular through informal channels. The good news is that we have some recent precedent on job owning via the Murthy and the Vullo cases, and also I think actually somewhat indirectly through the Linkey versus Freed case about social media, which has gotten very, very little attention, deserves a lot more because it's a state action case, and I think of state action as at the heart.
Just briefly, what were those three cases?
So the NRA, National Rifle Association versus Vullo, is a challenge to a financial services regulator in New York State. There were a series of NRA-affiliated insurance companies who offered policies that covered the holder for use of a lawfully possessed firearm. Unfortunately, it also covered the use of that lawfully possessed firearm for murder, and that turns out to be against not just New York state law, but actually insurance regs in New York. And so it seems the sort of underlying ground, right, for the regulator to actually act against the insurance companies, I think, was in very little doubt. The problematic aspect is that the head of the New York State agency, Maria Vullo, essentially said that, paraphrasing slightly, she would go lightly on them, right? They would get a better settlement if they were to dissociate from the NRA, right? So that they would not only cease carrying these unlawful policies, but cease association with the NRA at all. That's the one where the Supreme Court agreed, at least at sort of the motion to dismiss stage, that this was a good job owning claim. Hard part is it gives us very little information about actually what a job owning claim is, right? So there's no consensus on the methodology. Case two, and the one that I think got the most press, was a sort of conjury of lawsuits by a variety of people who were aggrieved with the practices in particular of Facebook, although a variety of internet platforms, in either removing their posts, deprioritizing them, or deplatforming them. And the claim was that informal pressures from the Biden administration, in particular around things like COVID-19 vaccines, had led to these actions, and that should thus be a First Amendment violation. Here, the Supreme Court deploys its favorite get-out-of-jail-free card, which is standing. You know, when you can't figure out what else to say as a federal district court judge, you just say standing, and it does a lot of work for you. And so the cases, at least at this point, evaporate largely because there is sort of enough of a nexus between the content decisions and the Biden administration's actions, where the Biden administration was very plainly trying to convince the platforms to do these things. And then lastly, Linke versus Freed is a case about when you can boot people off of your Twitter feed or delete their comments if you're a public official. And it's the classic case. Someone is a private citizen and likes to complain about things. They become a public official and take official actions, but also complain about things online. Their constituents want to comment, and what they do is they disagree, so they delete them. And the Supreme Court combines a sort of Sixth Circuit and Ninth Circuit case, says that both circuits have followed the wrong test, and sends it back for further review, looking at whether the official in question has authority in this particular area, and if so, whether the speech that they posted to their social media account was within that authority, was operating that authority. And Justice Barrett says, look, the hard part is exactly this set of facts, right? It's when you have a mixed account. So jawboning right now is something, everybody agrees that it's bad, and nobody agrees exactly on what it is. One of the sort of really neat parts about it is that Justice Alito's dissent in the Murthy case actually does a pretty nice job of synthesizing what the majority seems to be doing. It's just the majority won't be explicit about it, in part perhaps because Justice Gorsuch writes a concurrence that says, we don't really need and should not have a test for this. Like, as always, we will sort of know it when we see it. And so I know that one of the things that maybe we're going to talk about is, if we assume for the moment that the FTC today or the FCC tomorrow marches ahead in this vein and engages in some of the more official actions that you've described as a follow-on, at what point, like, what's the next step in jawboning? And I obviously don't hope for those things to come to pass, but if they do, my hope would be that we actually get some kind of further explication of how the lower courts ought to approach these kind of highly fact and context sensitive cases without it becoming a pointless painting.
Well, but before we get into what's happening here, do we expect that the courts are going to clarify this doctrine in other circumstances before we get litigation in this area?
I would say, as always, I am hopeful but not optimistic.
I mean, are there cases in the pipeline that we should know about?
Murthy could come back. Murthy is at the stage where now the original district court judge is making some findings of fact that hopefully are factual as opposed to just made up this time. So we might get something on that, but I just wouldn't expect the Supreme Court to sort of return to this until it percolates for quite a while.
Well, just for situational awareness, Murthy looms very large in this discussion. It came up repeatedly in, I think it was in Chair Ferguson's conversation with Eric Posner at the Stigler Center event. If it wasn't there, it was at the Antitrust Division discussion. They are very convinced by the trial court's opinion and by the dissenting justices in the Murthy case, and not by the majority in the Murthy case, which seemed to find that there was no evidence of coercion, even in the strongest arguments that were being made. So the Murthy case plays a significant role here. So how do we know whether what's happening is legitimate? I mean, as I said at the outset here, for those that might have missed this, in principle, the things that the RFI is getting at are not unreasonable concerns. And I just would cite again, as I did this morning, whatever you think of the Digital Services Act, the fact that the European lawmaking process came up with a bunch of due process and transparency requirements and embody them in the Digital Services Act, and that they look an awful lot like what people across the political spectrum, but especially on the right, are saying in the United States, does suggest that these are ideas that should be taken seriously. And a lot of what the RFI is asking about are those ideas, right? Even the ideas that I think are hardest to justify under US law, like the idea that decision-making should be consistent, right? That's what the Digital Services Act says. We've gone on record many times arguing that that's not consistent with the US First Amendment, that those are not decisions that private companies can be required to make in that fashion. But there are all sorts of other things here, like just having an appeals process, right, that don't seem to be on their face about the content of decisions. So how do you know when something is jawboning, when something that seems to be a regulation of a business practice, that seems to be content neutral, is in fact about trying to reshape the nature of content and therefore is constitutionally impermissible?
It's a great question. It comes back to the hard part about figuring out what the motives of government action are. I think that that's pretty difficult. One thing I will say against the DSA and against these requirements is that they're extraordinarily hard to achieve at scale. So the fact is that nobody's content is getting taken down as having it reviewed by a person, at least not at a social media platform of any size. It's all done in an automated fashion. It's increasingly done by AI. AIs are not consistent, as we have learned the hard way. They hallucinate all the time. It turns out that at least with our current understanding of things like LLMs, the research project I'm working on, we're doing something really simple, which is trying to get it to understate state probate codes, and we can't get the best LLM above about 85% accuracy. No matter how much query engineering we do, trying a bunch of different models. So there are going to be errors, and the error, if the transparency requirement can only be, we ran it through, right, the LLM with this current set of weights and training data, and it rejected, right? We don't know why, and with the current technology for LLMs, it is impossible to know why. There's basically no sort of ability to do provenance with a lot of the current AI models. So I think that at some level, it's asking for something that's not possible to achieve, and that makes me worry that it's just to impose costs, which I think is another thing that's at the heart of job owning. The legitimacy question is difficult, and we can talk a little bit about the factors that the court has kind of identified, or Justice Alito thinks he's identified. My own view is I think that there's kind of three things. One is that there has to be a threat, and threats are a little bit difficult because threats are bad, but government speech is good, or at least government speech is protected. And so it's a little bit hard to know what the difference is between saying Facebook is terrible for not taking down this content versus, and if they don't, I'm going to do something about it. So figuring out threats versus government speech, I think, is one hard problem. The second is that I'm interested in two things. One is, so we can map this, right? We've got ourselves a nice 2x2 grid. Dimension one is authority. So the more authority that a particular regulator has over the speech at issue, the more likely I think it is to be legitimate, right? So if it's the FCC dealing with content on broadcast television, the stuff that we originally had the rabbit ears for, although I'm dating myself, that looks fairly legitimate, right? Like we have some concerns about it, and maybe things like Pacifica are no longer good law in the age of streaming services, but the FCC, has undergone review for that. So the greater the authority, I think the less likely it is to be job owning. The second thing I'm worried about is power, right? Which is what is the ability of this particular regulator, state actor, to actually cause consequences for its threat or its demand. So we are not particularly worried about the town clerk who threatens to sue Netflix. We're probably really worried about, honestly, the FTC because of the broad set of powers that we've described it having. And so I think this gives us the easy cases, right? So we should be most concerned where there's a lot of power and very little authority. We should be least concerned where there is a lot of authority and very little power, and that leaves us with the two middle cases. And those are the hard ones that I would ultimately, back to your sort of original question, that's where I would like the court to grapple with them, right? We do well when the Supreme Court takes up the tough ones and not the edge cases.
Well, Manisha, I would imagine that the commission would push back here and say, look, we might have broad jurisdiction, but the agency actually doesn't necessarily have that much power. It's not like the FCC where they can cancel a broadcast license, and they're generally not able to impose fines. So what would you say, Manisha, in terms of predicting what might happen for next steps here? If the agency is merely writing reports, bringing investigations, even entering into a consent decree, if the remedies are the sorts of remedies that the commission normally engages in, what's the harm to speech?
Mm-hmm. Yeah. So, okay, lots of thoughts swirling in my mind. In terms of predictions for the future and kind of the question you're asking, I mean, I do think that there's ways that the FTC has used its authority in ways that could create existential threats for companies. So take the example of algorithmic disgorgement. The FTC several years ago said, hey, if you're going to deceptively collect data and use it in the algorithm, not only do you have to delete the data, but you have to delete any algorithms you created using that data. And so in this age of AI, you could see how that could be an existential threat to companies. So I think there are ways that the FTC has said, okay, we don't have fining authority, we don't have kind of licensing, so what else can we do? And they call it deterrence. Maybe we can name individuals, maybe we can have algorithmic disgorgement, maybe we can partner with the states to issue huge fines. So I think that's kind of for the future. But I think what this discussion reminds me of, again, the area I'm most familiar with is privacy. And so when we think about the definition of job owning, and Derek, I think the test you laid out, which I took notes on, is really fabulous. But I do think that there's areas where the FTC has gone before that could be called, quote, job owning. So take, for example, the first data security case where Microsoft said, your data is safe with Passport, and there was a deceptive claim, and usually the remedy for deception is thou shalt not deceive. Well, in this case, the FTC said, well, Microsoft, for 20 years, you're going to have to implement a security program, and you're going to have to get outside audits of that program. Nothing really in the kind of deception theory of the case, was that an issue. And then you had Microsoft essentially saying, thank you, FTC. You've given us a baseline for the whole industry. You've codified our practices. And so I think that's kind of one example of where the FTC really pushed the envelope. So I think there's many milestones where the FTC has been aggressive about its privacy authority. Even early before the Wyndham case was decided, it was thought that the FTC didn't really have this authority in privacy. Wyndham argued that Congress doesn't hide elephants in mouse holes, and if Congress wanted the FTC Act to cover privacy and security, it would have said so. Well, the FTC kind of carved out this area of deceptive and unfair privacy and cybersecurity practices, and it achieved a victory in the Third Circuit. And I would say that oftentimes FTC orders touch on free speech and curtail free speech. So whether it's bans on telemarketing or required disclosures for advertisers, I think these are issues that the FTC has been looking at in various other realms. And again, if I were in the building, I would be compiling all these examples and trying to figure out ways in which, within the bounds of the FTC authority, maybe it's a case that you get a company to agree to and deliver a roadmap of how you think content moderation should take place. Maybe it is a report, maybe it's guidance, maybe it's 6Bs. So I think, they know all this, right? So the people in the building, they know the First Amendment constraints, they know the uphill battle on unfairness, and so I would have to imagine they are kind of coming up with theories, targets, et cetera, to take into account all of that.
A few reactions. Number one, job owning, for the reasons you just mentioned, has been defended. I mean, for example, Tim Wu, in his book, The Master Switch, argues that in rapidly developing industries in which rulemaking is impracticable, highly informal methods are justified. And there have been many people who were very happy to have the Federal Trade Commission develop a so-called common law of consent decrees over privacy and data security that was not litigated. There was no clear legal authority until finally Wyndham litigated, and even that case left some open questions. But that took something like 15 years. So you can go long periods of time where the commission is just kind of out there trying to feel its way through, and if companies just settle, the commission can build exactly the kind of common law that you've described. Do we think that that's going to happen here, or do we think that the companies will push back? And does it depend on what the nature of the claim and the remedy sought is?
I mean, I think this is a dance that the FTC does, right? So, okay, so here are some theories. this is really aggressive. This is really an aggressive theory, and would we be willing to litigate this theory if a company pushes back, or, do we? I think this all happens in settlement discussions. So you have the CID. So let's say you have this RFI. They find the information from the RFI. They develop targets to send CIDs to, and they do a sweep, and they send CIDs. I do think companies are going to push back, and I do think companies are going to say that this goes beyond unfairness. This goes, this is First Amendment protected speech, and I think that's the dance that companies will do. At some point, they will reach. There could be an equilibrium where the company says, "Okay, well, we can live with this," and that's where you get a settlement. And I think it's that line that depends on who the company is, the size of the company, what their practices already are, what their reputational, what their fortitude for litigation is. And I think the FTC is kind of considering all those factors as it's developing targets for CIDs.
Well, I've myself quoted Timothy Snyder here in his book on tyranny. He talks about the problem of anticipatory obedience being where companies will and individuals will try to anticipate what the government wants and says most of the power of authoritarianism is freely given. In times like these, individuals think ahead about what a more repressive government will want and then offer themselves without being asked. A citizen who adapts in this way is teaching power what it can do. And that's certainly what we've seen in countries like Hungary, even in China. Authoritarian governments don't mostly operate by direct requirement. They operate this way. So Kate, you've talked about the context here of what's happening. I mean, how do you, having processed what Venetia laid out for us about how the agency works, what do you think we should expect?
Oh goodness, I don't know. I can imagine if this dance is happening, I can imagine there being landing on consent decrees that look like we are transparent in our content moderation policies. I imagine consent decrees that basically reify what companies are already doing. Many of them are already doing, or say that they do, where they provide notice of their content policies, but still withhold some details because you sort of have to, otherwise you're giving guidance to people for how to violate your rules. Provide abilities for users to report content that they see as being violative, and then provide notice and appeal processes when content is taken down. That all sounds pretty reasonable, but the problem to me might come in when you get to FTC enforcement of those things, right? Where the FTC has to decide, are you properly enforcing your own policies? At which point, how do we make sure that there is a separation between the FTC deciding whether the hate speech was hate speech under the policy or not? So those are, I think that we could probably, I think Manisha is absolutely right, that we could get to a point where companies start to agree to consent decrees and that they will look something like that. But I also worry that leaves out users entirely from the conversation the way that they have been left out of everything so far.
Well, I want to come back to that thought, but this seems to me to be the entire ballgame. Because I agree that what's really likely to happen here, that the goal is to get these companies operating under consent decrees that sound reasonable. I think besides the question that you've raised about how do you avoid a First Amendment problem, because you can imagine it being not about the substance of speech, but being about, for example, the consistency requirement, which is one of the things that the RFI asked about. And that's, again, the thing that is verbatim, the same thing as the Florida law, right? Did you moderate content in a consistent manner?
Let's put a point on that. Moderate consistently. If you allow anti-racist speech, you must consistently allow the counterpoint. You must also allow racist speech. Like that is what we are getting at. What's the definition of consistent? Maybe it is that. Or maybe it is, do you consistently apply your policies? And as Derek has already pointed out, that is impossible at scale. Impossible at scale, because we do not, under the First Amendment, under existing First Amendment doctrine, conceptualize probability. We're always dealing with, is this particular instance of speech illegal or not? Can the government enforce against this particular instance of speech? Not can the government enforce against this particular category of speech enforcement, which puts us in a really weird spot when it comes to the FTC's authority.
Thank you for making that abstraction of consistent decision-making concrete, because it sets up precisely the point I was going to ask you about, which is, to me, the real goal here, if one is concerned about jawboning, if that's what the plan is, the real goal, the real leverage in jawboning is to have a company operating under a consent decree that say things that seem banal, like consistent decision-making, clear appeals process, and so on. And then once you're under a consent decree, the ball game changes, because the commission, of course, cannot impose civil penalties in general for violations of Section 5. But if you're operating under a consent decree, they can. And there is, in principle, there is no limit on how large those fines could be. So you wind up in a situation where, most notably, famously, Facebook agreed to pay $5 billion for violating a consent decree that had similarly broad language about privacy. You could imagine exactly the same thing happening here, not in step 1, but in step 2, where you get all the companies operating under consent decrees, and then you have the ability to extract from them billions of dollars of potential civil penalties. That seems to me to be the real potential for jawboning.
You know, this also brings to mind, there are limits to what the FTC can do in a consent order. So if you look at the 11th Circuit's decision in LabMD, the FTC in a consent order, this was a litigated order actually, but the order basically said, thou shalt have reasonable security, you shall reasonably oversee service providers, and those standard FTC orders used to have reasonably like 5-6 times in the provision. And the 11th Circuit said, well, you're not giving the company fair notice as to when you're going to enforce the order. And so I think there's this tension, there's lack of fair notice, or there's would the FTC then have a 200-page consent order where it's is essentially setting up a content moderation policy for every company? That seems untenable. So,
it might seem untenable to you, but I mean, they have a roadmap. I mean, you could literally just copy-paste the concepts from the Digital Services Act, Article 14, about due process and decision-making, for example, which says that decision-making should be non-arbitrary and consistent. Recital 47 says it should be non-discriminatory. Those are concepts that to Europeans seem perfectly natural. They're precisely what Republicans have been arguing for here. You could copy-paste those into a consent decree and have that be, in fairly short form, the requirements that then could be subject to civil penalties. I mean, that seems, if I were trying to jawbone the companies into changing their content moderation practices, that's what I would do.
Yeah. I mean, I think, again, you're going to get pushback from companies. I mean, I think that it would be one thing to have a fairly bare bones along the lines of what Kate was talking about, but to incorporate the DSA into a consent order, I think that would be a line for many companies, and they would fight.
Well, they might fight, but you can imagine that politically it might be difficult for them to justify, because what the Republicans are already asking questions like this on the Hill. You are already subject to X, Y, and Z requirements in Europe. Why aren't you doing the same thing here? Why can't you accept that requirement in the United States? This comes up in debates about COSA and new legislation. It becomes very difficult to explain why a concept that's applied in Europe has a different effect here. Now, this is the subject of the thesis that I'm working on. I think, in fact, it's actually easy to understand that in the context of the US legal system, the consequences are radically different than a concept that's applied in Europe. Yeah. But it's a political matter, I'm not sure that matters.
Yeah, I mean, I think this area there's a lot of inconsistencies here. So, I think on the one hand, you have a potentially expansive interpretation of unfairness when it comes to content moderation. On the other hand, you have a traditional conservative viewpoint that unfairness should not be expanded in the privacy area. And so I feel like if you expand unfairness in one area, it's difficult not to expand it in another area. If you say DSA should apply in the United States, why shouldn't GDPR apply in the United States? So I think these are the issues that I think the FTC is grappling with doctrinally, and just in terms of making sure they're being consistent.
I was going to say that I think it's an extraordinarily important observation that, unfortunately, I'm worried is now outdated, which is that intellectual consistency is just no longer a coinage that has any value. And so just in thinking about this area, I mean, so you had groups that were really unhappy about Section 5 work for privacy and security. And the thing I would say there is that they were mad, really, but I think the thing they were most unhappy about was when the commission shifted from enforcing kind of explicit representations made to users by TOS or something to actually developing substantive minima. I'll say that that worries me less for security than privacy, because privacy seems to tread closer to First Amendment concerns, whereas security I think of as at most commercial speech, and I think that honestly there's an argument that it's conduct. So if you think like it's really it's improper, it's not statutorily authorized to use it in that context. Now we can actually do content moderation with it, right? Like that is a remarkable leap. The same thing, if I think about it again, just like Florida and Texas, always everyone's favorite too. The sort of net choice cases, it's really strange that you have a set of groups who are sort of vehemently opposed to net neutrality in whatever form, and who now really like the idea of must carry on social media platforms. I also think that this is, and one thing that we probably don't have time to touch on, but I think is interesting for future work in this area, is we're focused largely, if not exclusively, on federal level work, and we're focused in particular on executive agency work. And I think there's a lot more to be done at the state local levels, because I think that often those are actually the regulators who have the most grip over people's individual lives. And the second thing is to think harder about things like legislative job owning. Jim Jordan's an excellent example. He and Ted Cruz are very plainly using their authority at the moment to try to drive Google, for example, and Wikipedia to a lesser example, towards the concessions that Meta and X have made.
And that's abandoning fact-checking, changing their terms of service to allow plainly derogatory speech about sexual minorities, immigrants, and so on.
And as just to say, it's worrisome, right? So I thought it was strange that the Fifth Circuit was Texas's stuff is fine; it's not even speech. But on the other hand, everything the Biden administration did, right? You have an intern phone up Meta. That's a First Amendment violation. It's really hard to say both those things with a straight face unless you say them very fast. So I think that's my worry. It's just that this is, as I said, this is a worry that just makes me seem like, I arrived here in the horseless carriage, and I'm also interested in intellectual consistency. I don't know what to do about it.
So what could the commission properly do here that isn't job owning? We talked about some of these things before, but Manisha, if you were advising the commission now, what would you encourage them to do to really steer clear of the First Amendment?
Yeah, so again, I think a privacy analogy comes to mind. So I think around 2008, 2009, I think there was a discussion about, hey, we need to move privacy forward at the FTC. What should we do? And I think there were people in the building, myself included, who were like, hey, deception and unfairness can only get us so far. How do we get data minimization out of unfairness and deception? How do we get consent for certain uses of data from unfairness authority? And so I think the decision was made, let's do some workshops. We did a series of workshops, and then we did a report in 2012 where we explicitly said, this is not a roadmap for unfairness and deception. This is a set of best practices. And as I understand it, a lot of companies actually adopted the recommendations in that 2012 privacy report. But what's interesting that from there, we saw those recommendations in CCPA, and we saw increasingly more and more FTC cases that followed those recommendations. We started to see data minimization requirements in FTC orders. We started to see, it used to be a very controversial thing to say that you have to get opt-in consent before you engage in targeted advertising on health data. And now it's, these cases have come out and, doesn't seem so controversial anymore. So I do think that there are things the FTC could do to further its policy goals, and I mentioned them earlier, workshops, reports, 6B studies. So I guess more study and less enforcement action. And I think I've heard Commissioner Holyoke say this in the context of AI, that, hey, this is relatively new. We haven't kind of dipped our toe in this before. I think this area deserves further study. And I think you could say the same about content moderation.
But just explain a little bit. What I think I heard was that the report there could get pretty specific about recommendations for what content moderation should look like. And we've already seen, we have a pretty good idea what they think it should look like. If you ask ChatGPT to synthesize the Texas law, the Florida law, and a few other things, Adam Kandub's writings, the chapters in Project 2025, you'd have a pretty clear set of bullets.
I think the difference, though, is that let's say the FTC were to put out best practices and then were to sue a company based on failure to follow those best practices. I think the company hasn't agreed to a consent order that lays out those best practices. The company could fight back on First Amendment grounds. So, I mean, I take your point that it's not, a panacea, but if this is what they wanted to do, and I were staff at the agency, I might say, this is something you could think about doing.
As I recall, the Commission in the past in privacy and data security had a pretty consistent track record of turning its recommendations on best practices into its consent decrees.
Yeah. So, I mean, again, I think at the time that the 2012 privacy report was written, it explicitly said, this is not a roadmap for what are unfair or deceptive practices. The fact that the Commission later took that and included it in consent orders, I just think that there's a First Amendment barrier here that wasn't necessarily present in those cases.
If someone actually is willing to litigate.
Yeah.
I mean, Kate, as maybe another realist here, do you actually think that we're going to get litigation?
God, I hope so.
Well, that wasn't a descriptive answer. That was a normative answer.
It was a normative answer. I hope so. I mean, I think that, we've seen NetChoice do yeoman's work in this space. Should it have the opportunity to continue to do so, I hope that they do. And hopefully that gives some members and some companies some cover to be able to fight back in one way or another. I also what's a small company to do? I don't generally take the small company angle. I'm not a markets person, but what's a small company to do if it has been told if it has been told that these are what you have to do in order to set up anything that would host any kind of user-generated content. The ways that this is I hope we see litigation in part because of the ways that this will suppress the starting of new spaces for people to speak online, because it will erect barriers to entry that make it nearly impossible. Because even so, my organization was part of developing the Santa Clara Principles. In the Santa Clara Principles, we say this is not for new entrants. This is for developed companies who have the resources and have the structure the structure in place to be able to follow these things. So I think to the extent that I see an incentive towards litigation, towards fighting back, it may have to do with not every company is Facebook, because not every company is that big, but also not every company wants to host all speech. Not every company can follow the same types of content moderation practices. And more companies doing different things, hosting different speech, creating different spaces for people to be online, benefit users.
As a policy matter, that sounds great, but who's actually going to?
I don't know. I mean, I'm not in charge of it. I'm nobody's general counsel, so I don't really know. But I hope so. I hope somebody does.
You raised a concern earlier that I said I would get back to, which is the interests of individual users, and this is a thing that comes up often in these First Amendment cases, right? I mean, the NetChoice cases, the Texas and Florida cases, but other cases that NetChoice has brought have been, because it is a trade association, have been on behalf of corporate speakers and their rights to editorial judgments. The effects on users have not been so clear. We talked about this, we alluded to this a little bit earlier, but there are real effects on users here. The commission is focused only on one set of effects on users, which is individual people whose speech is moderated. The commission really doesn't seem to be at all interested in the people who benefit from content moderation, whose willingness to speak on social media will depend on content moderation, on not being attacked by hordes of people, not having their personal information shared, et cetera, on prohibitions on racist speech on platforms. How do you think those concerns about even the speech interests of users could be taken into account here by the Commission if it were serious about its inquiry, and especially if it's going to bring an unfairness claim, which it's talked about? That's clearly what it's contemplating. It's supposed to measure countervailing benefits, and those countervailing benefits should be comprehensive. That's what the unfairness policy statement says. How do you think those should get weighed here, or would, if you have a view? Manisha?
Yeah, I mean, I think, look, if I were representing one of these companies in an FTC investigation, I would, put a lot of my eggs in that basket. The FTC has to prove that, all three prongs, that, harm, likelihood of substantial harm, not reasonably avoidable by the consumer, not outweighed by countervailing benefits to consumers and competition. And you mentioned the free speech benefits, but there's also safety benefits. So, there's a lot of benefits, whether it's a vaccine misinformation or things like that. I think that I think companies would absolutely be able to show that there are countervailing benefits. One other kind of, if I were in the realm of trying to find solutions here, one other thing that the FTC has done in the past in the advertising area is this idea of surveys. So again, I think the Commission has in the past recognized certain First Amendment limitations on, for example, media violence or alcohol advertising or smoking advertising. And so they have done these surveys. On the violence area, it was video game industry, it was movies, and one other thing, I'm forgetting. But they tracked, they did mystery shopping, and they said how often are people under age 17 allowed into R-rated movies. And for alcohol advertising, they did kind of these surveys about how much of the alcohol industry's budget was focused on programming for X age, Y age. And so I think that creates some transparency. So if the Commission were trying to accomplish certain goals, that might be another way to do it.
You made a really astute point there about safety, which I really hadn't thought of, and I would just point everyone to the portion of the unfairness policy statement where here they're talking about what counts as substantial injury, and the Commission says that it's not concerned with trivial or merely speculative harms. In most cases, substantial injury involves monetary harms. Unwarranted health risks and safety risks may qualify as a finding of unfairness, while emotional impact and other types of more subjective harm will not. One would think the exact same logic would apply to countervailing benefits, and therefore that if you're weighing, some people's safety, trust and safety is another term for content moderation. Mm-hmm. There are very real safety harms that come to users. One would think that those would have to weigh much more heavily, even if they were for a small number of users. Let's just say it's trans users, right? That safety risk outweighs the emotional impact and subjective harm that's experienced by some people when their ability to say racist or hurtful things or to call transgender people it, which is one of the changes that Facebook just made to its content moderation practices. One would think that those fairly concrete safety risks would outweigh the subjective harm, so-called, of not being able to engage in bigoted speech. But anyway, I hadn't thought of that before. But just to wrap up your point, Manisha, we haven't talked much about evidentiary questions here today. You've been at the Commission. If the Commission has to prove its claims, either because it's bringing an unfairness claim or because it's bringing a deception claim and it cannot rely on the presumption of materiality, what would you advise them about how to make a strong evidentiary record?
Yeah, so I think that there's a Bureau of Economics at the FTC that does a lot of work on cost-benefit analysis, and so in past cases I've worked on at the FTC, we often consult with the Bureau of Economics. But if we think a case was going to litigation, we would hire outside consulting and or potentially testifying experts. So as an example, in the Wyndham case, one of the theories was the time value of money, the time it takes for somebody to to get their free credit report or to monitor their credit reports. That was actually financial injury. And so had that gone to court and had that gone ahead, we would have had an economist talk about the time value of money. So I think it is important to have experts out there to support whatever your theory is, that the harm caused by the practice you're trying to prohibit is not outweighed by benefits to consumers and competition. So I think they're going to have a barrier at the unfairness stage, and then also at the First Amendment stage.
Well, we have a little less than 10 minutes. Bilal, do you have any questions for the panel?
Well, I think I was surprised to hear a lot of discussion for the panel, a lot of discussion on using an order, to remedy some type of violation. And of course, we recognize the difficulty of doing that. But I guess the question is, do you think the FTC recognizes the difficulty of remedying the violation here? Because, and do they see it as an opportunity, right, for future compliance enforcement efforts, as a sort of further cudgel? Or do they recognize it will be difficult to monitor, and that they really should approach this in a different way, which is basically, as I said earlier, they use these as a basis for trying to just restructure companies to create additional competition and potentially get a different sort of mix of censored or uncensored content, right? I don't see an order as being a very satisfying outcome for anybody that's actually interested in increasing the amount of either positive or negative speech. But what I do see is a belief that the large platform companies are too large, and one way to address concerns about policies is to have multiple companies, more companies adopting different policies. So it's a long way of getting back to my original question. Do you really think they want borders in this space, or are they looking?
So the question for the online audience and for the record is basically, would consumer protection orders actually accomplish their goal because they're difficult to administer and enforce, or is the remedy that the Commission really wants here a structural remedy about, really competition remedy of breaking up the companies? And because we're consumer protection people, we've unintentionally spent this entire panel, now that I realize it, talking about consumer protection, really not at all about competition. So that's a good way to get in at the end here.
Yeah, I mean, you don't usually hear, and maybe you never hear, of structural remedies in a CP case. Mm-hmm. It seems an unusual approach to a deception case, but it doesn't strike me as fundamentally inconsistent with an unfairness case, where, as I talked earlier, it's sort of a duty to do or not do something. And if you just have more companies, you might get different outcomes.
So the question basically is, in a consumer protection case even, could we have structural remedies? And I would just note, as we pointed out on the slide earlier, that one of the sets of questions that the Commission asks about, which I interpreted as being about the reasonable avoidability prong of unfairness, was can people who are shadow banned or demonetized or whatever, can they find some other outlet to speak if the companies are all moving in lockstep, which is a claim that the chairman has made repeatedly.
So Bilal, again, I'm not a competition lawyer, so this whole structural versus behavioral kind of eludes me a little bit. But the closest I can think of for a precedent for a structural remedy in consumer protection was the Facebook order, where essentially the concern was you had a single powerful chief executive. So again, they haven't broken up a company, as far as I know, but you had the single powerful chief executive, and they said, okay, we're going to create a governance structure in the order, a board nominating committee, and you have to have like all these checks and balances. It was almost like a constitutional governance program set forth in the order. So they have done that, but I think all the questions about like what do you predict is going to happen, I don't think any of us have an answer to that. But I do think that we can look for kind of areas of precedent and maybe read some tea leaves based on that.
That could be a very satisfying outcome for them. I mean, one of the things worth pointing out here is the Meta Oversight Advisory Board has been making evaluations of particular content moderation decisions and not of the content moderation policies overall. If one wanted to re-architect a company's content moderation policies, one could do it through a combination of a structural remedy that required an outside board reviewing those and then taking control of the board. I mean, that's what Viktor Orban would do. So, to wrap up here.
But you would also have to ensure that the company had to abide by, because like the Facebook
Well, that's
oversight.
what I mean.
Yeah, okay.
Yes, but you could require that in a structural order. I mean, that could be analogous to what Manisha just described. Now, I realize that we may have just done the thing I didn't want to do, which was giving them ideas. We should probably delete this part, right? They're pretty smart. They're going to figure this out. Indeed. So, Kate, well, final thoughts?
Well, this didn't bring me much comfort.
Oh, well, you couldn't have expected that.
I
could you?
didn't expect that on a panel with you, Baron. Not at this point in time, anyway. Maybe one day.
No. Not my job.
Fair enough. I worry about how much the discussion today indicates to me that we are on a path toward companies continuing to sort of put their finger in the wind to determine how to adjust their policies in a way that will affect billions of people's ability to speak online. The idea that I am particularly terrified of the idea of like the consent decree sort of domino effect that Manish has pointed out. I can see that as like just creating the situation for the jawboning necessary that will put all of the largest platforms in a particular space that will then put downward pressure on everybody else that isn't under consent decree at a particular point. And I don't know how to challenge that under the First Amendment because you have companies agreeing to it. So if they're not going to challenge it and their users who are subject to it, who are also subject to these consent decrees, don't have the ability to challenge it, are we actually going to wind up losing free expression protections online this way? I think it's really possible, and that scares me.
Do you think that a user who had a valid safety concern from content moderation policy changes that seem to be coerced might have standing to bring a First Amendment claim?
That seemed to be coerced, and so company X, I didn't mean to use X because that is a company.
No, but that's literally
hypothetical company.
That could be the example. Yeah.
Hypothetical company is jawboned into permitting content which facilitates attacks against trans people, non-binary people, gay people, black people, disabled people in particular, sometimes all together at once. Does that person have standing to sue? I don't know. I mean, I'm not a litigator, I'm not a standing expert, but I do think that there are people who are thinking about what the right case is for a user to be able to assert their rights, because so far we've only had cases where it is the government and the companies, and we're only talking about the company's First Amendment rights, and to the extent that users have come in to certain cases like the TikTok case, to say that, hey, this restriction on the existence of TikTok actually affects my rights too. The courts so far have just kind of ignored that to a certain degree, or not dealt with the user's assertion of their First Amendment rights being impacted by government orders or pressure against the social media companies themselves. I think that case is coming, and maybe this would be it. If you have a document that takes the company itself out of the equation, takes the company itself out of the lawsuit, maybe that's it.
Jack Balkin puts this very well when he says, free speech today is a triangle. Its three corners are nation states, private infrastructure, and speakers. But that's not really how our dyadic mode of First Amendment doctrine works.
Daphne's wrote about this a lot, too.
Manisha, final thoughts?
I think it's going to be an interesting ride. We'll see how things develop, but I do think there's probably lots of discussions going on in the building about the best way to do this, and we'll see what happens.
3 quick points. One, standing's really hard. Standing's particularly hard, so the dyadic point I think is quite important. The other one is that it's an individual right at some level and we can waive it. And so one area, and this is I think fairly radical as a suggestion, is maybe at least in the job owning context we could pick up on Phil Hamburger's idea of the First Amendment, which is that it is in some sense a collective right, which is not waivable, right? It operates as a communal restriction on the ability of government to do certain things, right? And that gets us past standing, at least as articulated in that way. And then I want to close with 2 pessimistic things in keeping with the tone. One is just to point out something that Kate said right off the top, which is that this is a multi-pronged attack, right? Like we're talking about the FCC and the FTC, but it is also—
And the DOJ.
And the DOJ, it's calling people in front of Congress. It's having Ed Martin, who I guess is being replaced by Judge Janine and then eventually by Judge Judy or whoever else, sending letters to Wikipedia and letters to scientific journals, right? So it is in this sense, right, sort of like a swarming of speakers and intermediaries in particular, and I think this is really focused on intermediaries, who are out of line with what the current administration would like content, broadly speaking, to be. And I think that that's one thing that is also a little bit pessimistic, is that we have done the thing that professionals who are experienced in this area do, which is we assume that the agency is going to operate within the set of both substantive legal requirements and long-felt norms that agencies have, and I'm just kind of not convinced by that. And I want to say that if you think about the FTC, I think that the kind of deep reservoir of experience and I think commitment that in particular the kind of professional staff has is a non-trivial hurdle to that, but they are being fired and they're being replaced and they're probably at this point a little bit scared. And so the thing that I think about is I am not sure, for as much as I did not like the sort of neo-Brandeisian thing, and I thought it was not well-founded intellectually, there was an attempt to justify it intellectually, right? There's law review articles and stuff like that. And it is in some earlier tradition of antitrust within the United States. And I think that the current set of moves is outside of that. I don't think it actually makes a pretense to that. I don't think that the goal is actually any sort of order. I think that the goal is to bend the knee.
Well, I would just wrap up here by saying that there's a very well understood scholarship about authoritarianism operating as a dual state, where you have the normative state that operates according to established laws and regulations that take seriously what does Section 5N say, what does the unfairness policy statement say, and so on. And then you have the prerogative state, and the prerogative state does whatever it wants. And to paraphrase Andy Warhol famously said that art is what you can get away with. For the prerogative state, law is what you can get away with. Or as the former dictator, president of Peru, famously said, for my friends, everything, and for my enemies, the law, right? I mean, that's what the worst case scenario here is, and we'll see whether the normative state or the prerogative state really ends up ruling here in the end. So thank you for coming to the panel. We'll just wrap up with some final closing thoughts from Bilal and Jess, if you want to join us here. Thank you. I'd give the panel a hand here. I had to make the Peru reference because, in case you don't know, Tech Freedom is actually run by the Peruvian mafia. My colleague Dan Benavente here was very excited to have Commissioner Bedoya here as a fellow Peruvian. Well,
timely.
There you go. So, what did we learn today, and what's next? So, Jess, what did you take away from our conversations?
So many things. Where to begin? A couple things that jumped out at me as really smart that I hadn't thought about. The sort of dominant media, whatever we're using, whether it's movies or broadcast television, whatever, being a target of regulatory action, I thought was a smart point. And as unprecedented as some of the moves may be, there actually really is precedent for going after where the power is, which it ties into a lot of the authoritarian thinking as well, I'm afraid.
I mean, let's not forget the Grosjean case that we all learn about in law school, about a tax that's targeted against media companies. When I read that case in law school, I remember the analysis. Basically, it says that when you target particular speakers, that can be a form of invidious discrimination. You have strict scrutiny applied. I forgot until I was reminded about this just recently in reading, I think it was Doug Malamuth's paper. I forgot that the context of that was Huey Long, who was trying to shut down media that he didn't like in Louisiana by imposing a tax on them. Right? That was the closest America's ever come to a fascist dictator who was operating at the state level, who was weaponizing the power of the state. And that, so in other words, these are not unprecedented things. We've had much worse happen against the media in the United States within the last century.
And I think that ties in with just a few moments ago, we talked about how it's really the intermediaries that are being targeted and from a bunch of different places and in a bunch of different ways. And I will not give names or details, but that's certainly been my experience when I write anything critical of the Federal Trade Commission, is that the intermediaries who publish me have been contacted. Oh, wow. So, again, it's not unprecedented, but it's certainly not something that would have ever happened before. I mean, I think it's fair to say I really railed on the FTC. I really railed on them. And nobody ever heard from the FTC. I'll give them that. Nobody who published my work on them, my opinions on that, ever heard from them. And we're certainly, those same organizations have heard from the FTC about things that I've written critical of certain things. So, and that's not even, the FCC, which we'll talk about tomorrow. That's the Federal Trade Commission and media. So,
and it's worth noting that one of the FTC commissioners spent a good chunk of her career here, Commissioner Holyoke, worked here at CEI.
She did.
Do you have what would you say to her about CEI's approach to regulation?
I think I have been very impressed by her dissents, both in the last administration of the FTC and this one. I give a lot of grace to people who have jobs that I have never had and certainly will never have. I think I'm confident in saying I can't imagine the administration that would ask me to join the FTC. I think in those situations, maybe in a strange way, you're playing the new minority commissioner job. Maybe you're a dissenting voice to the extent you can be for things you don't agree with. But I'm not quite sure how much power is still residing in the other commissioners who maybe, based on their past work, I would not expect to be quite in lockstep with Ferguson and the administration.
So, what did I take away from today? I mean, I think I took away from today's discussion that, no surprise, this is sort of a complex issue. To some, I think to me, personally, I think it's a very simple issue, given the protections of the First Amendment and the inability of the government to compel speech. And so somewhere between me and a lot of what I heard today, maybe there's a little bit of a medium. And I think what I'm concerned about is what I mentioned earlier, which is I think the focus on speech and censorship is interesting and maybe in some sense laudable, because I think speech rights, the right to be heard, the right to speak, the right to be not to be compelled to speak, is important. I just don't see why the FTC or Antitrust Division are involved in this discussion at all, right? Outside of concentrations of economic actors outside the context of concerns about speech. What I'd like to see, look, when the FTC in the previous administration started down the path of the non-compete rule, many people said, not just Tech Freedom, many people said, this is sort of a fool's errand. You're going to spend a lot of resources on this, and you're unlikely to achieve the objective you wish to achieve. There, the objective may or may not have been laudable, and I think the same thing is going to happen here. They're pursuing this path for reasons that, may be felt, strongly, but there seem to be real hurdles to doing what they want to do. And rather than invest a lot of resources in trying to push through a view, it seems to me they ought to be thinking and consulting on and even publishing their legal framework for acting, in a way they may seem to want to act. I mean, maybe they can defend their, deception cases. Maybe they can explain why a deception case makes sense. Maybe they can explain why an unfairness case makes sense. I don't think so. And I certainly don't think there's an antitrust case here. But it would be useful if they started that process publicly. What we've seen so far is, look, we wanted to make sure that the comments of Ferguson were provided in their full context. Of course, that's impossible when he's speaking for a half hour, and we can only give him a few minutes of clip time. But they really have not developed their theory of the case here very well, outside of a few, what I'd say, casual remarks about speech being an important variable in competition case, and that just doesn't get you very far. So what I learned, I left this, and I think we'll see this tomorrow. It's a much more complex issue than they're letting on, and they really ought to explain that before they waste resources on this, when a better solution might just simply be some form of best practices, self-regulation that companies naturally work towards, and are not threatened with lawsuits around.
So, Bilal, when you ran the Office of Policy Planning at the FTC, you organized something like 19, was it, inquiries and workshops? It was quite a few, and they were really well done, about the Consumer Protection and Competition Authority, how to use it for digital markets. What would a workshop like that look like here? What advice would you give the Commission about how to really probe seriously these questions about the First Amendment?
Well, a few things.
Hypotheticals?
Yes, in fact, yes. Look, I think, the conferences or hearings we held, we're focused on areas where we knew something or knew a lot, right? And we're just thinking about how to move forward. The scope of the First Amendment and the protections it offers, and maybe some of the other questions I tried to raise in each of the specific panels and others have raised, strike me as really outside the area of the FTC's expertise. And so I would write some papers. I mean, I think they should put papers out for comment. When Tim Muris did the disgorgement statement, I believe what we did was put a draft out for comment and then reflected on the comments before finalizing the statement. I think that's what they do now with the merger guidelines. It's what we did with the vertical merger guidelines. I think that would be a much better way to pursue this, right? Identify the legal framework that, and maybe there's an economic framework, but identify the legal framework for what they intend to do. Seek comment on that. It could be written comment. It can be conferences, things like that. But that strikes me as a better path to a useful outcome here, then this, what appears to be is general statements and sort of fact gathering without a framework for thinking about how you would pursue any type of case or any type of relief. Now, I don't think they can't pursue a case, but it still, maybe they can, but to do that, I think they ought to put the framework out first.
Well, I think that's really interesting, especially because in rereading the unfairness policy statement, I was just struck by the reference. Remember, that was drafted in 1980. It was submitted later, and there's a letter that submitted that, which I think comes from 1984, to the congressional committees that oversaw the FTC, in which they say, here we're also in closing, in addition to the unfairness policy statement, a companion statement, the deception policy statement, that discusses the consumer protection law. And since your committee has indicated a particular interest in the possible application of the First Amendment principles to commercial advertising, the deception policy statement will include discussions relevant to that question. In other words, the deception policy statement was really framed as a way of trying to articulate how the commission would deal with this fairly new and inchoate field of regulating commercial speech and dealing with the First Amendment in that context. So I think this is a very constructive suggestion that the commission could draw on that model to have some further statement that says, look, the deception policy statement was about commercial speech. If we're going to get anywhere near anything related to non-commercial speech, even if it's sort of indirectly about non-commercial speech, we should have some framework that lays out how we're going to do that. And as you say, it should be subject to input, especially from First Amendment experts.
Yeah, look, I mean, input may not be the word I think about, but you should put it out there and think about what people say, right, before either adopting it or moving forward with it. I just don't see any other path, and that's going to be productive. And the non-compete rule effort, to me, is an example of what happens when you basically just hope you can get over the legal hurdles by sheer force of comments, basically, and public support for an action. And there are a lot of smart people there. I mean, not particularly, but the chair of the FTC, the general counsel, the bureau directors, they're all sort of serious people with litigation experience, case experience, and these cases, this is not foreign to them, right? And it's the same at the Department of Justice or in the Antitrust Division. People have real antitrust experience. They know how to build a case. Of course, the staff does too. They ought to be thinking about these things up front and not after collecting a bunch of, what may pass for facts.
Final word, Jess?
I think that today generally is a reminder that, all of these institutions, it's so important, the norms and the people that are in leadership. I mean, how many times has Tim Morris's name come up in glowing ways today, amongst others? But I think that, when character is important in these situations, and in DC, that always makes me feel uneasy, because we're really lucky when we get it, but things can really go off the rails when we're concerned that we don't.
Yeah, well, it was Reagan's chief of staff, chief of personnel, I think, who said that personnel is policy, and that if you really want to make sure the administration does what you want it to do, you have to change the people involved. This is clearly a very different set of leaders than ran these agencies under the first Trump administration. Those people were Republicans who were handpicked by Mitch McConnell. They were traditional Republicans, and in many cases they were originally appointed to their seats by President Obama, but picked by Republicans. Trump administration didn't make that mistake this time. They've handpicked their own people for these roles, and we'll see. We'll see. Maybe the normative state will prevail. Maybe they'll do something, as Bilal would say, sensible. Maybe it'll be a policy statement. Maybe it'll be reports. Maybe it'll be just investigations. Maybe it won't.
I just want to comment on that, Baron, a little bit. The people there, I think, are actually quite smart, and not only that, I think quite principled. Both during this workshop, maybe tomorrow, and in the comments just generally in the public, I think there is a tendency to discount the meritoriousness of the issues they're thinking about, and maybe struggling to find a way to address them. While I said on the panel, I have a lot of admiration for Joe Simons, and that was as well true of, I knew Christine Wilson a long time before she came, to the commission as a commissioner, and I got to know Noah very well. I really don't think there's a difference in terms of principles between the current leadership of the FTC and DOJ and the Antitrust Division, and that was there before. I think they are thinking about different issues, and when you think about different issues, you may not have thought about them as much. You may, and so you may appear less principled. I'm not saying that's what you said, but I don't think that's true. This is an issue of concern across a large percentage of the population. It may not be a very big concern for many people, but I think people are concerned about, their speech rights and their ability to convey thoughts. And so, as Jess, as you said, I'd give them a lot of grace in being critical of what they're doing. I think they're trying to get it right. I would distinguish between the speech of the president and the actions of the leadership.
I agree, but I only meant that the leadership speech, their rhetoric, their framing has been the opposite of what their Republican predecessors took to this, rightly or wrongly. Joe Simons, Macon Delrahim, they were, Noah Phillips, they were all very reluctant to get involved in these issues.
So I agree with that. They were reluctant to get involved in these issues. But I also don't think they thought about them a lot. We mentioned, as an example, you mentioned the MoveOn.org petition on Fox, Fair and Balanced, and Tim Muris's response. There was only a day between the petition and the response. Now, Tim is a very smart guy. He had been at the commission before. He'd been an professor, so he'd obviously thought about consumer protection issues and what type of case you could bring. But it was not the response to the petition was almost immediate.
And it was only a few sentences.
So Joe Simon's reaction to the executive order. Look, Alden was there. I was there. I don't want to say it was superficial, because it wasn't superficial, but it was just a sense that we do not go there. And I think this leadership is thinking, well, maybe we do go there. And that's a big step. I think probably the wrong step. But they are struggling with an issue that previous commission did not want to address, with the possible exception of Christine Wilson.
Right. Well, we will judge them by what they do and how thoughtfully they approach this, and we'll see. And we will do more on this. Tomorrow we're starting again with Commissioner Gomez from the FCC, who might be fired before tomorrow. We'll see. It could happen any day. You never know. And she'll kick us off around 9 tomorrow morning, and we'll spend the day talking about the FCC and its role here, both with respect to broadcasters and also internet services. So with that, thank you to CEI for hosting us, and thank you, Bilal, for helping put this together.
Thank you.